think I've gotten my sound working. Can you hear me?
Yes.
Thank you.
Well, YouTube is already recording, just so everyone knows.
Hey, Wendy?
Yes, it's Wendy talking. And YouTube is already recording if you shouldn't be echoing anymore. I had to sign on for Valentina, even though I'm co-hosting. She's working on something behind the scenes, just so you know, mics may be hot. That was the reason for the warning.
Thank you.
You're welcome.
I have nothing to fear.
Good afternoon, everyone. I'd like to convene this public hearing of the Government Administration and Elections Committee. I just want to make a couple of announcements before we hear from the first people signed up to speak during this public hearing. During public hearings and committee meetings this year, we've heard from our ranking members some of their frustrations with the joint rules, and I'm going to share one of mine that I hope will be helpful for those watching this hearing. Representative Fox and I have heard some frustration in recent weeks with regard to the 1 hour that is reserved at the beginning of our hearings for public officials. And I just want to say that the chairs of this committee understand that frustration. We've been frustrated by that for several years, but we are required by the joint rules of the General Assembly to allot that first hour for public officials. So there's no way around it. The joint rules govern how we have to conduct our hearings. And I just want to make sure that people understand that that's why the hearing starts that way. I do just also want to ask committee members to remember to speak through the chair during the hearing and be recognized by whoever is chairing the hearing, and also ask everyone, both members and people testifying today, to try to limit their comments to the bills that are actually on the agenda. So with that, before I introduce our first speaker today, Representative Fox, do you have any remarks?
Oh, no, just look forward to the hearing. Thank you, Madam Chair.
Thank you, Representative. And our ranking members, Senator Sampson and Representative Mastro Francesco, do you have any remarks before we commence this afternoon's hearing?
Thank you very much, Madam Chairman, and delighted to see you. And I'm enjoying the fact that you're either outside or you're in front of a window. So good for you, enjoying some spring. I want to just start by welcoming, the members of the committee today, and also members of the public and those who are going to testify. Thank you very much for your interest in the Government Administration and Elections Committee and the bills that we have before us today. This is important stuff, and your input is required for us to make good policy for the state of Connecticut. I want to make my typical comment that I've been making at the beginning of each of these meetings, which is just to make a very polite objection to the rule that allows and creates this Zoom public hearing process. I understand that it has some benefits and has allowed some people to participate who might not have otherwise, but I do remain concerned that we are shutting out some portion of the public that just doesn't have the ability or the technology to participate. So I wanted to get that on the record, Madam Chairman. And I will just end my comments by letting folks know that I'm going to take a much more limited role in this hearing today. I have not been feeling well, but I do plan on watching the entire thing and participating on some level, and looking forward to getting back to 100% soon enough. And with that, thank you very much, Madam Chairman. I appreciate it.
Thank you, Senator. Representative Mastro Francesco, any welcoming remarks?
No, thank you, Madam Chair. Just welcome everybody to the public hearing today. Looking forward to listening to everyone's concerns. And I appreciate you mentioning that we should absolutely keep the discussion on topic. So I appreciate those comments. Thank you.
Thank you, Representative. With that, I am going to call on our first speaker for today's hearing, Connecticut's esteemed Attorney General, William Tong. Welcome, Attorney General.
Thank you, Madam Chair. Very jealous of you and your surroundings. Clearly a beautiful day in Eastern Connecticut. So thank you, Chairwoman Flexer and Ranking Member Sampson. Hope you feel better. Good to see you. And Chairman Fox, also in Stamford, I think, today. And Ranking Member Mastro Francesco, great to see all of you and the members and my former colleagues. This is a really important issue and bill, and I want to thank you very much for raising it, because it affects the personal security and safety of people in my office and state employees. So every day, staff, paralegals, and attorneys in the Office of the Attorney General represent the state of Connecticut and do so often in very difficult circumstances, addressing contentious issues, contentious cases, involving situations where sometimes the state and the people in our state are not at their best and are in very difficult moments. And that includes our work representing the Department of Children and Families, DCF, representing DOC, and in many of the ways that which we represent the state and engage in cases that can be very difficult and emotional and contentious. And our state law under FOIA protects the home addresses of certain classes of state employees, including judges, prosecutors, public defenders, and the DCF and DOC employees that we represent. And that, I think, to everyone on this committee makes a lot of sense. The home addresses of those state employees has nothing to do with the substance of their work. And because their work is so contentious and emotional, it is important to keep them safe and their families safe by not disclosing their home addresses. That protection is not given to the staff paralegals and attorneys in my office, and we really need it. And so just today, I listened to a voicemail we got, I think yesterday or the day before, sent to a longtime assistant attorney general who does energy work and had stepped in on a DMV matter. And it's a short voicemail in which this person, screams at this assistant attorney general. It's almost 90% profanities. And at the end, threatens to introduce this AAG to a high-powered assault rifle. This happens more often than we would like. It happens often. It happens to attorneys, staff, and paralegals. It happens to me. And I understand the risk and the pain that this causes the people that work with me and for me. When I was a state legislator and on the Judiciary Committee, a disgruntled member of the public came to my house on a Sunday afternoon, threatened my wife, and when we called the police the next day, wrote an email to every partner in her law firm saying what a horrible person she was and making additional threats. That same person, I should note, later showed up at Representative O'Day's house in New Canaan and threatened him. And some of you may remember that resulted in a physical altercation. And so it's really important as employers that we keep our employees safe and that we afford the Office of the Attorney General and its employees the same protection that we afford our clients. And we hope that you will join us today and give that protection to the people that really need it here in our state. Thank you so much.
Thank you. Thank you very much for your testimony. Are there questions or comments from members of the committee for Attorney General Tong? Senator Sampson.
Good morning, Mr. Attorney General. Good
morning or good afternoon.
Yes, you're right. We usually get started a little later in this committee. So very interesting testimony. I'm certainly sympathetic to it. You might remember that as a mere member of the Judiciary Committee, I was also the subject of a threat. Someone had texted that they might blow me away if they had the chance. So I think that, members of the legislature, certainly members of the executive branch that are visible and, sometimes take strong positions on things are going to be in the public eye, and they're going to raise the ire of some of their constituents. So I'm certainly sympathetic to it. And I don't disagree the reason you're here or that you have this before us. I guess my question really is, how successful do you think such a policy is going to be? I know in my own case, I don't think I could hide where I actually live very effectively. And that may not be true. That may be more true for someone who is a member of the staff of your office. But I guess that's really my question: is do you believe this is going to be a truly effective means to help protect your employees? Well, first of all, let me say, Senator Sampson, you and I, we have very public roles as elected officials, and to a certain extent, you and I can take it. Right? That doesn't mean that anybody should threaten you or your family or mine, but there's a certain amount of public criticism that we endure, and that's part of our role, and we accept that. The people in my office who work every day representing DCF and DOC, they don't sign up for the same thing. And when they get stalked at their home or their homes are vandalized and their families are threatened, that's an altogether different thing, and they don't deserve that. And the risk to them is very direct, and the threat is very real because, frankly, they're not as visible as we are. And so while we may get more criticism, we also maybe get more attention.
and maybe people are more aware that we face these risks, whereas people who work for my office, they just do their jobs every day. And when they get threatened, not everybody knows about it. And it's a very scary thing, and it makes them less safe. Let me just address your specific concern about how effective this will be. I think it'll be very effective. And I think that we have an obligation as the state of Connecticut, as the employer, to provide the strongest possible protections for the personal safety and security of our employees, insofar as their being unsafe is the result of their doing their jobs. And even if someone might be able to find this information if they dug hard enough, that doesn't mean that the state of Connecticut, again, as an employer, doesn't have an obligation, which we do, to do everything we can to protect our employees and not to facilitate the disclosure of that information. And so let me also say, if we're a private employer, right, let's just say you're a Walmart, right, and somebody calls up Walmart and says, hey, I had a really bad experience with a customer service representative at your store today. Can I have their home address? Walmart would never give that information out, and neither should we. And so that's why I think we have a real obligation to be there for our employees who are directly at risk and do everything we can to keep them safe.
I appreciate that answer, Mr. Attorney General, and thank you very much for your testimony. It's very compelling. I guess the only follow-up I would have is that, is there a requirement? I understand as a public employee, your information is going to be public, but as you stated from the outset, you kind of signed up for that by becoming a public employee. I guess the question I have is that in your Walmart example, that's certainly true. I certainly wouldn't give up the information of one of my employees. And would the Attorney General's office be required to do that, number one? And I guess whether or not that information exists or not is really the question. I'm struggling with this only because I don't know that we're actually going to be able to hide people's information if we necessarily need to. And if we are going to hide it, are we hiding it for reasons which may not be beneficial to the public?
Okay.
I'm a big fan of, government transparency and accountability, and the FOIA people love me, of course, because of that.
Yeah.
And, it's one of those things where I don't want to create a government that is shielded from the public, but I do have the same concerns you have about the safety of all employees and public, private sector employees also. But we're not affording this protection to private sector employees. So I don't know if there's really an answer to that question, but that's what I'm struggling with. And I thank you for your testimony.
We're required to provide that information. There is no carve out for the home addresses of employees of the Office of the Attorney General, which is why I'm here. Number one. And with respect to your question about FOIA, because FOIA mandates this disclosure and transparency, I strongly support FOIA and transparency too. But your home address, where you live, and frankly, the location identity of your family and your loved ones, and my home address, and Representative Haddad's home address, and Representative Mastro Francesco's home address, and where her family lives, has nothing to do with public policy. Has nothing to do with any issue you will discuss today on this committee or ever. It has only to do with where we live and our privacy as to a certain extent still, as individuals who are entitled to the safety and security of our home and the safety and security of our family. So I would just say, I hear you about transparency. We should disclose information about the operations of government and your debates about public policy, but your home address has nothing to do with that.
Oh, thank you very much, Mr. Attorney General, for your testimony. I'm looking forward to hearing my colleagues and their questions and some more testimony on this. I know it's something that we've had in the past, And I'm hopeful that we can come up with a solution that is beneficial to the public safety of the employees of your office, but still maintains that transparency that we are both very much in favor of. So thank you very much. And thank you, Madam Chairman.
Thank you, Senator. Representative Palm.
Thank you, Madam Chair. Good afternoon, Attorney General. Had you been in office 30 years ago, would you have believed we needed such a bill?
If I, you know, I think 30 years ago was a different time. Certainly there are threats against public officials 30 years ago. I think given the time that we live in now, where we saw the son of a federal judge murdered at her home and her husband severely wounded, I think given that, and Representative Palmer, this is our second time together this week, I think, in a public hearing. And I spoke about on the Judiciary Committee when I testified the rise in hate and extremism in this country, and how our FBI director has again confirmed that the rise in hate and violent extremism is perhaps our nation's #1 domestic terror threat and law enforcement challenge. And what we saw on January 6th at the US Capitol, I think makes all of us unsafe. And I may have signed up for a certain amount of public attention and given up a good deal of my personal privacy. I get that, but I don't think that a secretary at the Office of the Attorney General signs up for the same thing.
Thank you, and I agree with you. And after January 6th, I think many of my colleagues and I felt a lot of threat. There was a police presence on my street, which I very much appreciated. Fortunately, nothing happened. But I do want to echo what you said about how this has nothing to do with public policy. I believe that the public has a right to know that we live in their district. I can't represent my 4 towns unless I live in one of them, which I do. But beyond that, and certainly when you start to bring in partners, spouses, children, even pets have been threatened. Neighbors have been, I had to go around my neighborhood and talk to my neighbors after January 6th about police presence in our neighborhood because of my choice to run for office.
Right.
So I do want to thank you very much for pointing out that public policy decisions that we make, whether they are brilliant or ludicrous, have nothing to do with where we live, and we don't owe it to constituents to give them access to where we live, is certainly not support staff. So thank you for testifying in this, and I do hope my colleagues will take very seriously, as you have pointed out, the very severe changing nature in the threat of personal violence to those of us in any form of public service, as a result of the tenor of our times. And I will leave it at that, but thank you very much for speaking out on this.
Thank you. If I may, let me just clarify. I would say that you're right, that if you're an elected official, you live in your district. It's important for people to know that you live in the district. And again, maybe I gave a bad example there, but at the end of the day, we who run for office sign up for a certain level of public scrutiny, but you cannot say that a secretary or a paralegal or an assistant attorney general, in my office sign up for the same thing. And their address, their residency, where they live, who they live with, has nothing at all to do with public policy.
I agree with you completely. And I would just simply add, I would draw a distinction between scrutiny, which I think we do absolutely deserve, and threats of violence. I would certainly say that's a different kind of attention, but thank you.
Thank you.
Thank you, Representative. Representative Mastro Francesco.
Thank you, Madam Chair. And thank you, Attorney General, for coming before us again. It's nice to see you.
Nice to see you.
Thank you. And through you, Madam Chair, just a couple quick questions. I'm just curious on a few things. Right now, what is the process if somebody wanted to find the home address of somebody that worked in your office or any office? How easy is that information for them to obtain right now?
They would submit a FOIA request, I believe.
Okay, thank you. And through you, Madam Chair, so there's nothing they can find online currently?
They
They would have
probably
to go through FOIA and get that information.
they could try to look online, and I think this is what Senator Sampson was speaking to. There might be other ways that they can get that information, but there's a difference between that and us giving it to them.
Correct. Yeah, I thank you. Through you, Madam Chair, I understand your concerns. I'm sure every person, wherever they work, or certainly an elected official, is always concerned about issues like that. Would it be your ideal situation that every state employee should be, their home address should be shielded from the public? I mean, would that?
This bill and proposal speaks only to my experience and my employees. And there are a number of categories of state employees who face similar circumstances, right? Where they're involved in really contentious issues and contentious matters involving the state, where those employees have seen over time a history of being threatened. And I can only tell you that my employees are threatened regularly. And I think we should provide the strongest measure of support for state employees who face these risks. And let me clarify again, because I think I've done a poor job of conflating the two. There's a huge difference between elected officials and state employees who are just doing their jobs and don't sign up for what you and I sign up for. And then there's a huge difference between those of us who have a public platform and an assistant attorney general who does child protection cases, right? I mean, child protection cases it's hard to imagine more emotional and difficult and emotionally fraught cases than those.
Thank you. And through you, Madam Chair, I completely understand and I can sympathize on the issues that your office deals with are very, very emotional to people. So I can certainly understand that. Do you by any chance know, and you may not know the answer to this, how many state employees are on that list right now where their addresses have to be requested through, that are shielded, we'll say? Would you know that answer?
Don't know the answer of the number, but I can obviously direct you to the statute. It is a subsection of our FOIA statute, and we can send that over to you, Madam Ranking Member. It includes judges, it includes prosecutors, it includes police officers, firefighters, DCF employees, Department of Corrections employees, people of that nature, law enforcement. And one thing to remind everybody is that my office is the office charged principally with civil law enforcement. And so I'm the chief civil law enforcement officer of our state. And these are law enforcement officers often in situations that, again, are very contentious and very difficult.
Oh, thank you for that answer. And through you, Madam Chair, I clearly can understand and sympathize. Of course, I'm all for transparency and obviously support the freedom of information, but I also understand your concerns with your employees. As with anybody in any business or any state employee, I can see, during this pandemic, how the Department of Labor was overwhelmed. People were very upset. You can understand then. I can understand the same situation put in to the employees of the Department of Labor as I can see in your situation, because people just react differently to emotion. So I clearly understand that, but I also appreciate the transparency on that end as well. That's all the questions I have. I just really wanted to understand it. Thank you so much, Attorney General, for your time and for coming in and answering those questions. Appreciate it. Thank you. Thank you, Madam Chair.
Thank you, Representative. Representative Thomas.
Thank you, Madam Chair. Most of my question was just addressed. I know I was struck when I read the language of the statute of the number of agencies who are already exempted. the firefighters, Department of Children and Families, Department of Mental Health and Addiction Services, and it goes on and on and on. So this proposal did not seem so out of sync or feel like it threatened transparency. It doesn't seem groundbreaking at all. It's just one more agency added to a long list of those who already have this protection. So my question for Attorney General Tung, through you, Madam Chair, and good afternoon. Great to see you. So my question for you is, I was confused why the Attorney General's office wasn't included in that list to begin with. And I just wonder if you had any thoughts about why that might have been. And it just seems silly given the rest of the list.
I don't. I guess I would only venture to say that I'm really proud of how the lawyers and staff in my office do their work. They do it under the radar a lot of times. They do it without complaint. They don't ask for a lot of credit, and they do extraordinary work. And they bring millions and millions of dollars back to the state of Connecticut every year. And they do this work again in situations where our state and the people in our state are facing really difficult circumstances, and they're not at their best. And honestly, they don't complain to me, right? They don't say, "Oh, geez, it was really hard at DCF today, in court," or it was really hard over with corrections at Northern today. They do their jobs, and they do it extremely well and in a very dedicated and committed way. But I do hear about it when they're threatened. And they get threatened more than you would think. And, just the other day, getting this voicemail, which, by the way, I would be willing to share with members of the committee if you would like to hear it in camera, I guess, outside of the committee. But this is a really scary thing for an AAG, a longstanding AAG, to get a voicemail where this person sounds like he's going to kill him. Honestly, that's what it sounds like. It is blood curdling, the tone of this voicemail. And you have to take every one of those threats seriously. And we do. It's being investigated by the state police.
My heart certainly goes out to them, and I thank you for being the type of boss who was here advocating for the safety of your employees, and I'm sure they would thank you as well. Thank you, Madam Chair.
Thank you, Representative. Representative Carpino.
Thank you, Madam Chair. Attorney General Tung, it is nice to see you, sir.
Nice to see you.
I appreciate your distinction between elected officials and state employees, because, and I agree with you 100%. As elected officials, my constituents know exactly where I live. And just as you've had visitors during your tenure with us, many of us have, a majority of them pleasant. And I also appreciate you wanting to protect your staff. And I take you at your word, but I was just hoping that you could perhaps get me some information after today to put it in a little bit of context. I agree that one threat is one threat too many, and I want to make sure that everybody understands that. But often, as we've dealt with other agencies and other employee groups, whether it was increased penalties under your leadership and Judish and in similar situations, folks often ask, why do we use such a broad brush? So if you or a member of your staff after today could just put it in a bit of context so that folks could better understand. Are there threats just coming to the AAGs and the paralegals? Or are they also coming to staff who one might not think interfaces with the public? And if there are any statistics or numbers so that folks can really understand the severity of this. I believe you. I don't need to hear the call. I feel awful for the AAG and their family, but I think it would be helpful if you don't mind providing some details for us.
So it happens with some regularity. We will get you that information. And what shocks me and compels me to be here today is that it happens to the staff, and it happens to paralegals, and it happens to attorneys. It happens to everybody without regard to their position, because most of us interface with the public in some way. And I think what's really different about the Office of the Attorney General is, and this may be the same for you and your staff, we're the kind of office that people think we do everything and that we are involved in everything and that we have the ability to make decisions and make people do everything, right? And so I'm just going to call the Attorney General and he's going to order somebody to do it, right? And as you know, that's just not the case. We do have broad authority, but we have limited powers that are defined by the Constitution, by our statutes, right? And we can't do everything. So, but people call up and they want us to do everything to help them. And in a lot of cases, people are in really tough shape. And when they can't get satisfaction, it's often at the point where they talk to a receptionist or they talk to support staff. And they don't get to me, right? Because the receptionist answered the call, right? And if she's unable to help them, they can get really angry. And that happens often. That happens every day. But it maturing into a threat happens with some regularity, and it happens to everybody.
Thank you. And it is disappointing and downright scary. So I appreciate you coming. I appreciate you wanting to protect your staff and helping us understand and actually see that it is happening to more than the AAGs. Not that there is any, and let me be, again, very clear, not that there is any reason it should be happening to just them, but knowing that there is a reason to be protecting folks who might be behind the scenes. Thank you, sir.
Yeah.
Good to see you. Thank you, Madam Chair.
Thank you.
Thank you, Representative. Are there any other questions for Attorney General Tong? Seeing none, thank you again for your testimony. Thanks for being with us today.
Thank you, everybody. Good to see you.
Next, we will hear from our esteemed Secretary of the State, Denise Merrill. Madam Clerk, is Secretary Merrill with us this afternoon?
Just one moment, please.
Okay, thank you. Okay, welcome, Secretary Merrill.
Am I there yet?
Yes, you are. Welcome. The floor is
Great,
yours.
thank you. Thank you. You have to push a number of buttons to make that happen. Good afternoon, the Chairman Fox and Flexer, Vice Chairs Haskell and Thomas, ranking members Sampson and Mastro Francesco, members of the committee. I am Denise Merrill, Secretary of the State of Connecticut. And in the interest of time, I will be really abbreviated because I'm kind of a regular on this committee. And so I want to leave plenty of time for people to ask questions. I know I've submitted written testimony today. I'm just going to address a few of the issues on your agenda today. I want to speak in support of them. So first, I'll start with Senate Bill 1017, which is an act concerning election administration. Its purpose is to make the administration of elections easier for local officials and make navigating that administration easier for voters. And I want to highlight some of the most important provisions in this particular bill. One of the most visible and popular responses to holding the 2020 election amid COVID-19 was the introduction of secure absentee ballot drop boxes. These secure drop boxes were paid for entirely by federal CARES Act funds. They were manufactured by American Security Cabinets, a vendor that's been manufacturing drop boxes for other states for decades, and were made to the most stringent security standards available. I want to make sure people understand that these are probably even more secure than your standard mailbox. We were able to purchase and deliver at least one and as many as 4 to each of Connecticut's 169 cities and towns. The importance of these drop boxes at the time in particular gave voters a safe way without person-to-person contact to return their absentee ballots themselves and not have to rely on the U.S. Postal Service. Although we don't have real data about how many people use these boxes, but anecdotally, the town clerks have reported they were widely used, and selfies of voters delivering their ballots to the drop boxes across social media last fall attest to that phenomenon as well. People were very proud of delivering their ballots, and they made that known. The authorization to treat these absentee ballots returned by secure Dropbox identically to absentee ballots delivered by mail expired with the 2020 election and the special legislation that was passed. The secure absentee ballot Dropbox provision would make these drop boxes a permanent, convenient part of Connecticut elections. Let's see, Senate Bill 1017 is the second bill I'd like to talk about. It's an act concerning election administration. This bill would also require the development of a system under which Title IX forms could be signed and submitted electronically. So this, for example, might allow absentee ballots to be requested, and I want to make sure I emphasize you'd be able to request an absentee ballot online. This would be an application process. It could open the online voter registration system to more people who are eligible to vote in Connecticut who don't have a driver's license, for example. It could be as simple as allowing emailed endorsement forms to my office or registration forms to the registrars of voters. This is simply allowing us to do more online process of things that now are done pretty significantly on paper. It would be a streamlining for my office, and it would make the system much easier for everyone who uses it. I'm sure most of you have returned endorsement forms to our office, for example. If this could all be put online, it would be much easier for everyone. So it would also make our audit procedures stronger, requiring centrally counted absentee ballots to be included in the post-election audit. That's important because more and more precincts were being left out of our audit drawing, and it's important statistically that as many precincts are as included as possible. It would also allow my office to create a voting system that would allow print-disabled voters to independently cast absentee ballots. It's a very important issue. And so those are the primary goals of that piece of administration, of the bill on election administration. So those are the three pieces to that. House Bill 6578, an act concerning participation in the electoral process, is a proposal that has come before you before in previous years. It has basically three pieces. I proposed this bill to make it more convenient for citizens to participate in democracy, to choose the people who will represent them in government and make their voices heard. So the first part of this would allow people who are on parole to register and vote, just like people who are on probation. And the basic thinking around this is that someone who has fulfilled their obligation and is back in the community should be allowed to regain their right to vote. And truthfully, now it creates a lot of confusion that you have a kind of a dual system, that people on probation are allowed to get their vote back, but people on parole are not. So this would simply level the playing field for anyone who is in the community. It would bring Connecticut in line with the 18 states and District of Columbia, including all our neighbors in New England, that allow voting rights to reattach automatically when the period of incarceration comes to an end. Reattaching voting rights to people as they leave their period of confinement doesn't just alleviate confusion, it helps people reintegrate into civic life of their community. And I think that's a very important goal for all of us, to make sure that people can reintegrate properly. And it's a form of civic engagement that we need to be encouraging. So we hope that those folks will become lifetime voters as they come back into the community and participate. The bill also, second piece, codifies our existing automatic voter registration process, streamlines the process, make it more convenient for voters, and allows the expansion of the program to other voter registration agencies under the old Motor Voter Act, which was passed many years ago and did require us to reach out to agencies that interact with the public and get them to do voter registration as well as the DMV. Since automatic voter registration was implemented in August 2016, more than 550,000 new Connecticut voters have used automatic voter registration to register. More than 700,000 have made changes to their registration. This has helped us enormously in making our lists better because people do it themselves. You don't have to read their handwriting, and a lot of mistakes get made that are clerical error otherwise. It's been a wonderful process. I think everyone sees that it has really expanded our ability to get people registered to vote properly. And finally, the third piece of this bill eliminates the anachronistic challenger designation on election day polling locations from Title IX. These challengers currently exist in statute, but it really hasn't been used for many, many years. And that's because it's kind of a vestige of a time when everyone in town knew everyone else. And when we changed the laws, and I don't remember exactly what year, we allowed everyone who's officially inside a polling place, including people who are not poll workers but are the unofficial checkers that parties designate, anyone can challenge someone who's attempting to vote in that polling place, so long as the challenge is not made indiscriminately and the person issuing the challenge knows, suspects, or reasonably believes the challenge is valid. So this was actually an expansion of people to be able to challenge anyone they thought was inappropriately trying to vote. I think the statute itself is no longer needed, basically. So I would very highly recommend that we eliminate this old statute. I also want to speak briefly about Senate Bill 753, an act concerning the counting of incarcerated persons for purposes of determining legislative districts. This bill requires incarcerated persons to be counted at their last known address prior to incarceration, rather than in the location of the correctional facility for purposes of determining legislative districts after the decennial census. As in the past, I am testifying in support of this concept. Counting incarcerated persons in the community in which they lived prior to incarceration gives a much more accurate population count in both Connecticut's major cities and in the towns that host our correctional facilities. It will result in fairer legislative districts that more accurately represent the communities from which they're drawn. I would remind you all this bill is time sensitive. The decennial redistricting following the census is scheduled to take place this year. So I just wanted to put that in there as my support for this concept based on the fact that you would have fairer districts represented. And finally, one other proposal I wanted to draw your attention, HB 6575, an act concerning risk limiting audits for election results, which would simply create a working group to investigate and test the possibility of instituting a system of post-election risk limiting audits. I want to point out, we do now have a very strong audit system, but it is based on the idea that we would have a finite number and determined number of districts. We pull the names out of a hat. It's 5% of all the precincts are included, and we then do an audit of those districts. We actually have a wonderful high-speed scanning process now where the burden has been taken off the towns to do all the hand counting, and it works very well. But what it doesn't do is take into account the fact that most of the questions around ballots after the fact come in districts where there are close races. So my understanding of risk limiting audits, and I have to say I have heard about this process from the national level from states that are starting to use it, and a lot of computer scientists are telling us it is statistically more valid than what we're doing. There are a number of ways to do it, but my basic understanding is that you audit those districts where there are very close margins, and that every district has to agree that they will audit a certain number of their ballots. but that way we'd be able to audit based on the margins in a given election to determine the results of an election tabulated by the machines, that they match the ballots filled out by the voters to a level of statistical certainty. And my understanding is that's the main point of a risk limiting audit. So statisticians and computer scientists have all lobbied us to go to this more precise method. I would very much like to try it out and do a couple of models in some towns who might volunteer to try this in the interim election in the fall. So it would just be a pilot program, and we'd test one or more of these different methods, because there are different methods of doing this. So the final report would be due to this committee prior to the 2022 legislative session. So I'd like to take a look at that. And just one final small note on House Bill 6212, an act concerning the confidentiality of residential address of certain protected persons in online municipal records. There are different pieces to this bill and different concerns. We've been talking about these issues for many years now in terms of how does one, and I was very interested to hear the conversation with the Attorney General about the protection of people's addresses, you know, state employees and so forth. But I would just say, and there are other issues, I'm sure the clerks, you'll hear from the clerks on this issue, but it does, in a very positive way, I think, touch on our Safe at Home program. My office operates a program that protects people who, you have to be referred to the program from an assault crisis center or something of the like, but you can have your address protected on the voter file. And as you can imagine, this is a very tricky question. We certainly don't do it lightly, but this would expand it to people who have actual court orders that are, you know, protective or restraining orders, or survivors of sexual assault, stalking, that sort of thing. They would be able to get on this list without having to have an actual referral. I would say that a restraining order is referral enough for someone to be able to get onto this list. And I do think it would protect more people. So that's all I'll talk about for now. Thank you for your time. Look forward to your questions.
Thank you, Secretary Merrill. Thank you for your testimony. I see some questions from members of the committee. Representative Haddad.
Thank you, Madam Chairwoman. I appreciate the opportunity to ask a couple of questions of Secretary Merrill. Well, welcome to the committee, Representative Merrill. Secretary Merrill. I wanted to ask a couple of questions about the redistricting bill, and I do so acknowledging probably that this is a complex area of the law, and that you are not likely to be an expert. But I know that you have consistently in the past supported the idea of correcting the census numbers to reflect the home address, most recent home address of prisoners, rather than counting them where they are currently institutionalized. I thought, though, one question, baseline question, it's my understanding that some portion of the imprisoned population hasn't lost the ability, you know, their voting rights. They might be pre-conviction or elsewhere, and they're allowed to vote by absentee. And it's furthermore my understanding that when they vote by absentee, they're required to use their last residential address and not their institutional address to cast that ballot. Is that accurate?
Yeah, I think you're referring to those folks who are in pretrial detainment of some sort, maybe right. In jail rather than prison, that sort of thing. And yes, then different rules do apply. You know, there's a lot of administrative questions about all of this, because you know, sometimes it's even difficult to determine where was the last residential address, for example. So yes, that's correct, though. There are a certain number. I don't know what that number is, but that is an exception to the rule.
Still, it just seems interesting to me that when somebody, again, sort of a pretrial, you know, imprisoned person is allowed to vote, cast a ballot, that they cast that ballot at their last residential address and not where they're currently housed. And yet when we count them for the purposes of reapportionment or redistricting, that we include those numbers in at the institutional location. It just seems to me that those two things seem to be inconsistent, and that would be wise to allocate those numbers where at their last known residential address. In 2020, 2010, you might recall a prison being located in what was your district and became my district. And one of the other sort of quirky things about this, I guess, I just wanted to mention, is that prison closed after the April 1st census period, but before redistricting was actually completed. And so I currently still have about 1,000 prisoners counted in the official count for the 54th district, who in fact were never there since the time that those new district lines were drawn. And those discrepancies could be resolved as well by reallocating the prisoner numbers to their last known residential address. I thank you for your testimony and thank the chair for the opportunity to ask a question, make a point. I look forward to working with you on that initiative as we move forward. Thank you.
Thanks very much. And you're reminding me of those old days when we had to grapple with some of these issues, but that's exactly right. And I would agree with everything you said. Yep.
Thank you, Representative. Representative Mastro Francesco.
Thank you, Madam Chair. Thank you, Madam Secretary. It's a pleasure to see you again.
Always
nice to chat with you. I have quite a few questions on the bill, but particularly I want to just, if you wouldn't mind, if I can just ask you a question on 6212, the confidentiality of the residential address for persons under protected persons. Just so I know that I'm asking the right person the questions. Did this bill come out of your office? Through you, Madam Chair.
No, it did not. I'm almost commenting as an aside on the fact that the result of this would be that more people would be eligible to get on the Safe at Home program.
Okay, thank you. And because I had some questions on it, but I guess I should reserve those for maybe the town clerks when they come in. So thank you for clarifying that for me.
Sure.
Okay, through you, Madam Chair, on Senate Bill 1017, you had testified on.
Mm-hmm.
So the first question I have is really with the drop boxes, right? I had concerns about them when they were first came out. I understand they were paid for through the CARES Act. If these were to be a permanent fixture in our elections, whose responsibility is it to care for them? And if something's damaged, they need to replace them. Is it goes through each individual town would bear the cost on that, or is that something through the state? Through you, Madam Chair.
It would now be, they now belong to the towns, so it would be the town's responsibility.
And then do we know, or do you know, what the cost is on those boxes?
I don't recall exactly, and maybe I do think my staff person, Ted Bromley, is on the call. I think it's in the vicinity of $2,500, something like that. Am I close? I'm told it's a little more than 4 million for the entire state.
Oh, no, wait.
No, I think, yeah. Anyway, I think they're about $2,500 each. They're expensive. They're not cheap. They're
Okay.
very well made and very strong.
Yeah. Okay. So if they're $2,500 per box, is depending on the size of the town, I guess, or the population, or the size of the town or the city, would there be a determination of how many ballot boxes they were allowed, or could a town say, look, I want to put one on every public building or every street corner? Through you, Madam Chair.
There were limitations on the way they were used, put in legislation. For example, there had to be a certain servicing of them and so forth, but all that would be the responsibility of the towns.
Okay, so and through you, Madam Chair, so for an example, let's just say I'll take a big city in the state of Connecticut. How many ballot boxes did they get? So I'm just trying to figure out cost per town.
Yeah. we paid for up to 4. I think for the larger cities, it was basically kind of based on number of voters. Some towns requested more because the towns have to be the ones to service it. The town clerks it had to be in a location that the town clerks were able to come and empty it every day. There even had to be police presence when they were somewhere that were not right at town hall. So there were a number of limitations that had to be honored to use these drop boxes. So I would assume that a town would have to take that into consideration if they wanted to place more of them in place. They'd still have to service them in the same way. That would be up to the town. We have provided everything we had. Federal money is done, but we have provided at least one for every town, and I think that's the important point.
Okay, thank you. Online in that particular section of the bill, when you excuse me, when you talk about the drop boxes, and I think you had just mentioned it, I believe it's on line 17. During the 2020 election, when the town clerk had to go out and secure those ballots and take those ballots, if they were off site and not in front of town hall, there was a police escort with them. In the language in this particular bill, you're saying that will no longer be. There will no longer be a police escort for them to get those ballot boxes. And let me look at the exact line. I think it was. Right, so there's no longer a police escort. Through you, Madam Chair.
Yes. Sorry, I'm consulting with staff back here, but I know one of the staff people, Ted Bromley, the attorney, is on the line somewhere if we need more specific information. But essentially, when we crafted this legislation, we consulted with the town clerks and we asked them, do you think this is necessary? Because essentially, this is a job for the town clerks. It's a way of making their jobs easier, frankly. Because they have the ballots come into one place and they can go out and collect them once a day in whatever way makes sense for their town. There's a vast variety of towns in the state. So they told us they didn't think it was necessary, that they thought they were capable of doing it without the police presence. We had absolutely no problems with the ballot boxes, despite I know there were concerns expressed about what would happen if different things occurred. They proved to be very, very popular and very well used. And I gather from the town clerks that we talked to, there were no problems whatsoever. So that was their advice.
Okay, thank you for that. And through you, Madam Chair. So the town clerk will be responsible for picking up the ballots. Does it have to be the town clerk specifically picking up the ballots out of the box, or can she just send, or he just send anybody there to pick them up?
I believe the town clerk has to do that themselves. I mean, either a town clerk or a designee of the town clerk. They can designate, certainly. I'm sure they have assistants and all kinds of people in their office that would be available to pick them up.
Okay, thank you. So pretty much anybody that works for the town, she can really designate anybody to go pick up those ballots.
Yes, well, it would be similar to, they could send somebody to the mail room to pick up the ballots from the mail too. It's the same idea. Ballot boxes are treated exactly like mailboxes, essentially.
Right. And speaking of mailboxes, thank you, through you, Madam Chair. Speaking of mailboxes that you mentioned, why do you feel that these are, or maybe you don't, that these drop boxes are more secure or just as secure as a regular mailbox?
Well, they're basically built specifically for this purpose. They're extremely strong and heavy, if you've ever tried to move one. And they have a smaller opening, actually, so you can't even really get your hand in it. It's very, very secure and used, as I said, throughout the country for this purpose.
Okay, thank you.
And by the way, I should mention they are Homeland Security certified. This has been all in response to Homeland Security concerns about all kinds of different security, but so they've been certified nationally, and so they have all the protections that you might need for something like this.
Right. So what I have a concern with is if the ballot box is not in front of the town and it's off-site, anybody can go, the town clerk can designate anybody to go pick those up, correct? to go to get the ballot and get it. It could be a neighbor. It really could be anybody because there's nothing really clarified in this piece of legislation. But when we compare it to a post office, when they open the mailbox, they use the key, they open it. It is an employee of the post office. They don't just send anybody out to pick up that mail and bring it back to the postal service. So I have a lot of concerns with the ballot boxes in that respect, if you can understand that. It's anybody can go collect those ballots.
Well, it has to be a designee of the town clerk. So the town clerk is the official that's in charge of collecting absentee ballots. So yes, it would have to be a designee of the town clerk.
Right, and it doesn't have to be an employee of the town. It could be anybody.
Anyone that the town clerk decided to designate, I'm sure it would mostly be an employee in that office.
Okay, thank you. And through you, Madam Chair, online, aside from the ballot boxes, on line 22 of the bill here, when they started talking about, in reference to nominating petitions, a line was taken out that the person circulating a petition does not have to be a resident of the state.
Oh, you're talking about the federal court case. Yes, there was a federal court case. That bill has been in front of you for several years now. There was a federal court case that required us to conform our statutes to federal law. That is federal law, and our statute is in direct opposition to the federal statute. The Department of Justice and others have recommended, and we lost the lawsuit when we challenged that ruling. So this would just do what we've been told by the court to do.
Okay, I was just curious on that particular one. Let me just check. I had a couple more here. I apologize. What's line number 201? Yes, okay. Going further through this bill, number 1017, on line 201, it says that a candidacy for nomination be filled on behalf of any person other than a party endorsed candidate not later than 14 days, and it was changed to the day. Can you explain that and clarify that for me after the party endorsement? And that was on line 200.
Okay, I need the bill. I don't have the bill in front of me.
The issue is that our timeline for these types of overseas ballots needs to be aligned with the federal, which is more, which means we back up some of the other.
Madam Secretary, what is basically happening when you talk like that is the person who's in your office, their audio is coming through crystal clear, just so you know.
That's fine. Yeah, okay. No, that's good. Actually, I wish we could have had a staff person actually online, and I thought there was going to be an opportunity to do that, but I don't see him on here. Is Ted Bromley on the call?
He is on here.
Oh, all right. Maybe I'll turn to Ted and ask him to explain it. Again, this is a conforming statute where our timeline for overseas and absent overseas ballots is not the same as the federal timeline. The federal timeline is longer, so we need to come into compliance with federal law. Is that roughly correct, Ted?
Good afternoon. This is Ted Bromley. For the record, Ted Bromley, B-R-O-M-L-E-Y. I'm the Director of Elections for the Secretary of State. And yes, that's correct. So all that is doing is at the request of Department of Justice to avoid a lawsuit. We simply need to back that language up. And that language only refers to a special election for a U.S. Senate or a representative in Congress race, where we have to make blank ballots available to our military personnel 45 days prior to any election, including a special election. And by backing that language up, it allows us sufficient time to prepare and distribute those 45-day ballots. Whereas if we were to leave the language the way it is, the 45-day ballots would not be available on time, and we would be in violation of federal law.
And I'm sorry for interrupting. Mr. Bromley, if you should speak again, if you are able to put on your camera, I think it's best for public hearing transparency if you could do that when you're contributing. And thank you for being here.
Oh, sure. Absolutely. I'll see if I can adjust the lighting. Otherwise, it may just be a dark shadow.
That's okay.
Thank you. And through you, Madam Chair. So I guess I'm just a little confused as to what it means, and maybe, and if you don't mind explaining it again, on lines, I guess, starting at 198. It says if a candidacy for nomination is filled by or on behalf of any person other than party endorsed candidate, not later than, the current language is 14 days after the party endorsement. What is that exactly, I guess, through you, Madam Chair? What is the 14 days for?
Attorney Bromley could again answer that question because that's about the timelines that are currently in place for us to get the absentee ballots to the overseas voters, right? So Ted, if you
Correct.
could.
Okay.
Right. So I am on camera now. Hello. Yes, correct. So what that statute is referring to is 9-450, which is a vacancy statute. So there is a vacancy in representative in Congress or US Senate. So that again is a special election. It has nothing to do with regular elections. And right now, our special election statutes are so compressed, it does not allow us time to comply with the federal law of allowing an absentee ballot to be sent to military 45 days prior to any special election.
Okay, so thank you for that answer. So you're saying now, currently, you have up until 14 days to send that, and we're changing it to make sure that it goes out on that specific day. Is that a
Correct.
right analogy? Thank you.
Correct,
Yeah.
because the,
Okay.
yes. I'm sorry, Madam Chair, can I?
Yes, you can.
Okay. Yes, correct, because obviously 45 days, we need to back it up 45 days rather than 14 days prior to. Of course, 14 days would not allow us to comply with the 45-day statute.
Okay, thank you for clarifying that. It was a little confusing to me. Maybe because today's Wednesday, they call that hump day. so I guess that must be it. Getting close to Friday. Thank you. And through you, Madam Chair, Madam Secretary, on lines 298, section 10, it talks about an electronic signature. Would you mind elaborating that a little bit more and explaining it?
Through you, Madam Chair. Yes, the request to have us authorized to use an electronic signature would help us as we, in other words, take an example like trying to get an application for an absentee ballot. You now you can get it, anyone can get one, right? You have to request it and we can send it to you. You can get it from my website, for example, but you still have to download it, print it out, sign it and mail it in. Now, obviously, that's a very labor-intensive process compared with the way we do almost everything else now. So what this would allow us to do was to have an electronic signature. And it's basically just a picture of your signature that's collected at DMV right now is the only place we can do that. It's the way we can facilitate you being able to send in a form without having an actual very expensive and difficult to put in place signature process. I don't know if you've ever signed things on DocuSign, for example. Now we do many things on DocuSign. We can't do that because we don't have a way to grab your signature. The only way we can do that is what we do right now through the DMV, which is when you go to the DMV to register your car or you're asked if you want to register to vote. We can do that because DMV does keep signatures on file. And so we can go into that file and get a picture of your signature, which allows us to use that signature. So this is the same thing. And it could be used for a number of different things. These systems would have to be, paid for and processed. So we don't have anything of the kind right now because we have no authorization to be able to develop those online processes.
Oh, thank you. And through you, Madam Chair. So are you saying that they would be able to just get an application online and request it? You will match their exact signature, their original signature that they have on file at the motor vehicle.
Right.
Right. If they even have anything on file at the motor vehicle, because
that's right.
Some people don't drive. Right.
That's right.
So how would you verify that and with someone who doesn't have that signature on file at the motor vehicle? The DocuSign I'm sorry.
Yeah, as at this point, we would not be able to. This kind of a system would only be useful for someone who had a signature on file with DMV. Now, bear in mind, in the future, I think it's kind of an interim step at this point. In the future, I think we'll be able to do things differently. Perhaps the state will have some sort of DocuSign type system where you log in and you have verification and all that. Right now, this would be a convenience. That's all it would be. And it could only be for people who have a signature on file that we can take a picture of. This is not a verification of the signature. It's just a picture of your signature that we would be able to affix to anything like that. So clearly it could only be, take another example. You all file endorsements, right? When you get nominated or elected, you have to file an endorsement form with our office. Right now, you can only file it on paper because we have no way to receive a file that doesn't have a signature on it. So frequently people have to come up in person. There are deadlines. If mistakes are made, we can't correct them because we just have that one document and there's no way to do what happens now on many online systems where it says, oh, you forgot to fill in number 15 or, you know, this is wrong or something. You know, it would be a much better, more streamlined system. So this just provides us the authority to begin trying to develop some of these systems. It's the first step, really.
Yeah. I gotta say through you, Madam Chair, that this is very concerning because one of the cost, do you know what the cost involved is in this? Is there a cost to the towns as well? Will the towns be able to utilize that system as well?
Well, no, there'd be no cost to the towns. And if there were, we'd have to work that out. But no, there would be a cost to develop some of these systems. We've developed many of these online systems through our IT technology fund. The state, right now we're developing a tremendous number of systems in the business services division where we've been able to put all these processes online that you used to have to come in person to do in my office. It's just a streamlining effect, and it's something all of state government is working toward, being able to do a lot more of this online.
So through you, Madam Chair, so we don't know the cost to the state of Connecticut for something like this. This is something fairly new. Is it done in other states?
Yeah, of course. There's no cost because there's no system yet. I mean, this just allows us to develop systems around whatever we want to put online. We would still need authority for anything we want to do online that would not be covered by statute. But this would at least let us start developing some online systems in a system that has become, it's very paper-based. We're still keeping all the records, the endorsement forms, all that sort of thing is all still being kept in paper in my office, for example.
Yeah, interesting. So I'm concerned as how a town would be able to verify the signature on the application with the ballot when it comes through, if it's done electronically. Through you, Madam Chair. Would you be able to
Well,
talk
I mean, right now, if someone requests an application and they sign it themselves, there's no verification process for an application for an absentee ballot. I mean, it's not verified now. It's verified by the fact they check the list, see if the person's on it, see if the address is correct. And that, I mean, it's no different in that sense.
Okay, right. So there's no verification that they need right now. The application is sent in, they sign it, they send it back to the town, and the town does not match it up with the actual ballot signature when it comes back. So that wouldn't change. Is that what you're saying through you, Madam Chair?
No, they probably verify the ballot signature. I'm saying they don't, there's not a file where the signature is on file for the voter themselves on the voter list. We don't have that system right now. You know, should we have many more absentee ballots? Maybe in the future we'll have to develop some system, although I think there are newer systems that are better than signature matching. But right now, it's not a verification. It's simply a picture of someone's signature, and it has been verified in the sense that they got it at the DMV, they signed at the DMV, so someone was there when they made the original signature. So it's a picture of an original signature, basically.
Okay. Thank you. I guess I was just trying to say that I would assume that that picture can be used to verify the signature on the ballot itself, on the outside envelope.
Yeah, no, it's on the inside envelope.
Or
But,
the inside, correct?
yeah, right. Yes, I'm sure it could be. I don't know if that's the process the clerks use right now. It probably is.
Right, because they don't verify, don't need to verify. So I'm sure many of them, some do and some maybe don't use it because it's not required that they verify the signature. Okay, thank you for that. A few more. On line number 326. It talks about the counting for central locations used in a municipality for counting ballots.
Right.
It says here that shall be deemed a voting district. Is it not a voting district now? And why would it have to be deemed a voting district? Through you, Madam Chair.
Because I don't have the bill in front of me, I'm not sure I can answer that because I don't know what the it is. I guess you're talking about the central counting place.
Yes, through you, Madam. It says any central location used in a municipality for the counting of absentee ballots shall be deemed a voting district. Is that no longer a voting? Is it never a voting district? I mean, if it's in that town, it has to be in a voting district, right?
Right. Well, no, what we're trying to net in there is anywhere that the central counting is being done, and it's not necessarily being done at a voting district. Sometimes it's being done at town hall or, wherever it's being done, we want to make sure they're part of the audit process. That's the point. Right now, centrally counted votes are not, those locations are not included in our audit drawing because they're not precincts. We only audit precincts. And so if they're counting the ballots somewhere that's not a precinct, we want to make sure we capture all the different ballots. That's why we're doing that.
Okay. Thank you for clarifying that. Couple more. Hold on. Get my. Great. Okay, and you had mentioned, it's on line 463, and this particular section talks about when there's a public health emergency.
Mm-hmm.
We're under public health emergency, that it would give you the authority to suspend supervision of filling out absentee ballots.
Are you talking about supervised absentee ballots?
Yes, I'm sorry. Yes, Madam Chair, supervised absentee balloting.
Yes, that was done in the special legislation and would be continued. Yes.
And that's only during a public health emergency, correct?
Correct. Right. And that's, of course, for the protection of the election officials and of the nursing home residents.
Okay, thank you. And lines 487, it talks about if somebody is unable to appear at a polling place because of visual impairment, that we can supply a ballot to them, provided that it is in a format capable of them, which is great. And it can be read on a computer related device. What type of a format would you think that would be in? Would it be like a PDF format you're talking about? Would it have to be something that conforms to the device that perhaps maybe they use? Would you know the format?
Through you, Madam Chair. Yes, it would entirely depend on the disability and the availability of whatever equipment they are using. This was quite a subject of discussion during the pandemic, as we had more and more people who felt they couldn't go to the polling places, and we were looking for ways to enable them to be able to vote using their own assistive devices. But also, we have just purchased a whole system of it's an assistive technology that covers almost any disability, but you do have to go to the polling place to do it. So this is trying to accommodate both.
Okay, thank you. And on the other topic on this particular bill I wanted to mention was removing the May municipal elections. Can you elaborate on that? Like why is that something that the towns want to do? And are they, I mean, with my thought that a towns should have autonomy and certainly to make those decisions themselves, as opposed to having the state get involved in it, saying that it can no longer. So why are you trying to move away from having the towns have a May election? Through you, Madam Chair.
Well, First of all, there are, I believe, 5 towns left in the state that still do May elections, and then there are some boroughs and so forth. It's a smaller number every year. A lot of it is governed by charter, and this statute, by the way, would be permissive. It does not make them change to a November election. But I have to say, for years now, we have suggested that everyone be on the same election calendar, because it's confusing for voters. We have very low turnouts for a lot of these elections, and this would conform it to every other district in the state. And all this does is allow them to do it. I mean, right now, it's not even permissive. If they want to do it, it's usually has to be done through charter of the town. And so this way, there is an avenue for them to be able to choose to go to a November election. We strongly have recommended it for years. But you know, it's difficult. Every town has its own dynamics, I can see. And so this just allows it to happen in a more streamlined way, I'd say.
Okay. Thank you for that. Just one more, Bill, I just wanted to just mention, and maybe just a question and just a couple of comments about the having incarcerated persons vote.
Mm-hmm.
So it is my understanding that when you are incarcerated, obviously there is a time frame that you are fulfilling your obligation for whatever crime you committed or whatever. Would you agree that even if somebody is on parole, that they are still fulfilling their obligation, that's just not being held incarcerated in a prison? Would you agree with that?
Well, yes, they are in the community. I mean, they are not any longer incarcerated. You have to remember, this is about formerly incarcerated people. So once they're in the community, they're living in the community. They may still be performing some things that they need to. That's true of people on probation as well. But that's the goal of this, is to make sure that people that are actually not any longer incarcerated are able to regain their right to vote.
Correct. But part of the current law right now is that if you must fulfill your obligation, whether it's an incarcerated or you're on parole, in order to gain your voting rights back. And of course, whatever obligations comes with that.
Yes. And
so whether they're incarcerated or on parole doesn't matter. They're still fulfilling their obligation.
Well, under current law, that's the definition of when we allow people to regain their rights to vote. I mean, even if people are on probation, they are still fulfilling some duties. They need to report in sometimes, and there are various things. But my yardstick would change. It would be anyone who's in the community and has been released from incarceration, I believe, should regain their right to vote. Our goal should be to allow people to become fully functioning members of society again. That's the goal. They're back in the community, living in the community, having to get jobs and participate. So this is just one more way, I think, to integrate people back into society.
So I guess what I'm understanding would be your assumption that, or maybe, I don't know, your opinion that that part of their obligation that they need to fulfill, one of them is that you cannot vote until your term, until you fulfill that obligation. Your feeling is that they should not have to fulfill that part of the obligation, that they should be able to vote.
That is not an obligation. That's part of what they need to do to regain their right to vote. The right to vote is not an obligation.
Well, they lose that right? Through you, Madam Chair. So they lose that right to vote until they fulfill their term.
And I think we should change that law. That's exactly right. I think there should be a different measure for when someone regains their right to vote. And by the way, many, many, many states now allow for this. We are more an outlier in the sense that we do not allow people who are out of jail in the community to vote, to regain the right to vote. In fact, as you probably know, some states actually allow people the right to vote while they're in prison. So, you know, it's just where you draw that line, and I think we should draw it at a different place.
Okay, well, I respectfully, Madam Secretary, I disagree on that particular note. I believe that if you're incarcerated or on parole, part of that punishment is that you lose your right to vote. And I believe that should be fulfilled before that right is restored. So respectfully, I disagree with you on that, but I understand your position. I don't want to take up too much time because I'm sure other people have a lot of questions. So I will end it there. Of course, I probably can sit here for another hour and ask you questions, but I will spare you and let the rest of the members of this great committee ask what they have to. But thank you, Madam Secretary, and thank you, Madam Chair.
Thank you, Representative. Are there other questions from members of the committee? Senator Sampson.
Thank you, Madam Chairman. Good afternoon, Madam Secretary. Nice to see you again.
Nice to see you.
Yeah, I'm going to be much more brief today. My co-ranking member did a fine job. She covered most of the territory I wanted to, but I just have a few follow-ups. I also just want to make a quick comment for some of the folks who have been tweeting and commenting this meeting and the previous one that somehow this is a filibuster attempt when my Republican colleagues and I ask you and other members of the administration a lot of questions. And I just want to assure people that, you know, you are a major proponent of this legislation, and you know, we're trying to get the information from the horse's mouth. And I assure you, I have no desire to waste anyone's time, nor make this meeting last until the wee hours of the morning. So I'll leave it with that, and I will try and be as quick as I can on some of these questions. So on the drop boxes, just to begin with, I guess the focus there is my concern, and people that have come to me, just it's simply a chain of custody situation. So would you be kind enough to explain to us how we are maintaining an appropriate chain of custody? Like, for example, when, you know, at individual voting precincts, at the end of the night, the ballots are collected and they are stored in bags and locked, and they are transported back to the central location, town hall or whatever. But they are constantly under the supervision of a Republican and a Democrat to make sure that nothing funny happens with those ballots. And I see that that is a lacking component when we move to drop boxes. So can you do anything to help reassure me that we are going to have an appropriate means of verifying that the ballots are not tampered with from the time they go into the box till the time they're counted? Through you, Madam Chair.
Yes, thank you. Through you. We are not doing anything different with absentee ballots that are dropped in drop boxes than have ever been done with absentee ballots. There is a chain of custody. It's well defined. The town clerks take care of absentee ballots. They have a way of storing them. We don't count ballots before Election Day in Connecticut, so that is all governed by current law, and we're not changing anything about that, except that they're going to walk out to this box and get the ballots and bring them into their office. And the same rules apply. It's just that there were more of them this time. And so until we have a situation where potentially, I hope, we make them available again to a broader range of people, there aren't that many. So it's the standard chain of custody we always have for absentee ballots.
I appreciate your testimony, Madam Secretary, and I respect you very much. I don't want to debate you here on that, but that's just simply cannot be true. I mean, for example, a town clerk doesn't work on weekends, so there's no one monitoring those boxes, you know, from Friday at 5 p.m. when they lock up shop. And this is, you know, ones that they may have some direct oversight at because it's right at the town hall. But when the boxes that are out on the street corner somewhere in New Haven, nobody's watching that box. I mean, that strikes me as a direct flaw in the custody argument. And also, you mentioned to me that you feel they're more secure than mailboxes. I want to point out that a modern U.S. Postal Service mailbox has nothing but a tiny slit. I mean, you can't really even put a very thick envelope in one. Whereas these boxes have a door that opens that you can put a sizable envelope in, bigger than what the absentee ballot envelope is, and then close it. And I want to share something with you, Madam Secretary, which is that, during the last election, I am an administrator on a Facebook page that asks people to report concerns with elections. And I got many comments from people about lots of different things, mostly about receiving absentee ballot applications for people that don't live in their home or in multiple names and things like that. But one of the things I received was a photograph of one of these drop boxes, and I'd be happy to share it with the committee. And I don't have any way, I don't want to make any allegations or anything, but it would be a very difficult photo to Photoshop, if you ask me. And it's one of those drop boxes that has multiple, maybe 6 or 7, I'm looking at it, 6 or 7 ballot envelopes stuffed in it, maybe presumably because the box was overfilled. I mean, they're clearly the right envelopes. I don't know that there'd be a way for someone to doctor this photo or something like that. It's a concern I have, that what if that did happen? What if the box overfilled and people are leaving their ballot envelopes hanging out of the slit or the door? Anyway, I don't know that there are answers to these questions. I just wanted to draw some attention to the chain of custody concerns that some of us have are legitimate. Is there any way to monitor these drop boxes during the weekends? Will there be any police presence? Anything that you might contribute to say, hey, Senator Sampson, you can feel much more confident about the drop boxes because they're going to be monitored in some way. And that the person that's going to pick up the ballots, we're going to have their name on file, etc., or they will swear to an affidavit that they are, transporting the ballots under penalty of whatever. Can you help me in some way trust the boxes? This is what I'm after, because I don't necessarily trust absentee ballots going through the U.S. Postal Service either, but at this point, I trust that more than the boxes. And you seem to believe they're more secure. And I gave you a bunch of arguments why I say no. Help me understand why you think the opposite.
I will try. I can only tell you that the drop boxes are extremely secure. I don't think you have any reason to worry that somehow they're going to be sabotaged or overrun with too many ballots. I mean, I'm sure there were instances where everything did not run perfectly in this election and every election. I think most of your questions would be addressed to town clerks, who are the ones who are responsible for the actual implementation of all this. But we did the best we could, and I think we did a very good job, by the way, of trying to come up with standards and practices that would make it easiest for voters and for clerks, but mostly for voters. And when I say I think it's more secure than a post office box, I'm not sure I think that's exactly true, but we did have a lot of questions about the timeliness of the delivery of the post office during COVID. I mean, a lot of these things were unique circumstances where we had to react and make things as good as we could for all the voters in the state. The main goal was to make sure that everyone could vote and that they could be secure in the knowledge that their ballot had actually arrived if they chose not to appear at a polling place for very valid reasons, by the way. And so if we had occasions where town clerks couldn't quite manage the flow of the ballots, maybe that happened. I'm not sure if it did or it didn't, but there could have been instances like that. But all these arguments remind me that if you have so little evidence of a problem, you shouldn't be worrying about just not doing it at all. It kind of reminds me of the fact that every time you go outside your house and cross the street, you probably have a 1 in a million chance of getting hit by a car. But that doesn't mean you're not going to cross the street again. It just means there's a chance of mishaps. And in this instance, I suppose if someone had reported that instance that you're citing to the town clerks, they may have been able to deal with it. But I'm sorry to hear it happened, if it did. And we have to do the best we can under any circumstance. There is no doubt in my mind that the ballot boxes made it far easier for folks to vote and to be sure that their ballots arrived at town hall. That was the goal of the ballot boxes. They are as secure as anyone can make them. They're widely used across the country and have been for many, many years. And I think they are a valuable asset in our goal of getting everybody to be able to vote. And I hope we can make them permanent, because they are, first of all, they're now the property of the towns. We bought these boxes. They were very popular with voters. As you can see, if the boxes were actually overflowing, that means great, we got more people voting. But, you know, I think you have to think about the voters in this instance. And that's all I can say, is I think we have to do everything we can to make it possible for everybody to get their ballots delivered in a timely way. And the clerks, I'm sure, do the best they can.
Respectfully, Madam Secretary, you put a lot of words in my mouth in those comments. I am not suggesting that we don't use the drop boxes. I asked pretty pointed and direct, and I think solid, important questions about chain of custody and security issues. And you simply answered me by saying you think it's more secure. You didn't answer any of my concerns at all directly. And I don't mean to be disrespectful, but you're implying that somehow I don't want people to have access to voting. And that couldn't be farther from the truth. You know, this committee took votes the other day on the constitutional amendments, and I believe all of the Republican members of the committee joined the Democrats in supporting both initiatives, as long as there were security, you know, concerns addressed as part of it. You know, and that's the same thing here. So my concern about the drop boxes, and I'll move on, is not I don't want to provide access to voting. It's we have to make sure we have a responsibility to make sure that people can trust those ballot boxes. And the things I mentioned are real things. And it doesn't matter what party you're in or whether your candidate won or lost. We should be making sure everyone's vote matters enough that we will never take a chance that there's inaccurate votes or ballots that are lost or stolen because they're hanging out of a drop box. I want to just move on to the audit situation. I know that the state of Connecticut does do audits of elections, and I think that's great, and I appreciate your desire to expand them. But you did, in your testimony, say that I can't remember the exact comment, but it was something to the effect that we do a lot more auditing than other places, that kind of thing. But I just want to confirm for the record, we do not audit election day registrations and those votes, do we?
No, we do not. We audit the machines. We audit the tabulators. That's right.
Right. So if someone comes in and swears that they are John Smith and they're going to vote on election day and they cast their vote, there's no way to ever really know whether that person was John Smith. The clerk will actually send out a card, a registration card, when they register them. And we learned from testimony in the last hearing that some of those registrations didn't occur for months afterwards. I don't know the reason for that, but the person voted on November election day registration on November 3rd, but they didn't actually become registered till March, which is a whole separate problem, but it does show that there is a loophole there. Would you be in favor of some process to help audit election day registration where we at least collect the returned registration cards and verify whether those are legitimate voters or not? Through you, Madam Chairman.
I'm not sure that would be a completely new type of audit, but you know, we could look at it. If you have ideas about how to do it, we'd be listening.
Understood. Well, it's a bill I propose every year, and I know that there are members in both parties that are interested and want to find the best way to make sure that we are verifying the veracity and integrity of our elections. So I thank you for the answer, and I appreciate your willingness to work with me on it. You know, a lot of the policies that you've come to us with, you know, I don't object to. I want to provide access to voting also. We just have concerns about making sure some of these security items are taken care of. We also don't verify signatures for absentee ballots, as you pointed out in your conversation with Representative Mastro Francesco. But many states do have a signature verification process, and some of them are very robust, where they actually collect multiple signatures in multiple places from folks. So they have a really solid record. Do you have any objections, for the Secretary of State's office beginning the process of setting a signature verification policy in place to be implemented at some point in the future if we, as you said, we radically increase the number of people voting by absentee ballot? It seems like it might be a smart idea. What do you think about that?
I think that is something we're probably going to have to look at some form of that should we get to the point where we have many more absentee ballots. I mean, remember, up until now, we've only had about 4% of the population voting by absentee ballot. When and if the constitutional amendment is passed and we're able to allow people to get absentee ballots more readily, I think we probably should look at some sort of verification system for a large number. Don't forget, most of the states that have the verification system have them in place. Those are vote by mail states. And that's why they have such a very, very.
Right. Well, I mean, this is the reason why I'm bringing it up is that I'm sorry, I thought you were done, but you were just cutting out, Madam Secretary.
Well, it looks like the secretary might be frozen.
Such a very.
We'll give her just a minute.
Hopefully it's
Secretary
just a
Merrill,
signal.
perhaps Secretary Merrill, if you turn off your camera, but turn your microphone back on, we can hear you, if not see you.
Madam Chair, are we back?
Yep, Madam Secretary, the floor is still yours. I think you cut out while you were just talking.
Oh, okay. I think we were talking about signature matching protocols, right? Yeah, I think I was just pointing out that most of the states that have the signature matching protocols that are quite extensive in some cases, like Colorado, are mostly vote by mail states where people are just mailed a ballot. There is no application. If you are on the list, you are mailed a ballot for the next election, and then you mail it back. So that's why they feel they have to have a more extensive verification. Where here we have an entire process of applying for a ballot, getting it back in the mail. So, and also, as I was saying, we don't have that many. Should we get to the point after passage of a constitutional amendment where we need to institute a more robust system, I think I would be all ears.
Thank you, Madam Secretary, through Madam Chairman. I appreciate your comments, although you're forgetting that the most recent election, we had a lot more than 4%. 650,000, I think, is the number you have used. So I believe signature verification should have been required in that election. Under perfect circumstances, which of course I understand we did not have. But if we ever move to a set of circumstances that has that many absentee ballots, I hope that this body and the members of this committee recognize that we really do need to address that concern. I'm almost done, Madam Secretary. I'm going to just make a quick comment on the setting up a district for absentee ballot counting. Representative Mastro Francesco asked you about this. I just want, for clarification's sake, are you suggesting that we establish a separate precinct number for the absentee ballots in each election district through you, Madam Chair?
No. I'm just trying to net in those centrally counted ballots. This results from the fact that when we first began auditing ballots after the fact, and we're defining it as a certain number per precinct, that at that time, most towns counted locally at the precinct level. And what's happened over the years is more and more towns are counting centrally, and they're not part of the audit process. And that, I think, statistically makes a difference for us. So we're just trying to find a way to define every place where they're counting ballots as part of that process. It has nothing to do with creating more precincts.
Okay, thank you for that answer, Madam Secretary. I guess, do we not now, when we do an audit of a particular Senate district, for example, are the absentees not part of that audit currently?
Well, this isn't about absentee ballots. This is about ballots that are counted centrally. Some towns count the ballots at the actual precinct, and some towns count it, all of them. They bring them all to town hall and count them there. And those are the ones that right now are not included in our audit process. It's really not to do with absentee ballots.
Right. Well, the reason why I ask is simply through you, Madam Chairman, is because many towns that do they do count their absentee ballots centrally because they're returned centrally.
Right.
So that's what I'm driving at. Is it in a lot of small towns, like my town of Wolcott, for example, that's what happens here. Is all of the absentee ballots are at town hall and they are counted in that location. They would not be part of a audit in, for example, my race or Representative Master Francesco's.
I believe that's true currently, but I'll ask Attorney Bromley to back me up on this. I'm not entirely certain how that works.
Okay. Well, I appreciate the effort to include them going forward either way. And so thank you very much for that, including that language in this bill. And I just have a final couple of comments about the two bills about incarcerated individuals. I guess what I would ask you on the subject of counting people for districting purposes based on being housed in prison, I guess it just leads to a lot of questions. Like, for example, if someone has a life sentence and they're never returning to the town that they lived in prior, does it make sense to count them as someone from the town of Ansonia or Farmington or wherever? Through you, Madam Chairman.
Yes, through you, Madam Chairman. It is. There are many questions regarding the administration of what would be, concerning these matters, and we've been through these conversations many times. And it is a complicated question, that residency question. But I guess in the end, I come down on the side of saying, they're not voting in that district. So in a way, you can see that for redistricting purposes, it doesn't really make sense to count them in a district where they're not voting. They're not able to vote, qualified to vote. So determining residency is sometimes a tricky problem, but I think the most sensible way to do it is to count them where they last resided, honestly. And that can be a very long time, you're right. But most of the time it is not.
Through you, Madam Chairman, thank you for that answer, Madam Secretary. I mean, I appreciate that opinion. The more questions I come up with, the less I agree with, though, unfortunately, because I just think, many people that are incarcerated in our state penitentiary system came from another state, for example. So we can't even count them as a resident of another town. And it just, you start asking many more questions and it leads to even more. But I look forward to working with my colleagues and hopefully coming up with a proper solution that is fair. And the final comment I want to just make to you today is your final conversation with Representative Master Francesco about folks that are on parole. I mean, to me, it was clear that you just disagree about the parameters of whether or not someone has paid their debt to society. And I just wanted to make that clear that we respect your position completely. And ours is just different. I look at it like when you are sentenced to punishment for a crime, and that punishment could be a lot of things. It could be time in prison or it could be a fine. And parole to me is a part of that because you are being let out of prison on parole, but you are still in the custody of the prison system, even though they're not holding you. So to me, you're still paying your debt to society. To me, that's a much brighter line. I didn't really like the way that conversation went. I just wanted to make sure that you understood we respect your position and to clarify what both mine and Representative Master Francesco share that same view. And that's it, Madam Chairman. I'll leave it to the Madam Secretary if she wants to comment on that, but I'm done with my questions and thank you very much.
Thank you. Through you, Madam Chair. I agree, and thank you for clarifying, but I had the same impression. We just don't agree on where that line is. And for me, it's someone in the community. I'm thinking we ought to be encouraging their civic participation at that point. It's a difference of opinion. You're right. And I don't know if we'll resolve it, but I think she understood exactly my position, and I did understand hers. And I respect both. Thank you.
Thank you. Thank you, Senator. Next, we will hear from Representative Thomas.
Great. Thank you, Madam Chair. And I apologize. My earbud batteries have already died on speaker number 2. I just want to make sure you can hear me.
Yes.
Thank you for that. And thank you, Secretary Merrill, for being here. I have appreciated all the opinions that you have shared, many of which I share as well. But out of respect for the 96 other people waiting to testify, I won't rehash a lot of that, but I do have 2 super quick questions. On Bill HB 1017, with regard to automatic voter registration, that is an issue that I care very much about, so much so that I submitted my own bill on the topic. And I am just curious, your bill did not include some of the state agencies that I called out, such as the Department of Emergency Services and Public Protection, state colleges and universities, DSS, and a couple of others. I'm just curious, would you have any objection to broadening the agencies in this bill?
Oh, through you, Madam Chair, or yes, through you, Madam Chair. I see other people jumping in here. No, not at all. As a matter of fact, I think there was possibly an error in drafting where we did leave some of those out. We have submitted substitute language to net in all the agencies that should be involved. And of course, that goes right back to the NVRA. So this is the time we should be extending the reach of what we're doing, absolutely, to every agency that interacts with the public.
Absolutely, I appreciate that. The more money we can save and the easier we can make it for the residents of Connecticut, the better. And my second question relates to HB 6575. I so appreciate your office thinking about ways to do risk auditing, which, I hear again and again, like how can we make our elections tighter, safer? And this, to me, is exactly the type of thing we want to do. When I was reading the bill language, I did just have a curiosity. Do you feel that you have enough time to implement this pilot program so that if anything needs to change at the municipal level for the 2021 elections, that could be implemented?
Well, if you look at the bill, we are proposing simply a study, and we'd have these pilots for the 2021 election. And then I don't know if we'd have time to implement by 2022. I think we would, because my understanding is there are not a lot of equipment changes we would need for any of this. This is a statistical change rather than a real change in that sense. So I've been told, I don't know if Attorney Bromley has any comment on the timing of this. Ted, are you still with us? I hope. Because, I'm just taking advice from the field as to how we're going to do this. We'll recruit some towns to try it out for the 21 elections. But of course, they're very, very different than the statewide elections, both statistically and every other way. So I'm told that we would have time to get this in place, at least partially by 2022, if we start soon.
Thank you. And through you, Madam Chair, and my apologies for forgetting that technicality. I'm still new to this body. Yeah, Mike, I just didn't know if it required the way the municipalities report the data, if they would need to adopt any changes, but it sounds like either very minimal or not of concern.
Well, it is a very different system. Each town would be required to identify precincts where there were close votes anticipated and that sort of thing. So it would require quite a difference in what we're doing from what we're doing now. I think it would be a positive difference, but I guess we'd find out from the study. I suggested the other day that we do both what we're doing already and the risk limiting audits. Apparently that is not a good idea, I was told, because right now, we are doing, I think, a very good job with the audits. They've been very successful. Our tabulators have been 99.9% accurate over almost 20 years of us doing this. So, but I guess we'd find out. I understand that it would not be a huge change from what we're doing now. In other words, not a huge burden on the towns.
Great, that's wonderful to hear. I will stop there. Thank you so much for your time. Thank you, Madam Chair.
Thank you.
Thank you, Representative. Representative Maureen Bello.
Thank you, Chair Flexer. And thank you, Secretary Merrill, for being here today. I, along with Rep. Thomas, was one of the co-introducers of the AVR bill, so I'm happy to hear that additional departments will be included in that, because I was disappointed to see only the DMV in this version. My questions and comments really are regarding the raised bill 1017. And the way I'm reading it is that the language we're taking out of it is, it says a drop box is located outside a building other than the building where the clerk's office is located. Arrange for the clerk or the clerk's designee to be escorted by a police officer. So when we remove that language, it appears then that the language does say on each weekday thereafter until the close of the polls, the municipal clerk shall retrieve from the secure drop box each such ballot deposited in it. So there does seem to be that chain of command specifically to the municipal clerk. Is that right?
Yes, that's correct. Yes.
And then my other question was, I know there was concern again about the chain of custody with these drop boxes, but it's of note that when we deposit a ballot or any mail for that matter into a USPS mailbox, there is also the question of whether somebody will tamper with it or something could happen to those boxes as well, given any evening or Sunday. So, I worked in the town clerk's office as an assistant town clerk for 10 years. I'm very familiar with the absentee ballot process, and I really commend you on all of the improvements we've seen, with the absentee ballots through the years. I started back in 1994 when we had, briefcases and adding machines and paper handwritten spreadsheets to what we have now with all of the computerization and sharing information digitally. And so I commend you for all of your work in those improvements that are allowing us to have more people, access absentee ballots.
Thank you so much for bringing this up. And you're absolutely right. The chain of custody is what it is now is very strong, and nothing about ballot boxes changes any of that. And it sounds like firsthand the kinds of protocols we have, the incredible system of checks and balances that we have now for absentee ballots. So thank you for pointing out those things from your firsthand perspective. I think it's really important that people know those things.
Thank you, Representative. Seeing no further questions or comments, thank you again for your testimony, Madam Secretary. And I will just say just a couple of quick housekeeping things on some of the dialogue you've had with my colleagues on this committee. I believe the committee has been informed that the cost for the drop boxes last year were $550,000 for the entire state, if that seems like an accurate number to you, Secretary Merrill.
Yep.
And that the laws that we passed last year required the clerks to check the drop boxes on a daily basis.
Correct.
That included the weekends.
Yes, that's correct.
Okay. I just
Good.
wanted to check that. So
Yes,
they're checked more frequently than the U.S. Postal Service
absolutely.
boxes that you
Yes.
think. Okay. Okay. And there was a municipal primary just the other day in Connecticut, correct? Secretary
Yes,
Merrill? So that just shows you how haphazard some of these election schedules can be. It was a Monday, not a Tuesday.
that's right. And I haven't heard yet what the turnout statistics were, but I'm sure they weren't very good because people get terribly confused by all the different dates and the times and the, we have referenda, we have, so that's why for years we have advocated for having all municipal elections on the November date. It's just much easier for voters. And I understand entirely the mentality of staying the same, land of steady habits and all that. But I think slowly towns are coming to that realization themselves. And I know we've had quite a few of them that have gone to November elections in the last couple of years. So I think it'll probably continue, but I'd like to facilitate it.
Great. Well, thank you again for your testimony today, and we look forward to working with you in the weeks and months to come.
Thank you so much. Thanks to all of the committee.
That more than concludes our first hour of hearing from public officials. So now I am going to begin calling on members of the public for that portion of our testimony today. And I'm going to call first on Hannah Leahy. Welcome, Hannah. The floor is yours.
Chairperson Flexer, Chairperson Fox, and members of the Government Administration and Elections Committee. My name is Hannah Leahy, and I'm here to testify in support of Senate Bill number 760, an act prohibiting publication of an image or a video of a fatal accident until a family or household member has been notified. On May 23rd, 2019, I had just put my phone away to get into bed when I got a text from my little brother's best friend. He had seen a picture online of a fatal car accident near Yukon where they both went to school. He was nervous because the description matched the car my brother and I shared, and he couldn't get a hold of him, so he asked me to call my parents to see if my brother was home. Instead, not wanting to worry my parents, I Googled the article that he was referencing and was met with a clear photo of the accident where I could see the car and the license plate. I knew it was my car, and I knew my brother was the fatality in the accident. I panicked, sitting 2 hours away in Boston with my boyfriend Dave, trying to figure out what to do next. I tried calling the state police, Yukon police, tried calling my brother countless times, and nothing happened. I called my dad's cell phone once in case he was still awake, but wasn't sure if I should call the home phone and wake or worry my parents. I went back and forth with the idea for 30 minutes, all while continuously calling and texting my brother and looking at the news articles online, desperately hoping to find something in the car that would make me believe it wasn't him. As I continued to look, I continued to study the picture online, and nothing could convince me it wasn't my car. Then my phone rang, and it was my dad. I stood up and answered the phone, and before my dad could get a word out, I just said, "Is it him?" To which my dad choked out a yes. I dropped the phone to the floor, followed shortly by falling myself. Dave had to pick up the phone, talk to my parents, and then call Tommy's best friend so that he heard the news directly from us, knowing that this idea was already coming. I've told this story more times than I can remember. Every time I tell it, I'm met with the same reaction. People can't believe it. How could that happen? Who would publish that? Why would they publish that? Unfortunately, I don't have the answers. One thing I do know is that allowing the publishing of this information is dangerous and traumatizing. I was lucky to have someone by my side trying to speak in whatever rational terms he could at the time, but had a call from my dad not come when it did, we would have been in the car on a 2-hour ride home to find out for ourselves. Losing a loved one is hard. I'm not here to say that I wouldn't have been just as upset about losing my brother if I'd found out a different way, but I am here to say that it could have been less traumatic for me. My younger brother was my favorite person in the world, and as his big sister, I always felt my role was to protect him. I shouldn't have had to learn from his death, from an article online, and a photo that led me to no other conclusion. It was incredibly traumatic. I still have flashbacks to that night, sitting on my bed, listening to Dave try to convince me that he couldn't read the license plate, so we wouldn't know anything. Perhaps that is what the person who posted that picture thought as well, that nothing in the photo revealed the identity of the accident victim, but that's not an excuse. There is never and will never be a reason to post that kind of information until you are certain that the family has been informed. In fact, the only people who would recognize the car were the very people most impacted, because whoever posted that picture and wrote that article ensured that Tommy's sister, some of his best friends, and his family spent their night being absolutely terrified before having to also deal with the grief of losing their best friend. I asked for this bill to be filed with the hopes that you can prevent this from happening to another parent, sibling, or friend who is about to deal with the unthinkable. I'm just asking for a little compassion. Thank you for the opportunity to testify today.
Hannah, thank you so much for your testimony today and for very bravely sharing this incredibly horrible story that your family had to endure. I want to thank you for your advocacy since this happened to prevent other people in our state to having to face similar circumstances when faced with such a terrible tragedy. We're all so sorry for the loss of your brother. And I know how difficult to some, as best as anyone can, that this has been for your family, but kudos to you for trying to turn this into something, you know, where you're ensuring that someone else doesn't have to endure this in the future and trying to raise attention to how, you know, something that might seem small to someone else had this dramatic effect in your experience in this terrible tragedy. I just cannot thank you enough for your advocacy over the last almost 2 years on this issue, and just incredibly brave of you to share your story with us today. Are there questions or comments from members of the committee? Representative McCarthy-Vahey.
Thank you, Madam Chair. And Madam Chair, I just wanted to echo what you said, Hannah. There you are. I'm looking for you on the screen. I just want to thank you for coming out and just speaking to this issue, and your courage and your bravery in doing so is really tremendous, especially in the face of the trauma and the loss that you and your family have faced. And I think it's so important, this issue at this point in time in the digital world where everything does happen so quickly. And sometimes, you know, all of us, certainly in the legislature, we're now kind of conditioned with our phones and texts and messages and everything, and media is in the same boat in terms of things moving so quickly. And sometimes we really need to stop and think about what the impact is going to be, as you said, on the people most affected. So thank you for bringing this to our attention, to helping to raise the issue, and to sharing your pain and experience so that other people don't have to go through the same kind of suffering. Thank you, Madam Chair.
Thank you.
Thank you, Representative. Are there other questions or comments from members of the committee? Again, Hannah, I really just can't thank you and your whole family enough. I've had the opportunity to speak with your father a few times about this, and I think he's going to testify next, but hopefully one of the good things that could come from this conversation is that when anyone is faced with an opportunity to publish the kind of photos that you had to see, that they'll really think twice about it, whether they're a member of the media or a first responder or a bystander who happens to be, you know, in a situation where they're witness to something like this, that they really think twice. I think oftentimes when these things happen, people have a desire to get as much information as possible out of general, you know, human nosiness or curiosity or whatever you want to call it. And there's not a real thought in this very quick modern age of the ramifications that you've outlined here so eloquently and so bravely this afternoon. So again, Hannah, thank you very much.
Thank you.
Next to testify is Jim Leahy. Is Jim Leahy with us? Madam Clerk, is Jim Leahy with us?
No, Madam Chair, he's not.
He's not here. Okay. Okay. Well, I hadn't looked at my list beyond that, so I will go back to the beginning. Just Madam Clerk, one more time. Is Jim with us?
Not yet.
Okay. Well, if Jim is not here, then I will rotate back and call on Noel Petra.
Good afternoon. Thank you all. Thank you, Senator Flexer, Representative Fox, Senator Sampson, and Representative Mastro Francesco. I appreciate you giving me time. I am here to testify in support of Senate Bill 1015 and against House Bill 6577. Again, my name is Noel Petra. I am the Deputy Commissioner at DAS for Real Estate and Construction. I brought with me 2 years ago 26 years of real estate and construction expertise from the private sector. And I am happy to be at the state helping to expedite and process all of our systems. Our goal at DAS right now is to maximize the efficiency and bring in as much private sector best practices and efficiencies as we possibly can. And to that note, Bill 1050 or 1015, I'm sorry, will do that. So if you guys have, I believe you have that in front of you, I'll just go through it as quickly as I can. Sections 1 through 3 make technical changes to what is called an updated bid statement. When we collect bids from contractors, they are required to give us an updated, basically it's a financial statement that verifies that they have the financial capacity to perform the work that they have on their plate, including the bid that we are attempting to award them. For some reason, the current legislation requires that we eliminate the low bidder if they don't automatically give us an updated bid statement or financial statement. It's very strict. And a couple of times in the last couple of years, we've had to skip the low most qualified bidder and go to the next lowest bidder, which has cost the state hundreds of thousands of dollars, all because of a clerical mistake. So this is not a big deal. We're just trying to give ourselves the flexibility to give them, 2 days to submit the updated financial statement. It's really just giving them one more chance, and it doesn't hurt or put the state in jeopardy whatsoever. Any questions on that?
Mr. Petra, we will take questions at the end when you finish your testimony.
At the end? Okay, great. Section 4 streamlines the way that we surplus real property through DAS. That'll help us eliminate unnecessary carrying costs. Every month that we own and operate a building costs us, depending on the building, tens of thousands or hundreds of thousands of dollars. Right now, whenever we surplus a building, we offer it up to the town or the city that we're in, and we give them a chance to buy it. The statutes right now allow for 120 days for them to make that decision. But the reality is they don't need that much time. We give them lots of upfront notice, unofficial notice, so that by the time we give them the official notice, they've already really made their decision and they know whether they can afford it or whether they want it. So we'd like to reduce that to 60 days. That'll give us a chance to reduce our costs by at least 2 months, and it'll give us 2 additional months of putting that piece of property back on the tax rolls. Section 5. This gives DAS the ability to grant and receive easements from other governmental entities. Usually it's the state. Generally, these easements are necessary to allow towns to have right-of-ways for fire access, police access, sometimes utility access, that type of thing. And right now, we have to send this through the legislature for approval, and it obviously takes a while. Sometimes that slows down our projects, and we would like to be able to just do that within our own means and not take up your valuable time doing that. Section 6 and 7, this is to clarify the State Property and Review Board's scope of focus. Back in 1975, the Property Review Board was established to make sure that state agencies were complying with procurement policies and that we weren't handing out, sweetheart deals and, giving our friends really great projects. We have many checks and balances in place to make sure that this doesn't happen. And what's happened is we've come to loggerheads with SPRB because their legislation is very open-ended and very broad. It essentially gives them no limit to what they can ask for, what they can review, and what they can reject or not reject with no objective criteria. We're asking that we rewrite their legislation to refocus their efforts on ensuring that we are following the procurement laws and to make sure that we're giving everyone a fair shake at state contracts and state properties. The way that it's going right now, they're doing their best to do their job as well as they can, but their scope is growing. Their questions are increasing. We spend hundreds and hundreds of hours every year just at DAS explaining to them, basic construction contract law, explaining to them basic, 101 contract construction, best practices. These gentlemen work hard and they put in a lot of hours, but they don't have the expertise or the understanding or even the exposure to the projects as we're working on them to understand the complexities that we're working on. We get rejections for things and questions for things that have been resolved on our projects months and months and months, sometimes years ago. And it's very frustrating and very time consuming on our end to have to answer their increasingly detailed and minutia oriented questions. We would really like to focus them on the most important aspect and the reason why they were created, which is to make sure that we're following the procurement laws. In addition, we'd like to raise the threshold for when SPRB will review our construction, design contracts. It hasn't been updated for a long time, and we'd like to raise it to $500,000. We write hundreds of contracts every year just at DAS, let alone DOT and AG and everyone else that SPRB has to try to oversee. There's simply not enough time in the day for them to review all of these contracts and understand them. And again, they really lack the expertise to get into the details that they'd like to. So we'd like to focus them on the larger contracts and focus on making sure that the larger contracts are compliant with statutes for procurement. The next section 8 gives DAS authority over integrated works of art. So what is an integrated work of art? It could be a large fountain or a large statue, or it's basically a work of art that we put into one of our state buildings that's actually integrated into the building itself. The way it works right now is DECD procures the art, and typically they do it after the fact. So if we were to put in a fountain that required structural work and electricity and plumbing and drainage, we need to include that in the architectural design up front so that we're not trying to retrofit the building to accommodate the artwork. Now, we believe fully in the value of art. We just need to make sure that it's designed within the architecture. If we give the architect a chance to integrate the artwork into the design, we could actually benefit the artwork by designing some of the building around it. So this is just basically taking the responsibility from DECD and giving it to DAS for that integrated architectural artwork. The remaining artwork, such as a painting or a sculpture that doesn't need structural work, that's still going to be managed by DECD. We have no interest in that. We're already very busy. And section 9 simply identifies the changes that need to make section 8 work. So thank you all for raising that bill, and I'm happy to answer any questions on that bill.
Thank you. Thank you for your testimony. Representative Fox.
Thank you, Madam Chair. Thank you, sir, for being with us today. Appreciate your time here today.
Of course.
I just had a few questions, if I can, about there's two bills before us that are in conflict, but I think you acknowledge the bill addressing the SPRB. I just wanted to kind of flesh out some of the SPRB language in both those bills if I can. I guess from your perspective, would SPRB be an arm of the legislature or the executive branch?
SPRB is currently in the executive branch.
Correct. And I'm just trying to, it seems as though do you see there being a role for SPRB, or it seems like the I'm just trying to get a better handle on your testimony today.
Absolutely. The intended purpose of SPRB continues to be valid and important to the taxpayers. We need someone to be looking over our shoulder and making sure that we actually do follow the procurement laws. I mean, we've all been through that a few administrations ago. We don't want to see a repeat of that type of behavior. So we strongly support the original intention and role of SPRB, and we'd like to see it continue. Absolutely. But we'd like it to be focused on its original goal, which is to make sure that we follow the procurement laws.
And in your opinion, is that they've gone beyond that authority?
So far, they're at the point right now where they ask us to review requisitions for construction projects. They give us responses that say, we'll deny this unless you change the terms. They don't like leases because of certain terms in the leases that are typical commercial real estate terms. They're getting into, I mean, the ultimate minutia of what we're doing, questioning what we're doing and dictating how we're going to make decisions. They lack the expertise to do that. It's plain and simple. I mean, they don't have the expertise on that board to understand, and they shouldn't. They're not, I mean, how could they possibly? It takes an entire career to develop the understanding and expertise for just construction contracts alone, let alone adding commercial real estate in that. And then when you add it to how does DOT apply the law? How does DOT contracts work? And then ag contracts, it's incredibly complex. And they don't have any legal counsel. They don't have legal expertise. And I don't know how we could adequately give them that expertise, but still they're diving into our contracts and they're making decisions on our decisions that are costing the state money. It's frustrating, I have to say, to watch. It's frustrating for my team. It's frustrating for my partners at DOT and the other agencies. And you know, we don't hold a grudge against them. They legitimately think that that's their role and they're trying to do it to their best ability. The problem is basically what they're doing. These are outside consultants. They're paid consultants. The more that they review, the more that they get paid. And the deeper and deeper they get into our decisions, the more they're second guessing and trying to take over, you know, the responsibilities of trusted state employees. My rank and file people are very frustrated. My legal team is extremely frustrated because we spend, again, hundreds of hours explaining to them, you know, basic legal concepts that they just don't understand. And they don't take the time to read the contracts and understand the contracts. I'll give you an example. A construction management contract is integrated with the architect's contract, the engineer's contract, and then a whole bunch of those terms carry down through the subcontractor and supplier's contracts. There is no way that these gentlemen could possibly understand that legal complexity. I have an entire legal team just for my department so that we don't make mistakes. And every time we work on a contract, it starts with our project managers. It goes to our construction legal team. Once it goes from the construction legal team, it goes to SPRB, and then it goes to me. And then ultimately the AG reviews every single contract in detail, and they have the final word of approval. So we don't lack checks and balances by any means. We have multiple levels of checks and balances. We don't need an extra level of detail that it gets extremely slow and tedious.
Okay. Just back to the section on the SPRB. The only reason I'm focusing on this is that the two bills before the committee, both of which go in opposite directions. Just kind of to hammer out the differences between these two standards. In section 6, 1015, the inclusion of the word commercial. You touched upon it in your testimony. Can you just focus on why DS want to focus on commercial experience rather than a more broad experience?
Well, commercial real estate is commercial real estate. You know, the state of Connecticut doesn't work in residential real estate. We don't sell or buy houses. I mean, we might, but we do it for commercial purposes. Having a residential realtor on a board doesn't really help us negotiate a complex commercial real estate deal. It's simply not relevant. I mean, there are some similarities, but the reality is they're completely different industries. If you went to look at any real estate company, you would see they have brokers for commercial and they have realtors for residential. They're very different animals. I mean, we would really like them to have expertise on the board that understands contract law, that understands construction best practices and typical construction practices. We'd like them to have, real estate brokers or even better, lawyers that are real estate land use attorneys. That's the expertise that it takes to oversee what we're doing.
Okay. Then just moving on. For how long have you been with the Mr. Pitcher? I'm sorry.
I just passed 2 years.
And as the SPRB, I don't want to identify attention, but has attention been there? The 2 years have been there before then? Is it?
So when I first got to DAS, one of the first thing everybody complained about was SPRB because they're the watchdog. And I thought, ooh, this is great. This is the whole purpose of why I came to the state, was to make sure we were watching people and getting things done efficiently. So I embraced SPRB's role, and I went down and I met them and we got along great. But then as time went on, even my own decisions were being questioned by them. And instead of picking up the phone and asking me, they run it through all this paperwork and stop what we're doing. And I started seeing my projects being slowed down. I started watching my legal team spend a good portion of their day explaining basic concepts and trying to justify decisions that we've made. All of this is after the fact anyway. And so we haven't had any obvious tension, but there's obvious frustration on our end. I'm sure there's some on their end as well. And then the AG, SPRB took it on themselves to ask the AG, which was a good move, to clarify what their legislation says. And the AG responded with, this legislation basically gives them a really broad purview. They can basically ask anything they want. The legislation, and then the AG commented that the legislation is overly broad and it needs to be defined. So that's what we're trying to do.
You're referring to 6577, sir? When you say the legislation?
This is the original legislation.
Okay.
And we can get you a copy of the AG's report on that if you'd like it.
Well, that'd be helpful. And I just think quickly the phrase in section, I think section 6 is section 6 or 7. There's one reference to a standard of objective evidence, I believe.
Objective criteria.
Yeah, correct. That's correct. Can you just expand for me a little bit of what you mean by that? I mean, I always get a little nervous when I see objective criteria. It's kind of the moving target in a way.
So objective criteria is something that doesn't require an opinion. Objective criteria is checking the box. This is included, that's included. They complied with this statute or this policy by doing X, Y, and Z. It's not, I don't think I like those terms because they just don't make sense to me. I'll give you an example. We had an issue where they rejected an additional service contract with one of our engineers who was doing a design build contract because the board did not think that the contract allowed for any additional change orders, which had absolutely no legal bearing whatsoever. So we had no choice but to tell the engineer that we couldn't pay them the extra money because they found things underground that weren't identified in the bid documents. SPRB would not change their mind. And so the contractor had no choice but to go to file a claim. And now it's with the AG. So we spent many, many hours working on this. SPRB spent many, many hours working on this. And now the AG is going to be working on this. This is not a subjective decision. There's a contract that has objective criteria. If this happens, then this. It's not a matter of, well, I don't like that term. It's not I feel that this should be something else. It's a matter of, I read the contract and understand that this is exactly how this will work. So when I say objective criteria, I mean very specifically, you have to check the boxes and it's not up to your personal feelings or what you'd like it to be. Does that make sense? Did I answer your question?
I think so, yeah. So should the board review the scope of work of the consultant, do you think, or?
No, I don't think so. They don't have the technical expertise to do that.
Okay.
How could they? I mean, I'm not faulting them. I don't know how they would ever be able to do that.
Okay.
They can certainly make sure that we followed all the requirements that we have to make sure that when we hired that consultant, everyone else had the same opportunity that they did. and that we hired them based on their qualifications and then their proposal, their fee proposal. That's very objective. That's an easy thing to follow. But to come back to us later and say, I don't think that was the right amount of fee, or I don't like the scope of work, I think they should be doing it. I mean, how could they ever have the expertise to do that? It takes us months and sometimes years to develop a project scope. And all of a sudden they're going to read it in a couple of weeks and understand that we made a mistake, or it should be done a different way. It's just not realistic.
Okay. So with that in mind, I don't mean to be repetitive, but then how then, I guess it gets back to your idea of what they should be looking at in a sense, because if they, from that, the comment you just made, they should be more just a one-stop review shop. Just check, and then we're done. There should be there's little role for them. I'm just trying to get to the point of what it is you're looking for. Basically, this legislation before me is pretty much, it confines with what SPRB can do in so many respects.
Right.
It changes the threshold to objective evidence. It changes the type of contract they can review to commercial contracts. It changes the money thresholds. I mean, you really kind of cut the legs out in many respects. I'm just trying to get, I mean, you're just trying to, I think, significantly reduce the scope and role of this SPRB. I'm just trying to get a better handle on that. If that makes sense.
I'm trying to, it's not just me, it's everyone. There are multiple agencies doing this together. We want to focus them on what their intended purpose was. And their intended purpose was to make sure that we're not giving out sweetheart deals to our friends. And that's why they were created. Their goal is, like any other consultant, to grow their scope, to grow their authority, to increase their payments, and in effect, what they're doing is they're stepping in and they're dictating the decisions that state employees are making. They're essentially asserting their authority to do the job of the employees. And how can we allow that to happen, especially when they don't have the expertise? I'm not trying to take the legs out. I'm trying to take legislation that was written extremely broadly with all good intentions and focus it to what it was intended to do.
Okay. Just one final question, sir. On the other change that the SPRB on this is increasing the threshold to $500,000. Do you know, just for my edification, how many contracts would that apply to? Like, are there currently, are there how many currently submitted, and how many would be submitted if this were made law? Just trying to get a handle on it.
I don't know that offhand, but I can get that for you.
Do you know, would it be 100 contracts down to 2? Would it be 50 down to 40? Would it be any just general idea?
I would say it would cut it. I don't, honestly, I don't know. I'd have to look. And we'd be willing to work on that number. That's fine. I mean,
okay. Great. Well, thank you for your time today, sir. Appreciate you being here.
Sure. Thank you for your questions.
Thank you. Are there other questions or comments from members of the committee? Seeing none, thank you again for your testimony.
Great, thank you. Would you like me to continue with Bill 6577? I can do it much more quickly since we've already covered part of it.
Oh, Mr. Petra, I thought you had given us all of your testimony before I called on the good representative for his questions.
That's all. You know what? We kind of covered them both. They're related.
Okay, well, just so for your future reference, we usually have people say all they're going to say, if you will, and then open it up for questions.
I think I've covered it.
Okay, well, thank you again for your testimony. We look forward to working with you in the coming weeks.
All right, thank you so much.
Thank you.
Take care.
Next, we will go back to the public list, and Jim Leahy has joined us. Welcome, Jim. The floor is yours.
Thank you, Chairperson Flexer. Sorry about the technical difficulties earlier. I was on the public link and not the speaker link. Chairperson Flexer, Chairperson Fox, and members of the committee, my name is Jim Leahy. I'm here to testify in support of Senate Bill 760. As many of you know, I've been a lobbyist here for more than 30 years. I can't count the number of times that I've testified in committees like this. That experience has provided me the wisdom to not even try to compete with my daughter's testimony from earlier. As you can imagine, I'm incredibly proud of her and amazed by her strength and courage. The bill is before the committee today because of her. I've submitted written testimony and just want to make a couple points here. As a parent, my heart broke twice that night. First, when I learned that my son had not survived the crash, and again when I spoke to Hannah. I wasn't able to protect either of my children that night, and it will live with me forever. I understand there's no good way to learn that a brother, or a sister, a son, or a daughter, you name it, has died in a tragic accident. But I hope we can all agree that some ways just shouldn't happen. You know, I'm the former executive director of the Connecticut Daily Newspapers Association, and I'm an ardent advocate of the First Amendment. There's no news value in that photograph, or even most of the details of the story. The details that caused Hannah pain that night and Tommy's friends pain that night would go unnoticed to most people. The only people that know those details are the ones that really shouldn't find out online. The only actionable news was there was a really bad accident on Route 195 in Mansfield. People should stay away so the emergency people can do their work. The rest of the details could have waited until folks were notified in a more compassionate, humane manner. So I really want to thank the committee for raising this bill. This coming May will be 2 years since the accident. Hannah is committed to making sure nobody has to go through what she went through, and I will fight with her to try to make that happen. So thank you for your attention.
Thank you, Jim. Thank you for your testimony, and thank you to your whole family for your dedication. Obviously, this doesn't, this conversation or any initiative isn't going to take away the pain that your family endured, but your whole family is to be greatly admired for trying to take what you did endure and make change so that no one else has to face those same sorts of circumstances. And I can't thank you enough. Are there questions from members of the committee? Well, let me just say one other thing or two other things. First of all, I regret that I forgot to express to Hannah, and I'll express it to you and to Hannah in this conversation, my deep sympathy for the passing of your son. I'm very sorry for the loss your family's had to endure. And in your testimony, you just referenced that you had formerly been the executive director of the Connecticut Daily Newspaper Association. So I know that as we consider the bill before us, there's a lot of complications in terms of how you actually legislate this. So I'd ask you, given your work with that organization previously, you know, how can we work to make this a best practice, right? Perhaps a law isn't the best way to get this across, but how can we work to make this a best practice across news organizations, first responder agencies, bystanders, that sort of thing, so people get the point that you made, that getting people to avoid traveling where something like this is happening is important, but knowing every little detail before the people whose lives are going to be altered forever know is unnecessary.
You know, it's interesting because I've obviously had a lot of conversations about this. Had a very interesting conversation with one of the Connecticut TV stations this morning. And no reputable news organization would ever publish the name of a victim until it had been released by the police. But putting a photo up that has a license plate is doing virtually the same thing. And whether the public hearing focuses attention on that and we have these conversations, I am hopeful that we'll have these conversations over the next several months. I agree with you. Sometimes the law is the right thing and sometimes it's not the right thing, but maybe it's what we need to get someone's attention. The standard in this really is kind of compassion and humanity and not just the race for clicks online. Because that's really what happens. If you look at the photo, and it's on my Facebook page from that night, if the cameraman had stood 4 feet to the right, the photo would have been of the police car. And that would have been fine. It was clearly an accident. You wouldn't have seen what make or model the car was, and you wouldn't have seen the license plate. It wouldn't have made the next day any better for us, but it would have, it would have made Hannah's experience over those few hours different. She fortunately is someone who has turned that pain and channeled it into energy. But I'm fearful if she was by herself that night, she would have gotten in the car and tried to drive home from Boston, and that puts her at risk. And that's not okay. So I will continue to have those conversations. I will, I'm a dad. I'll do whatever I can to try to get my daughter what she wants. And what she wants is for people not to experience that. however we do it.
Thank you. Thank you, Jim.
Thank you,
Again,
Senator.
thank you very much for your advocacy and your brave testimony today. And we look forward to working with you to try to make that a reality, that no one has to experience what your family experienced again.
Thank you, Senator.
Thank you. Now we'll return to the public official list. Next, we will hear from Peter Lewandowski. And after Peter, we will hear from Kelly Moore and Tanya Rhodes Smith. Peter, the floor is yours. Welcome.
Thank you, Senator Flexer. Good afternoon, Representative Fox, Senator Sampson, Representative Mastro Francesco, and distinguished committee members. My name is Peter Lewandowski. I'm the Executive Director of the Office of State Ethics. Thank you for this opportunity to provide testimony in support of two raised bills that contain legislative proposals presented by the Office of State Ethics. I've submitted written testimony on the two bills, and I will summarize it here. First, I'd like to say a few words in support of Senate Bill 1016, an act concerning municipal ethics. This bill requires all municipalities to adopt and maintain a code of ethics no later than October 1, 2022. The provisions in this bill originally stem from the work performed by the Citizens Ethics Advisory Board Subcommittee on Municipal Ethics. The subcommittee, in consultation with Connecticut Conference of Municipalities and Connecticut Council of Small Towns, determined that at this time, the best approach concerning municipal ethics is to require all municipalities in Connecticut to have a code of ethics. This bill reflects a compromise language reached between the Office of State Ethics, CCM, and COST. And I'd like to thank both organizations for working with the Office of State Ethics on the current language and for submitting testimony regarding this bill. The language of this bill passed in the Senate on consent during the 2019 legislative session. Important note here that I'd like to make is that this bill makes it clear that any municipality that has adopted a code of ethics prior to January 1, 2022, and most of them already have, are not required to adopt a new code of ethics. Such municipalities will only be required to certify that they have a code of ethics in place and supply a copy of their code to the Office of State Ethics. Those municipalities that do not have an existing code of ethics may either adopt their own code or adopt a model code to be developed by the Office of State Ethics in consultation with CCM and COST. In any event, it is up to each municipality to adopt an ethics code that fits their particular need. Municipalities may utilize some, if not all, of the provisions the model code that the model code will have, and the OSC is required to develop the model code no later than January 1, 2022. It is the firm belief of the Office of State Ethics and the Citizens Ethics Advisory Board that the residents of Connecticut towns and cities are entitled to have a government whose officials and employees uphold the highest ethical standards and who are provided with clear and basic guidelines to help them uphold such standards. The Office of State Ethics and the Citizens Ethics Advisory Board encourage the GAE committee to support this bill. The second bill that I'd like to bring to your attention is House Bill 6574, an act concerning revisions to the state codes of ethics. This bill contains numerous key revisions to the state code of codes of ethics, and I want to just highlight a few of them. The bill provides for a statutory definition of confidential information under the Code of Ethics, which is currently defined in agency regulations. The inclusion of the term under statutory definitions will provide consistent application of the term to all sections of the code and make the term more prominent and easily accessible to the regulated community. When we brought this proposal to the GAE committee during the 2019 legislative session, the Office of State Ethics proposed a modification to the definition following our discussions with the Freedom of Information Commission. Due to an inadvertent inclusion of our originally proposed definition, the Office of State Ethics requests that the definition be modified as requested in 2019. The proposed modified language to which both Office of State Ethics and Freedom of Information Commission have agreed, is noted in my written testimony. The bill also amends certain revolving door provisions under the Code of Ethics by requiring enumerated agencies to submit an annual designation statement to the Office of State Ethics for certain positions with significant decision-making or supervisory responsibility. Currently, these designated positions are submitted through regulations, which means that at any time a designated position changes, the regulations would need to be amended. The process to amend regulations takes considerable time, meaning that the list is not necessarily accurate or up to date. The proposed amendment seeks to ensure compliance with the revolving door provisions by requiring annual designation of such positions. Those designated positions will be published on the Office of State Ethics website. And finally, the Office of State Ethics is also proposing to amend Section 1-83 of the General Statutes to require an electronic filing of the statements of financial interests. Most of our filings are electronic, and actually in 2020, out of the 2,525 required filers, only 42 filers filed the paper version of the statement. So we would like to move to electronic, completely electronic version of the SFI with this proposal. There are other proposals, but again, they are noted in my written testimony, and I will stop here and thank you for your consideration of our agency proposals, and I'll be happy to answer any questions you may have.
Thank you. Thank you for your testimony. Are there questions or comments from members of the committee? Representative Fox.
Thank you, Madam Chair, and thank you, Ms. Ludesk, for being here today. Just two quick questions. One, well, on the beach bill, the first bill, municipal ethics bill, it sounds like that bill was kind of more or less been hashed out, agreed to by all interested parties at this point in time. Yes, we've CCM, COST, and OSC have agreed to this language. That's in the bill. And of the 169 towns in the state, how many do not currently have a code of ethics? Do you know? Thank you for this question. Actually, out of the 169, we are estimating between 20 and 30 towns that do not have anything in place. Both the Office of State Ethics and CCM during the last 2 years conducted surveys of all towns. OSC conducted in 2018, I believe CCM conducted in 2019. And at that time, I think the figure was around 26 or 27 that do not have anything in place. And interestingly, a number of towns already contacted us and expressing interest in adopting a code of ethics, knowing that most of their counterparts, most of the towns in the state already have a working code of ethics. Right, because if I recall from the discussion in 2019, towns' concerns were that, if what works in one town may not work in another town. One town in certain departments, just because nepotism, there might be the son of might have an uncle or a cousin, or there might be interrelated to a small dynamics of the town might dictate that. And was that your recollection as well? Yes. So, and actually, we're very cognizant. Those were part of our conversations and concerns. The Citizens Ethics Advisory Board is very much cognizant of that concern, and that's why the bill has the language that allows the municipalities to be in the driver's seat. Mm-hmm. They will be responsible for creating their own code of ethics, recognizing their own needs, whether they're mid-sized town or a tiny municipality. And determine and create the code of ethics that is responsive to those needs. Okay. And just on the other bill before us from your agency, can you please touch upon the revolving door changes? Sure. So right now, under the revolving door provision, certain regulatory agencies are required to submit designations of certain key positions within their agencies that have supervisory authority or significant decision-making authority, and the revolving door provisions specifically prohibit those positions, those employees from pursuing, negotiating, seeking, or accepting employment with the industry they regulate for a specific period of time, whether it's 1 year in certain circumstances or 2 years in for example, in situations involving those folks who regulate gaming industry. Again, I think the process of designation is somewhat cumbersome. By having, providing this list through regulations, and as you know, modifying regulations or changing regulations is more time involved process. And I think to provide a more up-to-date, more responsive listing for everyone, for the folks who are regulated, who are subject to this provision, and for us to determine, to provide advice, I think the better way will be to have those agencies that are subject to the statutory provision to submit an annual listing to our office, indicating who's subject to that provision. Okay. Thank you for your time and testimony today. I appreciate being here, sir. Thank you. Thank you.
Thank you, Representative. Representative McCarthy-Vahey.
Thank you, Madam Chair, and thank you, Mr. Lewandowski, for being here with us and for your work in the Office of State Ethics. Just a question in terms of the municipal codes of ethics. It's really wonderful to know that so many of our municipalities and only a small group have them and only a small group do not. In the creation of the model code, is there any requirement that a town that already has an existing code of ethic needs to review their code and kind of pair it up next to that model code to make sure that it's sufficient in what it has in place already?
Thank you for this question. No, there's no requirement that they would have to modify their existing codes to make it consistent or responsive to the model code. It's their option. I mean, obviously, if a locality, if a municipality determines that, well, this provision in model code would be appropriate for us, then absolutely it's their choice, but it would not be required.
And I thank you for that answer and for working so diligently with the various organizations to come to consensus on this matter. Thank you very much, Madam Chair.
Thank you.
Thank you, Representative. Are there other questions or comments from members of the committee? Seeing no other hands raised, thank you, and thank you again for your testimony.
Thank you.
Next is Kelly Moore, who will be followed by Tanya Rhodes Smith, who will be followed by Commissioner Brian Hurlbert. Kelly, welcome. The floor is yours.
Thank you so much. Chairpersons Flexer and Fox, distinguished members of this committee. My name is Kelly Moore. I'm the interim senior policy counsel for the ACLU of Connecticut. I'm here to testify in support of Senate Bill 753 on ending prison gerrymandering and in support of House Bills 6578 and 5318, restoring the right to vote to people on parole. First, we support Senate Bill 753 and ending prison gerrymandering. A free and fair voting system upholds the foundational cornerstone of our democracy, the right to vote. The current practice of counting incarcerated Connecticut residents as residents of the towns where they are caged, known as prison gerrymandering, is fundamentally undemocratic, and we need the change proposed in this bill. First, the practice of prison gerrymandering hurts incarcerated people by undermining their dignity and identities and also depriving them of real political representation. Secondly, prison gerrymandering harms the communities where incarcerated people live. In Connecticut, almost half of incarcerated people are from the cities of Bridgeport, Hartford, New Haven, Stamford, and Waterbury, and will often return to those communities after they are free. Those people there, though, are not counted as residents of those cities if they are incarcerated during the census. This undercounting of those communities leads to each person in those communities having a vote that counts less and fewer resources to share among more people relative to correctly counted districts. Conversely, the majority white towns where Connecticut's prisons are located benefit from vote and resource inflation and a direct transfer of political power and resources from communities of color to mostly white areas. Prison gerrymandering is a serious injustice, and it's critical to solve this problem now with redistricting occurring later in the year. If you do not pass this bill this year, Connecticut's districts will continue to be gerrymandered for the next decade. The ACLU of Connecticut strongly supports Senate Bill 753 and urges this committee to also support it. I'll turn now to the bills restoring voting rights for people on parole. The right to vote is a fundamental part of America's democracy, as I said, but the modern practice of felony disenfranchisement is a Jim Crow era relic created by white lawmakers to explicitly target Black Americans in many parts of the country and diminish their electoral strength. It's time to end this practice. House Bill 6578 is the best version of the bill before you today because it removes the requirement that people pay all court fees before getting their rights back. Removing this provision ensures Connecticut does not just substitute one Jim Crow era voter suppression method, felony disenfranchisement, for another, poll taxes. By passing this bill, Connecticut would join Massachusetts, Rhode Island, New Hampshire, and 15 other states. Mass incarceration combined with disenfranchisement undermines democracy, particularly for communities of color. Restoring the right to vote for people on parole is one important way to reduce the harms of mass incarceration. We urge this committee to support voting for people on parole without requiring a poll tax. Thank you.
Thank you. Thank you for your testimony. Are there questions from members of the committee? Senator Haskell, the floor is yours.
Thank you so much, Madam Chair. And Kelly, it's great to see you today. I just wanted to ask, and thank you so much for your time and for your testimony. I wanted to ask a brief follow-up on what you believe might be the impact of the disenfranchisement of individuals on parole. It seems in other states that re-enfranchising those who are on parole actually sort of promotes greater civic engagement and perhaps even reduces recidivism. Is that something that you believe might be one possible impact from this legislation?
Absolutely. I completely agree with you, Senator Haskell. And I almost hesitate to say more because you encapsulated it so perfectly. When people on parole are given their rights back, it leads them to be more active members of the community. And we think that when people are given full opportunities to participate in civic life, both through restoration of their constitutional voting rights, but also through opportunities at employment and housing, education, that is a way to make all of our communities safer by reducing recidivism and really building up strong communities that take care of each other.
Well, thanks so much for your advocacy, and I look forward to supporting this legislation. Thanks, Madam Chair.
Thank you, Senator. Are there other questions from members of the committee? Seeing none, thank you again for your testimony. Thank you. Based on attendance thus far at today's hearing, I believe the next person we'll be hearing from is Commissioner Brian Hurlburt. Commissioner Hurlburt will be followed by John Murphy and then Patricia Rossi.
Good afternoon, members of the committee, Senator Flex, Representative Fox, Senator Sampson, Representative Master Francesco, and the honorable members. Thank you for the opportunity to testify today on House Bill 6577 and that concerning the State Properties Review Board. For the record, my name is Brian Hurlburt and I'm the Commissioner of the Connecticut Department of Agriculture. I have submitted written testimony on this bill, which I'll highlight from, but I do want to share upfront that I support many of the comments that Deputy Commissioner Petra made earlier today during his testimony. House Bill 6577 would expand the purview of the State Properties Review Board to include the approval of the Community Farms Preservation Program applications. The Department of Agriculture regularly submits applications to SPRB for approval of farmland preservation applications, which are different than the community farm applications. And just for the committee's awareness, in 2020, the department protected 13 farms totaling over 1,000 acres across the state. The current process that the SPRB has over our farmland preservation program has created unnecessary delays and a significant backlog in our ability to preserve farms across the state. Extending their approval to the community farms program would further delay the completion of these transactions and impede our ability to preserve additional farmland in Connecticut. In order to fund farmland preservation transactions, the department has been able to extend our state investment through better leveraging of federal and partner contributions. So the committee is aware in fiscal year 2020, the state share of the investments on those 13 farms was 52% of the total investment. The USDA contributed 39% and local partners contributed 9%. This investment from the USDA comes with the requirements of the federal program, which includes the review and acceptance of the value and designation of the soils, the appraisal, and the restrictions on future buildings. And I just want to point out that that's a very tight program with a lot of very stringent requirements regarding the approval process to be eligible for those federal funds. In 2015, on the final revised report from the subcommittee on the Farmland Preservation Program's best practices memo from the Farmland Preservation Advisory Board, a board that sits administratively within the Department of Agriculture, the memo includes the following statements on SPRB's ability back in 2015 on the Farmland Preservation Program. And I'll quote, "The review by the State Properties Review Board is of questionable benefit for the state, given the amount of scrutiny provided by the department staff and its management of deals and through the multiple reviews of the Attorney General's office. Notably, the SPRB review is not required for the acquisition of conservation easements through the state's open space and watershed land acquisition grant programs administered by the Department of Energy and Environmental Protection." In summary, the department does not feel that it's in the best interest to the farmland preservation efforts in the state by expanding the approval authority of the State Properties Review Board. I thank everybody for the opportunity to testify against this bill. I'd be happy to answer questions from the committee members if they have any.
Thank you. Thank you, Commissioner. Thank you for your testimony. Are there questions or comments from members of the committee? Representative Fox.
Thank you, Senator. Good afternoon, Commissioner. Good to see you again.
Good to see you.
Just a quick question. Realizing you haven't been with, how long have you been Commissioner now? About 2 years?
2 years. 1 year COVID, 1 year pre.
Lucky you. Great timing. Just a quick question. You may not know the answer to this because you've only been Commissioner for 2 years, but any idea of the SPRB's role in the 2 years prior to you, or a few years prior to you, or has it been your sense that SPRB has suddenly taken on an expanded role over the past 2 years, or has it been longer than any? Just looking for some background information to begin.
It's thank you for the question, Representative. That's very important information for the committee to have. Prior to probably 2018, the program worked well. There was, and I think Deputy Commissioner Petra kind of relayed this, that applications went in, they were reviewed based on the information provided, understanding that there is internal review by the submitting agency. The facts were looked at and then moved forward. Now we have a lot more questions coming back, and questions that dive into the appraisal methodology that was used. And just to be honest, the staff at the State Properties Review Board doesn't have the appraisal authority or background that the appraisers that we have to use in farmland preservation have. There's questions about whether or not the amount of or the value of the crops on the property are accurately represented. These aren't questions that drive towards their ability to be an oversight agency, which we strongly support their role in. And they just delay the timeline and the application process from moving from a submission to approval. I will note that over the past few months, it has gotten a little bit better. So I'll say that I was actually fairly surprised to see that this bill was submitted again, and that there was an interest from some members to review it. I've had a number of conversations with the chair. We have better lines of communication that are open. And we have seen, especially in calendar year 2021, that our applications have been moving a little bit more smoothly through the process. There's been a lot less of that going back and forth in the pre-meeting stages of these applications than there were during 2020.
Great. Thank you very much for your testimony. Appreciate your time. And thank you very much for the past year on behalf of the state of Connecticut. Thank you.
Thank you, sir.
Thank you, Mr. Chair. Are there any other questions or comments from members of the committee? Seeing none, thank you again, Commissioner, for your testimony, and thanks for your innovative work over the last year in particular.
Well, thank you very much. Appreciate that. I'll pass it along to our staff at the agency.
Yeah, you guys are doing a great job.
Thank you.
Next, we will hear from John Murphy, who will be followed by Patricia Rossi, who will be followed by Representative Michael Winkler. John, the floor is yours. Welcome. Now, I know John was here. I see that he's here. Let's see. There we go. Welcome, John. The floor is yours. And after John, we will hear from Patricia Rossi.
Good afternoon, Senator Flexer, Representative Fox, Ranking Member Master Francesco, and members of the committee. My name is John Murphy and I live in East Hartford. On behalf of United Auto Workers Local 376 and the Connecticut Citizen Action Group, I'm testifying today in favor of House Bill 6578, an act concerning participation in the electoral process, Senate Bill 753, an act concerning the counting of incarcerated persons for purposes of determining legislative districts, and Senate Bill 1017, an act concerning election administration. All three of these bills are about increasing voter participation and voter confidence in democracy. House Bill 6578, Senate Bill 753 are about racial equity and justice. House Bill 6578 allows people on parole to vote. Parolees in Connecticut are overwhelmingly African-American and Latino. We believe that if you are not incarcerated, you should be able to vote. Formerly incarcerated people have a hard enough time rebuilding their lives searching for a job and housing. If we want them to become productive members of society, we shouldn't be denying them the right to participate in our democracy. Connecticut should not be proud of the fact that we have the most stringent criminal disenfranchisement laws in the Northeast, and we're the only state in the region that prohibits parolees from voting. This must change. House Bill 6578 will restore fairness to districts where parolees reside, as does Senate Bill 753, righting another racial inequity. For purposes of redistricting, people should be counted in their communities where they lived at the time of incarceration, not in the towns where they are incarcerated. Automatic voter registration, also known as AVR, will simplify and streamline how we register to vote and is supported by 77% of Connecticut voters. AVR will increase the security and integrity of our voter rolls by updating bad addresses and duplicate registrations. Senate Bill 1017 would allow voters currently qualifying to vote absentee to retain the freedom and convenience we had in 2020 to use their town's official secure ballot drop boxes, just as I did myself last August and November. Again, we should be enabling voter participation and peace of mind, dropping off their ballots in person, not discouraging it. In closing, House Bill 6578 and Senate Bill 753 and 1017 will go a long way in building racial equity, increased voter participation, making our democracy vibrant and strong. And on a personal note, I also would like to say that I'm in favor of Senate Bill 760. Jim Leahy's a friend of mine, and again, I wouldn't want to go through that with my own family. So that's not an official position of my organizations, but it's a personal one. Thank you.
Thank you. Thank you for your testimony and your time today. Are there any questions or comments from members of the committee? Seeing none, thank you again for your testimony.
Thank you, Senator.
Next, we will hear from Patricia Rossi, who will be followed by Representative Michael Winkler, who will be followed by Randall Collins. Patricia, the floor is yours. Welcome.
Thank you. Good afternoon, Government Administration and Election Committee. Thank you for holding this public hearing. I'm Patricia Rossi of New Haven, Connecticut, and I am speaking for the League of Women Voters of Connecticut. The League supports Committee Bill 753, a bill which would end the practice of enumerating incarcerated persons in the town where the prison is located, rather than in their home communities. Our support is based on two longstanding positions held by the League. Our position on apportionment, which holds that congressional districts should be based on population, and our support for voting rights, which recognizes that reapportionment should not dilute effective representation of minority citizens. As you know, incarcerated people were enumerated along with all other people during the census undertaken last year. The question before you is, to what locality will those people be attributed? Currently in Connecticut, inmates are counted as residents of the districts where the prison is located rather than at their home addresses. Inmates are often from urban areas, which are disproportionately communities of color. The current enumeration practice simultaneously distorts the true population basis on which apportionment should rest and creates a race-based gerrymander by diluting the effective representation of communities of color. Last year, the League, as well as state officials, worked diligently to help the census conduct a complete count, particularly for communities of color. But the current practice of attribution creates a structural and systematic undercount for those communities. This will affect their political representation and the services and funds allocated to their districts on the basis of population. Bills similar to 753 have been introduced in earlier sessions, but this year is different. This is the last opportunity to fix this unfair practice before the once every 10-year process of reapportionment and redistricting is done. In previous year's testimonies in front of this committee, experts outlined the arguments rooted in both Connecticut state law and in the US Constitution against counting inmates in the town where the prison is located. I don't think I'm not going to enumerate these compelling arguments because I think you've heard them before. But it really is only fair to count people where their families live and where they live and to help reintegrate them into the community. I'd like to very quickly express our support for two other bills. HB 6578, which would allow for automatic voter registration, and HB 5318. A recent Secure Democracy public opinion poll shows that 77% of Connecticut voters support AVR. Across the country, localities have saved an average of about $3.54 per registration by moving from a paper to an electronic method. We support providing an opt-out system for AVR as well. 19 states have versions of AVR. Finally, I'd like to express our support, for HB 5318, for which we have also submitted more detailed written testimony. Restoring the right to vote to people re-entering their communities on parole is important because disenfranchising people on parole sustains a racist system of inequality in our state. Those on parole are concentrated in only a handful of Connecticut communities, those with significant populations of Black and Latino people.
Your 3 minutes is now over.
Got one sentence. Withholding or delaying voting rights to citizens just diminishes our democracy. Thank you very much.
Thank you. Thank you for your testimony. Are there questions or comments from members of the committee? Representative Thomas.
Thank you so much, Madam Chair, and hello, Patricia. Hope you're well.
Hi.
Thank you, Madam Chair. A couple of quick questions, and you are probably not an expert in these, but I thought you might have some information. It's my understanding that to qualify or to be released on parole, you have to have both a place to live and a job. Do you know if that's the case?
I'm afraid I don't. I'm not an expert on that.
And I don't know either, but something you said struck me that, parolees are not the same as incarcerated people. They are encouraged to be contributing members of the society. And if they are required to hold a job and have a residence, I say, why not be able to vote? And the second question, you also may not know, but it also struck me when you were speaking that, this reapportionment is based on the census, which is every 10 years. And it seems that there are probably people who are incarcerated serving fewer than 10 years. So it feels like a system that is very much out of sync. Like, why should those people, I think Representative Haddad mentioned earlier, a prison actually closed in his district, and those people were still part of the count. So through you, Madam Chair, I just wonder, Ms. Rossi, if you have any thoughts about that disconnect. And yeah.
Well, I can't speak directly to that because I'm having a hard time doing the math in my head. But I would say that it certainly makes no sense to count people where they have no connection to the community. The representative of that community doesn't go into the prison and ask them what they want. I mean, it just seems wrong on several levels. And also, you do want these people to be connected to their home communities. You want them to feel part of a community. We want to reintegrate people into the community. So for all sorts of reasons, it's wrong. It's just wrong.
Thank you for that. I appreciate it. Thank you, Madam Chair.
Thank you, Representative. Representative Haddad.
Thank you, and thank you very much for your testimony. Regarding a reapportionment and redistricting, I wanted to thank you for your testimony. You give us a lot to think about. As I understand it, in the last round of redistricting, I just want to make sure that this matches your understanding of the scope of the problem. In the last round of redistricting, there were I think 7 House districts that had where a significant portion of their population was counted from a prison. And in fact, I can name 5, the 52nd, the 59th, the 61st, the 103rd, and the 37th, where the level of incarcerated population approached 10% of the total value of the district. Is that your understanding? Did that give us a good idea of the scope of the problem?
Yes, actually, our figures suggest that it's 9 Connecticut House districts. And that comes from the lawsuit filed by the ACLU, I do believe, last year. Yes, it's a significant number of House districts are not in compliance with the 1 person, 1 vote rule, which is based on equality of population in each district.
And I guess just so that we have an understanding, well, that actually works to the benefit, I suppose, of the rest of the residents of those districts, because the rest of the residents of those districts have an enlarged voting power in terms of their representation.
That's correct.
That voting power is actually usurped from every other district in the state of Connecticut.
That is correct. That it inflates the power of the district where the prison is located, and it suppresses the power of the district from which the incarcerated people came and will go home to.
Thank you very much. I'd be very interested in knowing what the list is of 9 House districts that you mentioned. If you wanted to forward that to me or my office or to the committee, I'm sure we could share that with the rest.
I'd be happy to do that.
I appreciate your testimony today. Thank you.
Thank you very much, Representative.
Thank you, Representative. Representative Rosario.
Thank you, Madam Chair, and thank you for letting me speak. I want to touch briefly on SB 753 and HB 531A because they bring up a personal story for me. My brother is currently incarcerated at Willard Cybulski, and I was the statewide co-chair for the Census Complete count. My brother's going to be coming home soon, and all of his services that he needs when he gets out, when he re-enters, housing, health, everything, they're all going to be in Bridgeport. And being that he's going to be coming home, he got enumerated as part of the town where he's at right now. So that's one thing I want to touch upon. And secondly, HB 5318, back in 2014, I had 13-14, I had run for town committee. And at the time, my brother was on parole. And he did everything he did for my campaign. He worked on my campaign, he canvassed, made phone calls, put up lawn signs, and standed with me at the polling place all day. The one thing he couldn't do for me was vote. And it broke his heart. So I want to make sure that opportunity, he gets given that opportunity in the future when he gets out and corrects his life, like many others, that they have that opportunity to vote. Thank you.
Thank you, Representative Rosario. I appreciate your comments. Further question or comments for Patricia Rossi? Seeing none, thank you for your time and your attention today. Appreciate your advocacy here, ma'am. Appreciate your time.
Thank you very much.
Up next, Representative Michael Winkler, followed by, I believe, Randy Collins. Representative Winkler, the floor is yours. Good to see you again, sir. Welcome back.
Good to see. Thank you. I have a lot of respect for this committee. To chairs, Representative Fox, Senator Flexer, Vice Chair Senator Haskell, Representative Thomas, Ranking Member Senator Sampson, Representative Mastro Francesco, and the members of the Government Administration and Elections Committee. I'm Representative Mike Winkler. I'm here today to speak in favor of House Bill number 5011, an act concerning the copying of public records under the Freedom of Information Act. This bill would allow Connecticut citizens for the first time to take pictures of public documents using cell phones and cameras. Currently, the statute says you can only use a handheld scanner, usually connected to a laptop, which you roll over the paper. Taking pictures is much faster for everyone involved, eliminates contact with the record, and is a non-controversial update of the statutes. As a result of a compromise with the towns, the bill now maintains the $20 per day charge for copying land records. Maintaining this $20 per day charge was an important goal for the towns and a major source of their FOI revenue. The current $20 charge for residents who take a picture of a public document outside of land records has been eliminated. The bill reduces the charge for copies to 15 cents a page. This has much less impact than it would have had even 4 years ago when this legislation was first introduced. As a result of technological changes and the pandemic, increased awareness of how disease spreads, the variants, working from home, towns are moving to transmitting electronic copies. This bill changes nothing in the statutes about electronic copies. The people who will need paper copies will be those who have no computer, printer, or internet. Generally, these are low-income households who need reasonably priced access to public documents. I am very grateful that this committee raised this bill despite the challenges and limitations on legislating in the time of COVID. Thank you for the opportunity to testify before you today.
Hey, Representative Winkler, Representative McCarthy, your hand is raised.
Thank you very much, Mr. Chair. And Representative Winkler, I just wanted to say thank you for being persistent with this issue. I know that we had hiccups in the past, but I really do appreciate the work that you did to bring it to this point and to work through some of those issues and questions and concerns. And isn't it amazing how the world has changed since the conversation initially happened, and this is an even more important issue now. So I'm happy to hopefully work alongside you to support this effort, and thank you. Thank you, Mr. Chair.
Yeah, was there any further questions or comments? This seeing Representative, thank you for your time. I recall a year or two ago when we brought this bill to our attention, you brought in what was then a handheld scanner, was the size of a tape recorder, the big, massive, clunky piece of machinery you brought for us. So it's visually very helpful for us to see.
The amazing thing for me is you had to roll it over the paper 3 times, and then the software stitched it together. Crazy.
Yeah. But thank you for your advocacy efforts and appreciate your time here today. Thank you, sir.
Thank you.
Up next, Randy Collins, followed by JP, followed by Liz Linehan. Mr. Collins.
Good afternoon, Chairman Fox, members of the GAE committee. My name is Randy Collins. I'm an advocacy manager with the Connecticut Conference of Municipalities, and I just want to comment briefly on a few bills. CCM supports Senate Bill 1016, which you heard enact concerning municipal ethics. I know that Peter Lewandowski spoke very well of the bill. We have worked with the Office of State Ethics to come up with a compromise that we believe will work with all communities. CCM's always supported municipal ethics. Since 2016, we've conducted 16 ethics training sessions, quite often regarding right around with our newly elected workshop. And we have, have consideration, we've talked to Office of State Ethics to continue to conduct municipal ethics workshops to make sure everybody gets up. We do appreciate the fact that it's not a mandated one size fits all, which would be problematic because what works for Hartford might not work for Salem, Connecticut. I did want to express a little bit of concern with House Bill 6212, an act concerning confidentiality of residential addresses of certain persons in online municipal records. Well, we appreciate the intent of the bill, and we'd like to work with the committee to see how we can make this work. I think there is concern, given the broad scope of how many municipal records are online, that if a municipality made a good faith effort to redact the addresses of participants in the address confidentiality program and something was missed, that there could be a potential for liability. You have records with the clerk's office, the assessors, Park and Rec may have different applications, dog license. They're all over the place. And that would be something that we would have concerns with as we go forward. So we'd like to be able to work with the committee to, as I said, if a town makes a good faith effort to try to comply with that, that they wouldn't be held liable if something was missed. We do have some concerns with Senate Bill 353, an act concerning municipal elections. While the bill, the bill would change everybody's municipal election to November, and then a town could opt out with a vote of a 2/3 majority. We just think that that should be flipped, that if a town is restricted from moving its election due to charter revision is very expensive and onerous, and to open it up for small issues, you have to open it up for the entire process, which a lot of towns just won't do. I think the better option would be to allow a town to vote proactively to move that election to November rather than having to vote to keep it where they are. And the last bill that we have concerns with is House Bill 5011, decreasing fees for copying of public records under Freedom of Information Act. I've spoken many committees on this. Towns are over reliant on a regressive property tax. We have a property tax structure, and then we have a few fees and fines that municipalities assess. Anything that reduces that revenue simply shifts that burden onto a property tax. And right now, our municipalities are extremely concerned about how we're coming out of COVID. We have a lot of unemployed residents. We have businesses that are barely hanging on, and any shifting of that cost will be a burden that we don't want to have to place on our town.
Your 3 minutes is now over.
So it's just in summary, we'd love to be able to talk about revenue diversification and to move us away from a regressive property tax and the need to apply fees to these small items, but those are the fees that keep the lights on. Thank you, and happy to answer any questions.
Hey, Mr. Collins, any questions or comments for Mr. Collins? Seeing none, Mr. Collins, I appreciate your time. I look forward to continue to work with you on the underlying bills.
All right, thank you very much.
Thank you. Up next, I believe I said JP, followed by Representative Linehan, followed by Doug Casey. Mr. P available.
Yes, I'm here. Thank you.
Good afternoon, sir.
Yes, thank you for having me here. It's an honor to participate in this process. My name is JP. I'm the founder of Save Standard Time, a public benefit nonprofit working throughout North America. I'm here to ask that you oppose HB 5877 and recommend its amendment to permanent Eastern Standard Time. This bill seeks to end clock change, which is a good idea, but it goes about it the wrong way in seeking permanent Atlantic Time. Connecticut's longitude is 73 degrees west. Eastern Standard Time is centered on 75 degrees west, just 2 degrees away. You're almost perfectly aligned with EST. Atlantic Standard Time is centered on 60 degrees west. It's about 750 miles east of you. AST in Connecticut would be permanent daylight saving time, an extension of DST into the winter. And we don't observe DST in winter because it makes sunrise too late. This bill would delay Connecticut's sunrise to 8:21 a.m. and past 8 a.m. for up to 2.3 months. Most school and work days begin around 8 o'clock. For a fifth of the year, from late November to early February, this bill would force hundreds of thousands to start school or work in the dark. They might not see sunlight until lunch or the end of the day, and that's depressing and dangerous. This bill is also contingent on New York doing the same, but it would be even worse there with their sunrise as late as 8:48 a.m. and past 8 a.m. for 3.6 months, nearly a third of the year. Artificially delayed sunrise reduces sleep and immunity. It increases illness and accidents. It's not just clock change that harms. Clocks are not arbitrary. If you were to ask most people, would they willingly set their alarms an hour early every day? Would they wake themselves hours before sunrise in the cold of winter? They would say no. But that's what permanent DST would force them to do. Permanent DST was hugely unpopular in World War II. It was hugely unpopular and even lethal when it was tried again in the 1970s oil crisis. Countries that try permanent DST do not adjust. Instead, they sleep less, their health suffers, and they eventually seek to revert it. Permanent daylight saving time is opposed by the National PTA, opposed by the National Safety Council, opposed by the American Academy of Sleep Medicine, and many more organizations. Every advocacy group for health, safety, and children's well-being that has spoken on this issue urges instead for longitudinally correct permanent standard time. Permanent Eastern Standard Time keeps your sunrises before 8 a.m. It saves the morning daylight, which doctors tell us is most necessary for mood, health, safety, learning, productivity. Morning daylight helps you wake naturally. It keeps you healthy, alert, active, and on time. Permanent EST in Connecticut is also pre-approved by federal law. The Uniform Time Act of 1966 permits any state to observe its correct standard time year-round, as Arizona and Hawaii already do. Permanent EST on the East Coast is the quickest, simplest end to your unpopular clock change. Please listen to the consensus of doctors, teachers, and history. Please stop this bill until it is amended to permanent Eastern Standard Time. I've provided you with a letter with citations, expert statements, comparison photos of how mornings look on these two different clocks. I'd be glad to answer any questions you might have. And I thank you very much for your time and for your service to the public.
We appreciate your time and testimony. Representative Blumenthal, your hand is raised.
Thank you, Mr. Chair, and thank you, sir, for being here with us today. I just had one question, basically. So you said you're recommending Eastern Standard Time versus Atlantic Standard Time. You said Atlantic is the correct longitude is, you said 720 miles east of us? Did I hear that right?
Yes, approximately 750 miles, nautical miles east of you, out in the middle of the ocean.
Okay, so there are no states on the East Coast that are at that longitude, correct?
Correct,
okay.
Yeah. No, the East Coast belongs on Eastern Standard Time.
All right, yeah, I was just concerned about if there was a coordination problem, all being on Eastern Standard Time, but that makes sense. Thank you, sir. Appreciate your testimony, and thank you, Mr. Chair.
Thank you, sir.
Thank you, Representative. Any other questions or comments? Seeing none, Ms. P, appreciate your time and testimony today. Thank you for your advocacy. Thank you for being here.
Thank you, sir.
Up next is Representative Liz Linehan, followed by Doug Casey, followed by Fulvia Vargas de Leon, followed by Colleen Murphy. Representative Linehan, floor is yours.
Thank you very much, Mr. Chairman. To you and Senator Flexer and all the ranking members, vice chairs, and distinguished members of the GAE committee, thank you for the opportunity today to come and testify on House Bill 6212, an act concerning confidentiality of residential addresses for online municipal records. This legislation seeks to allow survivors of domestic violence to have their names redacted from online municipal records, including land records, GIS records, and tax records. Now, the impetus for this bill actually came from a constituent in 2019 whose former partner had just been released from prison, and at which time she received a protective order, but she was unable to scrub her address and information from municipal records, and she and her young child feared for her life. She did go to the town hall, who said essentially they don't have the permission to redact that information, and that's where this bill started. However, that was in 2020, and obviously because of COVID, we were derailed. And now that we are in 2021, and actually recently in the last 24 hours, while talking with my constituents, other incidences have come to light, which leads me to believe that the bill should be expanded to allow any individual to walk into their town clerk and request that identifying information regarding residential addresses be redacted from online records. After discussing the bill with constituents, there are three people who brought forward some information that they would be helped by this bill. First, EP from Southington, who's actually Rep. Master Francesco's constituent, as well as Senator Sampson, was harassed online by someone using the GIS system, tax records, and voter records to harass her and her family, and even using threatening language about the residents of the home, knowing how many occupants were in the house and their ages. This made her so uncomfortable that she contacted her attorney to step in. JB from Cheshire was stalked online by a member of a Facebook forum who used those online land records to learn her address, drove by her house, and then posted information meant to invoke fear. Namely, he mentioned a red Solo cup that was left out on her porch and frequently reminded her that he saw it there and knew where she lived. And ultimately, it made her fear for her safety. And finally, CA from Cheshire was harassed also by using land records for the harasser to know their home address, drive by, take photos of the home, post them online, and refer back to that house no less than 20 times in separate harassing posts in the last year. These are just a snippet of what is happening, and I know we cannot stop the harassment from occurring. Information is available all over the internet, but the government should not be complicit by posting sensitive information on the internet, which can be used for any number of nefarious uses. So I humbly ask the committee not only to support this bill, but to amend the language to include any person to simply walk into their town hall, redact that information as they see fit. And I'm happy to answer any questions, and I thank you very, very much for your time.
Thank you, Representative. Representative, I think the thing that gets me about this bill, just the in today's world, how online harassment is becoming so much more expansive and aggressive and terrifying, if you ask me. Do you have any thoughts on that?
I do. I think that it is terrifying. It's been no secret that my family and myself have been harassed online. My children were threatened. My husband and sister-in-law are continuously threatened because of their relations to me and their work. And this information is found on the internet. And like I said in my testimony, I recognize that we can't do anything about all of our information on the internet, but the government should not be the ones providing that information. All of this, all of the information in the land records are still available by going into town hall. We are not asking that that not be available for inspection, as it always has been. It's simply about redacting that information online so that people aren't threatened by it being there. And I will say, actually, for the members of the committee, all of us have recently received postcards from a lobbying group. I know that in my mailbox, there were hundreds of them, and they were sent to my home. Given what has happened in politics in recent time and about the January 6th insurrection, this makes me nervous as a representative as well. I would very much like my home address to remain private while still allowing people to contact me at the Capitol. So I think that online harassment has gotten worse and worse and worse. And we in the government have a responsibility to not allow and not participate in the release of that information for people who want to cause harm.
Thank you very much. Seeing no questions or comments, I appreciate your time here, Representative. Thank you for your efforts today and look forward to working with you on this bill.
Thank you so very much.
Up next, I have Mr. Doug Casey, followed by Fulvio Vargas de Leon, followed by Colleen Murphy. Mr. Casey, there you are.
Good afternoon, Senator Flexer, Representative Fox, Senator Sampson, Representative Master Francesco, and distinguished members of the Government Administration and Elections Committee. I'm Doug Casey. I'm the Executive Director of Connecticut's Commission for Educational Technology. I want to thank the committee for raising our bill, House Bill 6573. As a quick background on the commission, we're the principal education technology policy advisor for the state. We coordinate and oversee the management and successful integration of technology into Connecticut schools, libraries, colleges, and universities. This bill is administrative change. It's a reinstatement of 4 positions, and it comes in direct response to some of the lessons we've learned during the ongoing COVID-19 pandemic. With online learning so predominant in our schools today and for the foreseeable future, it's vital that the commission include members who represent those who are charged with teaching our children in these challenging times, and that would be educators as well as K-12 school district leaders. So specifically, our proposal seeks to restore 4 members of the commission's board that were moved in 2013. Those individuals would represent superintendents, the Connecticut Educators Computer Association, which is a group of experts on digital learning, elementary school teachers, and secondary school teachers. So by restoring those representatives of those constituencies, we'll be better positioned to meet critical education technology needs and goals, particularly the challenges of online learning, both in the classroom and at home. These additional board members who represent educators that have firsthand experience dealing with the challenges of opportunities presented by remote learning will help our commission better meet the pandemic-related technology needs of both schools and school districts. To answer any, perhaps a couple of questions that might come up, there is no fiscal impact to the suggested changes and addition of these new members. We've never had an issue with quorum, and we see nothing but a positive impact of adding these 4 additional members to better inform the work of the commission. With that, I'll be happy to respond to any questions that might have arisen.
Thank you, Mr. Casey. Just a few quick questions, Mr. Casey. I don't I don't recall this bill being before committee before. Is this the first year it's been raised?
Yes.
And then I presume because of your testimony, it's in light of the recent pandemic.
Correct. This is the motion, or the language that came through this came directly from the commission members wanting to have a wider representation from educators and education leaders.
Can you just briefly identify for me again the four new appointed positions, or
Sure.
who they'd be from?
Sure. And to be clear, these are positions that were formerly on the commission, but that were removed in 2013. And so it would be 1 each from the Superintendent's Association, CAPS, the Connecticut Educators Computer Association, which is a professional group of education technology experts, and then 1 each from the 2 school or teachers unions in the state. So four positions in all.
And that would, how big would the commission be total if this were to pass, number-wise?
This would bring it up to 23 voting members.
In your experience, it doesn't sound as though you're concerned by that being too big, it sounds as though you're adding these positions because you see that the resources that these individuals provide would be valuable in light of the certain circumstances.
Absolutely. I've served in my current position for more than 5 years. We have never had a meeting that has not had quorum by a long shot.
And how often do you meet?
We meet quarterly.
Yeah. Okay. Thank you very much. Representative McCarthy-Bay, your hand is raised. The floor is yours.
Thank you very much, Mr. Chair and Mr. Casey. It's wonderful to see you. I appreciate your work so much, and will say that if you feel that these positions are needed to be returned to the body, I'm going to be fully supporting you, because I know that you have gathered stakeholders together and that you work collaboratively together with them. So I'm happy to see you here today, and I know I appreciate the work that we've done together in the past on student data privacy, and I know that there are other conversations I hope that we'll be able to have in the future on technology for our students and learners. So thank you very much. Thank you, Mr. Chair.
Thank you very much, Representative. Any further questions or comments? Seeing none, thank you for your advocacy today, so thank you for being here.
Thank you.
Up next, Fulvia Vargas de Leon, followed by Colleen Murphy, followed by Alan Pender. Ms. Vargas de Leon, I believe you're there. You are. The floor is yours, ma'am.
Thank you. Good afternoon, committee. Thank you for the opportunity to speak in support of Senate Bill 753. My name is Fulvia Vargas de Leon. I'm an associate counsel with Latino Justice. Latino Justice works to advance, promote, and protect the legal rights of greater Pan-Latino communities throughout the nation. As part of our work to protect the right of Latino voters, we have advocated and litigated against practices that seek to dilute the vote of minority communities, including fighting against prison gerrymandering. We are before this committee today to urge the passing of SB 753 and finally put an end to the perpetuating harm that is caused by prison gerrymandering, especially for communities of color across Connecticut. Connecticut's legislature is tasked with ensuring voting districts are proportionally drawn to guarantee equal voter representation. Despite being bound by the idea of one person, one vote, the process of prison gerrymandering threatens the very idea of equal representation among voters, especially those of communities of color. The hyper-incarceration of Latinos in Connecticut is evident, where Latinos make up 16.5% of the state's total population, but disproportionately make up 27% of the total incarcerated population. It is in the same regard that population of prisoners disproportionately make up a significant portion of the population of the voting districts where many of these prisons are located. In a democracy where we value the right to vote, the right to equal representation, how do we reconcile denying others the right to vote, yet still using their physical presence as a means of creating voting districts which are not invested in their well-being, education, or re-entry back into their community? This matter is not isolated to the voting districts where the prisoners are located, but rather it is a practice that affects the entire state. A discriminatory practice that does nothing more but disenfranchise the very communities that have fought so long to have a voice and representation in government. Connecticut law recognizes that those incarcerated within the confines of such voting district are not residents of the town, Yet current redistricting laws allows the physical presence of these individuals to be used to artificially inflate the population of such districts. Equal representation is at the core of our democracy. When a practice exists that artificially inflates the political power of rural residents at the cost of diluting the vote of urban residents, we are perpetuating a continuous disenfranchisement of Latino and Black communities. We urge the legislature to consider the continuous discriminatory harm caused by prison gerrymandering and move forward with enacting SB 753. Thank you.
Thank you, Tesman. Any questions or comments? Ma'am, can I ask one quick question? Well, the number you indicated, the Latino population that makes the incarcerated population, what was that percentage?
Latinos make up 16.5% of the state's total population and 27% of the incarcerated population as of March 8th, when I looked at the statistics.
And going deeper down to those numbers, any ideas of the towns, municipalities where those individuals may come from or may permanently reside?
I provided written testimony that indicates that where these individuals are usually residents of, but I do not have that information in front of me right now.
That's fine. But you submitted written testimony, said?
Yeah, correct.
I'll take a look at that. Thank you. Any further questions or comments? Thank you for your time today and your advocacy. Appreciate you being here. Up next, we have Colleen Murphy, followed by Alan Pender, followed by Jeanine Davis. Ms. Murphy, the floor is yours.
Thank you, Chairman Fox, and good afternoon, members of the GAE committee. I'm Colleen Murphy, the Executive Director and General Counsel of the FOI Commission, and I thank you for the opportunity to provide some testimony on 4 bills that are on your agenda today. I know you've been meeting for quite a while now, and we've heard some testimony on some of these bills already. I will try to short circuit the testimony as best as I can, and we've provided written testimony to support the oral testimony. First, the Commission supports House Bill 5011, an act concerning the copying of public records under the FOI Act, which proposes to decrease fees for copying public records and to update the definition of a handheld scanner in Section 1212 of the FOI Act. As you heard from Representative Winkler, this is a step to reduce the current fees in the law, which allow for paper copies a charge of 25 cents for state agencies, 50 cents for municipal agencies, and this would reduce that to 15 cents. Except for land records. In addition, the current statute permits all agencies to charge up to $20 for copies made by a handheld scanner. And this is where the biggest problem in our statute is right now, and this proposal would fix that. There's an outdated definition in the law currently. It causes a lot of confusion. Therefore, the Commission endorses redefining handheld scanner to include a mobile telephone or camera and any similar device, and making the per instance charge no more than $20. The FOIC would support taking modifications of the law even further, actually, though, to eliminate fees altogether. We realize that will probably not be popular with everybody, but we think it could potentially be appropriate, especially when individuals make their own copies of public records. California has taken this approach. It would cut through a lot of red tape, along with time and costs associated with processing such requests. Although the proposal falls short of doing that, the Commission believes that the changes in 5011 will align the law with current technology and will permit technology to be used in a way that enhances public access, and therefore we support that. The second bill the Commission wishes to comment on and provide some background information for the committee before considering passage of it is House Bill 5879, an act exempting constituent contact information from disclosure under the FOI Act. And the proposal aims to exempt certain contact information in the custody of members of the General Assembly. First, the Commission wants to apprise the committee that there is currently a pending case on this topic before the Commission. While the Commission believes it's inappropriate to state a formal position on the proposal due to that, we would recommend that the committee potentially take a wait and see approach to determine whether legislation is necessary and what that legislation should be as a matter of policy. If the committee wishes to proceed, we have several cases on the topic of constituent information already, where the commission has attempted to split the issue in half and has ruled that basic constituent information is not part of the legislator's official duties as a legislator, and that is exempt. And the commission, though, has also held that when there are communications related to legislation, important public business, that those communications should be subject to FOI. But as I stated, there is a case pending, and once that is resolved, potentially you may find that there is not a need for legislation. So that's why we urge a wait and see approach. Third, the commission has a somewhat unenviable position of opposing 6576, an act concerning the non-disclosure of residential addresses of certain employees under the FOI Act. Oppose is probably too strong a word for our feeling toward this proposal, particularly after hearing from our Attorney General. The bill does propose to add to the list of protected categories under 1217, the employees of the Attorney General's office. The concept of adding another classification of workers to an already long list in 1217 has been opposed by advocates of transparency, not because the advocates don't believe in protecting employees, and certainly we heard the passionate plea of the Attorney General, but because the security that it provides is very, very narrow and potentially illusory. And second, the categories of employees that keep expanding under this proposal set up a situation where there's a fairness issue, that you have some categories of employees who are covered and others who are not. I guess at this point, if the committee wishes to pursue this, the commission would generally recommend that you consider putting all public employees in that category. Again, it's a very narrow provision of security insofar as the only thing it really does is exempt an address from the employing agency, so that if somebody requested the address from the AG or one of the other protected categories, the agency could withhold the address. It does not mean that addresses are removed from other public records. So we feel that it gives a bit of a false sense of security, but if you wish to pursue that, we think the best approach would not to be this piecemeal approach and to make it apply to all public employees. Last, the commission has just a couple of concerns related to House Bill 6212, an act concerning the confidentiality of the residential addresses of certain persons, certain protected persons and online municipal records. And the FOIC doesn't oppose expansion of the address confidentiality program. In fact, we were at the table when that program was put into place, and we really appreciate the aim of the bill to eliminate addresses of people certified in that program from online exposure. But the commission is concerned about lines 97 through 99, which state that the town clerk and other officials may make the originals or physical copies of such records available. That type of discretion put in the statute would run afoul of the FOI Act. It would make it confusing as to whether those physical copies should be accessible or not. The FOIC recommends taking that sentence out or revising it to make clear that the originals must be made available to the extent required under the law. And second, the commission shares the worry of, I believe, the town clerks, what they will express when they appear before you, that the proposal will reverse the progress made, particularly during pandemic times, of proactive disclosure for land and other records. The FOIC worries that the proposal may cause public officials to simply take down all of the records out of fear that they might violate the law. So we'd ask that you consider those items, particularly lines 97 through 99, as you consider whether to take this proposal forward. Thank you, and I'm happy to answer any questions you might have.
Ms. Murphy, Representative Master-Francesco, the floor is yours.
Thank you, Mr. Chairman, and thank you, Colleen, for being here and sharing your information with us. I appreciate all the work the Freedom of Information Commission does and everything that you do. It's very important to our democracy, so I appreciate that. Just a couple quick questions on the copying of public records. Can a town with technology today, can a town just email information to someone? Is there
Sure.
any, and there would be no charge to the taxpayer at all? Is that possible?
Yes, that is certainly possible. The question has been posed about whether there ought to be a charge in those instances, but currently there are none, and there are no bars to providing information that way. That would probably be advisable.
Okay, yeah, and I'm all for I think the people, we pay enough taxes in towns, right? And I think all that information should be free of charge if it was up to me. But I understand, and just with technology today, you have to wonder why every single time that information is not emailed, because one, you certainly have a record of it electronically that you sent it to them, and then also that they received it, and then it would be up to that person, if they can, to just go to print it from home or wherever, go to Staples and print it. It just seemed to me that it would be a much easier process, especially even for the town clerks. I'm assuming that you've had conversation with the Town Clerks Association on this issue. Do you know what an average, and I know this is hard, what would be the average cost or expense a town incurs for making copies? I know it's a broad question, but
that I don't know. I think some of the concern is around the labor that's put into making a copy. I would imagine it would be very inexpensive these days to make a copy of a record. The current provisions in the statute, it was originally 50 cents for all agencies, and a number of years ago there was a reduction. I think the idea was to lower it to 10 cents, and the compromise came out of 25 cents and to allow municipals to retain that 50 cents. But as time has gone on, that seems more and more exorbitant.
And that the more reason that we should certainly use technology when we can for people who have access to it to email it. Okay, thank you for that. I had a question on another bill, which was 6576. I'm sorry, it was 6212. I apologize.
Yes.
The residential addresses of protected persons. I certainly understand the concern on that. Would you know of how this is going to affect the towns when it comes to their land records? People want to look up information, even realtors. Somebody wants to buy a home and they go online and they want to see what the home is assessed at. You certainly know who lives there. How would they gather that information? They could still just go through Freedom of Information and just get it manually, correct? In other words, it would not be posted online. Am I understanding that correctly?
That's right. My understanding is you could still go into the office and obtain it that way, although there is that confusion now in lines 97 through 99 as to whether that's required or not.
Right. My concern with it is, even just in the real estate market, people looking to buy a home and they want to see what the person pays for property taxes on that home. They want to see what the assessment is, and they will no longer be able to look that up online. They will now have to go into and request it another way, which is a concern. When a town has a suspense list for their taxes as well, those would come off of that line as well. So the towns at the end of the year, they have a suspense list where there's going to purge past due taxes. Would it come off of those as well? Would it just be anything that's published online?
I believe, the proposal is directed to online publication.
Okay. That's all I really had. I had some concerns. I understand the concerns of a victim, obviously, if they're under a protected order, but I'm also concerned that, people should have access to that information. So I guess we have to listen to more on it, but thank you so much for your testimony and for answering my questions. Thanks.
Thank you, Representative.
Hey, Representative. Mr. Murphy, I just have a few quick questions. On 6576, the Attorney General's bill.
Yes.
There's currently 12 exemptions in 1-217. Do you know historically, just I don't know, was that done one fell swoop, or was that done piecemeal like this we're trying to do here? Do you remember? Do you recall?
After the initial passage, which I believe included judges and police officers and maybe one other, whoever the other third category is, since that time, there have been the incremental add-ons. And originally, the idea was for security, and it was to provide some level of protection to the at-risk individuals, particularly those directly in criminal law enforcement. And now it has expanded to other entities, who have some, as the Attorney General said, civil enforcement, in the civil realm. So that's kind of the history of it.
And all that this protects the residential address of the individual, correct? Nothing, just residential address, correct? Nothing further?
Just the address, yes.
Okay, and then just very quickly on 5879, you provided, I think, two examples of can you just clarify the two examples, what's to be disclosed, what's not to be disclosed? Can you just give that to me again?
The first in a declaratory ruling, and then in some cases that have followed, the commission has tried to split the issue in half and has generally ruled that information pertaining to constituent services, where a constituent is asking for help on a personal matter, as opposed to asking for a bill to be drafted, that constituent information is not part of the legislative role, not part of the public official's role that is covered under the FOI Act. And so the constituent information has been ruled to be exempt.
And what is defined as constituent information?
Well,
name,
I don't
address,
think that,
email address, phone number, things like that.
well, I think that kind of remains to be seen. It's been handled on a case-by-case basis. I don't believe it's ever officially been defined. Heretofore, the issue has been more about the subject matter as opposed to, the name, address of the person who was contacting the legislator. The focus was more on the content. But I think constituent services could potentially include the name and address, of the individual contacting.
Okay. And then the second of the, so they're split in half. So the second half of that theory was what?
So the second half of the theory is that, information related to legislation being put forward or, in the process, that information does relate to a public official, a legislator's role as a public official, and that those matters are subject to freedom of information, of course, subject to any exemptions in the law.
And what if I, as State Representative Fox, get an email from the first half saying, can you help me with this? You read this piece of legislation. Can you help me on my insurance law? I need help with my insurance issue. And I say, fine. And I take that individual's contact information and I set it aside. And then someone contacts me in the second half of your explanation and says, I need this, that, the other thing. And I take that contact information, I set that aside, and then I put those two names together, and I have a bit of a list. Is the list I've created protected or no?
Well, I don't think that specific question has been answered yet. I think potentially in cases pending before the commission that may be addressed. So I want to steer clear of something that might come up before the commission, but that specific thing has not occurred as yet. And one thing I do want to mention, Chairman Fox, is that I didn't mention in my testimony is that the language as drafted currently is very unclear to us as lawyers for the commission. And if it is to go forward, I would respectfully ask to work with you on that language, because I don't think the commission would really know how to interpret it as it is currently drafted.
Okay. Seeing no further questions, comments, thank you for your time today. Appreciate your advocacy. Thank you for being here.
Thank you. Bye now.
Up next, Alan Pender, followed by Janine Davis, followed by Representative Nuccio, Mr. Pender, I believe I saw you earlier.
Yeah, I'm here now. Can you hear me okay?
You can, yes, sir. The floor is yours. Please proceed.
Okay, thank you. So good evening, co-chairs, Senator Flexer, Representative Fox, Ranking Member Sampson and Mastro Francesco, and members of the Government Administration and Elections Committee. My name is Alan Pender, and I am a second-year graduate student at the UConn School of Social Work. And I am testifying today in support of House Bill 5318, an act restoring electoral privileges to convicted felons who are on parole. Since 2017, when I moved from Ireland, I've been a permanent resident of the United States. And although I currently cannot vote, I am using my voice today to support the expansion of voting rights so that everyone has equal access to their right to vote. My citizenship is imminent, and I will soon be eligible to vote in state and federal elections, and I plan to vote. I am interested in restoring the right to vote to individuals on parole. As you are aware, individuals in Connecticut who are sentenced for committing a felony cannot vote until they have completed their confinement and parole. Today, I want to share with you why this is inequitable, exclusive, and give you an example of a different model. In 2005, the European Court of Human Rights found that the UK government had violated a prisoner's rights by refusing them the ability to vote in an election. The following year, in Ireland, the Electoral Act of 2006 was created. It permits all prisoners to vote by mail if they are registered. If they are not registered, they can register to vote in the area they would have otherwise been living in. Seeing this in my home country, I know how important it is to make this a reality for incarcerated people in Connecticut, my new home, and allowing individuals to vote on parole is only the first step. Many countries, such as my home country of Ireland, have continued to remove barriers for those most impacted by a single weekday election. In 2020, Ireland moved the day of their general election from a weekday to a Saturday. We in Connecticut have multiple voter expansion bills that could make real tangible progress towards a fairer democracy. As much as I value my homeland and Ireland's progressive laws and policies, as I mentioned, Connecticut is my new home, and being a social worker is my new profession. As a social worker, I have an ethical obligation to advocate for those who have been purposefully excluded. As a state, let's remove the barriers to voting instead of implementing them. By supporting this bill, I am supporting the American dream of democracy, one that I myself am striving for. Thank you for your time today.
Thank you, Mr. Pender, for your testimony. What are you studying at UConn, out of curiosity? What are you studying?
Social work and in policy practice.
Oh, very nice. What part of Ireland are you from? Where's home?
Kildare, just outside Dublin, towards the Midlands.
Yeah. Oh, very nice. Oh, good. Yeah. I appreciate your testimony. Representative McCarthy-Vahey has her hand raised. The floor is yours, ma'am.
Thank you very much, Mr. Chair, and I appreciate your indulgence. And Mr. Pender, thank you. As a fellow social worker, I appreciate your advocacy, but I also appreciate the international perspective. I think that's helpful for us as we contemplate this legislation. Thank you very much, Mr. Chair.
Thank you, Representative. Mr. Pender, seeing no more questions or comments, I appreciate you taking part in the hearing today. Thank you for your advocacy. Thank you for being here, sir.
Thank you.
Next up, Janine Davis, followed by Representative Nuccio, followed by Chuck Pine. Ms. Davis, good afternoon, Ms. Davis. How are you?
Hi, how are you?
Doing well. The floor is yours. Please continue.
Can you hear me?
Yes, ma'am.
Thank you. Thank you, Representative Fox, Senator Flexer, and esteemed members of the GAE committee. My name is Janine Davis, and I'm the co-director of Bridgeport Generation Now Votes, along with Callie Gail Heilman, who's not feeling well, so she couldn't be here to testify today. So I'm going to speak for both of us. And we are here today to strongly support Senate Bills 1014, 753, 1017, and House Bill 6578. In May of 2020, Bridgeport Generation Now Votes, PT Partners, Greater Bridgeport NAACP, Make the Road Action Connecticut, and the Council of Churches of Greater Bridgeport formed the Bridgeport Safe Vote Coalition with the primary goal of strengthening voting rights during Bridgeport's local elections and the COVID-19 pandemic. Alongside the Connecticut Safe Vote statewide coalition, we pushed for expanded absentee ballot access so Bridgeport residents could vote safely from home. Throughout the summer, our members also emailed, called, submitted testimony, and won an election monitor for Bridgeport during the 2020 general election. I want to be perfectly clear as I begin that Bridgeport does not have widespread in-person voter fraud. What we have here is a system that allows political operatives to exploit the absentee ballot process to target, manipulate, abuse, and defraud Bridgeport voters for the purpose of monitoring and controlling their votes. This abuse disproportionately affects some of our most vulnerable residents, our elderly, low-income, disabled, and Spanish speakers. The result of this decades-long behavior has essentially broken our local democracy. The appointment of Attorney Max Medina by the Secretary of State as Bridgeport's election monitor provided necessary oversight and guidance during our 2020 presidential elections. However, it is well documented that oversight is most needed during our local primary elections. Bridgeport voters deserve free and fair elections every time we go to the polls. Passing SB 1041 will fund this position for the next 2 election cycles in Bridgeport, giving our election officials and our voters the support we need to rebuild trust and restore democracy. We want to thank Senator Marilyn Moore and Representative Rosario and all the members of our state delegation for recognizing this as a key voting rights issue and making it a priority this legislative session. In addition to SB 1014, our coalition also supports SB 753, an act concerning the counting of incarcerated persons. With the passage of this bill, Connecticut can end prison gerrymandering, thereby correcting the harm of racist and classist policies that disenfranchise and defraud Black and Brown communities of true political power. In our representative democracy, incarcerated people should be fairly counted as residents of the towns they resided in and not in the towns of the correctional facilities they were placed in. We strongly support HB 6578, which restores, I'll be done really quickly, that restores the right to vote to people re-entering their communities on parole without requiring the payment of certain fines. We also believe that the bill makes an important step in codifying automatic voter registration, but we would like to see it improved and expanded beyond the Department of Motor Vehicle. So I'll just stop there since my time is over, but thank you very much.
Thank you, Ms. Davis. I appreciate your testimony. Any questions or comments from Ms. Davis? Seeing none, thank you for being here today, ma'am. I appreciate your advocacy. Thank you.
Thank you.
Up next, Representative Nuccio, followed by Chuck Pine, followed by Tanya Hughes. Representative Nuccio.
Good evening, Co-Chair Senator Flexer and Representative Fox, Ranking Member Senator Sampson and Representative Mastro Francesco, and distinguished members of the Government Administration and Elections Committee. I'd like to thank you for the opportunity to testify today in support of Senate Bill 760, an act prohibiting publication of an image or video of a fatal accident until a family member or household member has been notified. In my very short time as a legislator here in Hartford, I've written a few testimonies in support or opposition of bills. I found the testimony process helpful, and it's been very easy to express my opinion or convey why I believe a piece of legislation is good or not so good. This testimony, however, has sat on my desk for 3 days with a simple paragraph for a start and nothing more. I've rewritten it 5 times. The only words that I can come up with for this is what the media is doing is wrong. It's shameful that we would have to even discuss something like this. You would think human decency would prevail, but as you will hear, as you have heard today, it has not. If this only happened once, once would be too many times. More than once, and we don't do something to make a change, we are complacent and intentionally inflicting additional trauma and pain on surviving loved ones. Today, you heard from 2 members of my community, both Jim and Hannah Leahy, on how this law would have prevented additional trauma during one of the very worst times of their lives. You also received testimony from Ryan Regan, who was Tommy's best friend, who really started the conversation on this. What you will not hear is testimony from others, like the mother in my town who showed up at the scene of a fatal accident when her son's motorcycle picture was blasted across the social media pages, or the wife whose husband's motorcycle was pictured off the side of the road, mangled with LifeStar taking off. You won't hear from the multitude of other residents that have found out this type of news alone while they had their cell phone in their hand and began to question or confirm whether or not their loved one may have perished in a fatal accident. To turn on the television and see a post on social media about a deadly accident and then to see your loved one's vehicle clearly identified is not only irresponsible, it's just simply cruel. I support this legislation because no family should have to go through what several of the families in my district have gone through, and it is within our power to ensure that it does not happen again. I thank you for allowing my testimony today, and I thank you even more for consideration of this bill.
Thank you, Representative. I appreciate your thoughtfulness and your words and your advocacy on behalf of your constituents and your community. Seeing no questions or comments, thank you for being here. Appreciate your time.
Thank you. Have a good evening.
You as well. Up next, I believe I stated Chuck Pine, followed by Tanya Hughes, followed by Brianna Shane. Chuck Pine present. Mr. Pine. Hearing no response, Mr. Pine, Tanya Hughes, followed by Brianna Shine, followed by Sherry Quickmeyer.
Good afternoon, Representative Fox.
Good afternoon, good to see you.
Good to see you as well. Good afternoon also to Senator Flexer, Senator Sampson, and Representative Mastro Francesco and members of the GAE committee. Thank you for the opportunity to testify today regarding HB 5652, an act concerning a study of equity in the construction industry. I'm Tanya Hughes, the Executive Director of CHRO, and I have with me our Deputy Director, Cheryl Sharp. And we just will abbreviate our submitted testimony. Basically, through our contract compliance unit, we enforce the state's anti-discrimination contract compliance laws, which include the set-aside plan compliance, which guarantees that competitive bidding and other contracting processes will give qualified but underutilized small businesses within the state an opportunity to get contracts. These set-asides currently 25% for small businesses and then 25% of those small businesses for enterprises owned by women, ethnic minorities, and individuals with disabilities are designed to create greater inclusion of historically disadvantaged persons in state-funded public works contracts. The program in turn contributes to the state's economic development by allowing dollars to be turned over within the state and keeping state dollars in local small businesses. We at CHRO believe these are laudable goals, but behind that, the state set-aside program must stand on solid legal ground. And this means that the set-asides must be grounded in specific, strong evidence that shows past or present discrimination against each of the protected classes in the set-aside program. So to that end, and to ensure that the study conducted gathers the data needed to provide the foundation for the set-aside program, CHRO respectfully requests that the committee broadens the scope of the study to encompass the following. Whether based on available data and analysis, there's significant statistical evidence of past or continuing discrimination in the awarding of state contracts. It must determine the number of small contractors or minority business enterprises that are qualified for eligibility of state contracts under the set-aside program, and a determination of whether such businesses are in compliance with the definition of a small contractor or of a minority business enterprise as defined in Section 4A60G of the general statutes. It must also determine if there are any contracting processes, even unintentional but barriers that may exist in the process that prevent small contractors and minority business enterprises from fully participating in the contracting process. So finally, we request that the CHRO be added to the bill to work in concert with the Department of Administrative Services. We've already been in talks with them, and we'd like to issue a request for proposals for the conduct of a disparity study. We thank you again for introducing a bill of this important subject, and we look forward to working with you, all of you, on this important issue. Thank you.
Thank you, Ms. Hughes. Any questions or comments? Sina, I appreciate being here. Appreciate your advocacy. We'll take your comments to heart. Thank you very much for being here, ma'am.
Thank you.
Up next, I realize I skipped over Martin Coburn. So we're going to go to Martin Coburn, followed by Brianna Shine, followed by John Erlinghauser. Mr. Coburn, I apologize. My mistake.
No worries about it. Thank you for this opportunity to speak to the committee again. My name is Martin Coburn from Cheshire, Connecticut. I'm here to speak in support of House Bill 6578 and Senate Bill number 1017. As I said in my last testimony, those of us who are fortunate enough to live in this wonderful republic or representative democracy have an obligation to protect and extend the reach of the primary means of operation, namely the ballot. And HB 6578 takes a vital step in that regard by codifying into law the automatic voter registration at the DMV, and I applaud that. But as you know, there are many in our state, particularly the elderly and the poor, who do not drive. And therefore, I think it's imperative that we expand AVR to Department of Social Services, Husky, Access Health, Access Health Connecticut, state colleges and universities, as well as other well-regulated state universities. It's important to note that the addresses provided to these agencies are essential to the people filing them because they get their benefits, their payments, their grades, and everything through those at those addresses. So we know that they have an intrinsic interest in keeping those accurate and up to date. Their use also enhances the security and integrity of the elections by automatically delivering the most accurate residency information to cities and towns and eliminating outdated and inaccurate duplicate address tracking. A study, which I included in my written testimony, shows that reliance on things like postcards and things often unfairly disenfranchise voters, whereas these systems will reduce that error. I'm also supporting SB 1017 because it codifies the use of secure drop boxes for absentee ballots. As others have noted, a mail ballot passes through many hands. It's difficult to track and may be subject to delays. These boxes are at least as secure as a street side mailbox because they're right in front of a town building and they're emptied daily. And they're certainly much more secure than putting it in your personal mailbox outside your house. The only way that the chain of custody would be more secure is if you went into the registrar's office and personally handed it in. But you can only do that during business hours. So I would say that both of these stipulations do two things. They expand access to the vote and they enhance.
Your 3 minutes is now over.
They enhance the security of the election process. I thank you for your attention.
Thank you, Mr. Coburn. Senator Haskell, the floor is yours. Your hand is raised.
Thank you very much, Mr. Chair. Mr. Coburn, thank you for your testimony. I was especially interested in your suggestion that automatic voter registration would increase the accuracy of our voter rolls. We've heard a lot about that in the course of other committee meetings. The fact that voter rolls in Connecticut are imperfect. I don't think anybody claims that they're perfect, but I wanted to just give you an opportunity to mention, to explain how this has worked in other states, and if it has been the experience that where there is automatic voter registration, that voter rolls are generally more accurate. In addition to being a more inclusive voting procedure, it's actually a voting system with more integrity. Is that your understanding?
That's my understanding. The study I cited, which you can see in my written testimony, actually took place in Wisconsin, where they don't use automatic voter registration. And they found that at least 4% of the people whose names were stricken from the rolls by what appeared to be duplicate addresses or changes of addresses were in fact still at their given addresses. They were denied the right to vote or had to go through hoops to vote. And also that those primarily affected minority voters. So this, as I say, the system of using other mechanisms where a person has a vested interest in giving the state their accurate contact information, so otherwise they won't get their medical reimbursement check or their college grades or whatever it may be, is a much more accurate way. It also reduces the burden on the local registrars having to run around and look at all different files and, you know, different ways to try to verify the addresses. So I think it is not, as I said, it's not only more inclusive, it's also more efficient and more accurate than the hodgepodge system we use today.
Thanks so much, Mr. Coburn. I think that's such a perspective, at least I am often guilty of overlooking. So I really appreciate that. Thank you, Mr. Chair, for the time.
Thank you, Senator. Any further questions, comments, Mr. Coburn? Seeing none, thank you for your time tonight, sir. Appreciate your advocacy. Thank you for being here.
Thank you.
Good to see you again. Up next, Brianna Shine, followed by John Erlinghauser, followed by Marcus Kors. Brianna, if you're here, please activate your microphone and your camera.
I got, can you hear me now?
We can, yes. Do you access your camera, ma'am?
I'm not sure how to access the camera.
There you go.
Is it on?
Yes, ma'am, it is. Yep.
Okay, I can't see if this is my first time doing it this way. Well, I want to thank you, Chairman Fox, and I want to thank members of the GAE committee for giving me their time today. And good afternoon. My name is Bryna Shane, and I'm a voter from Cheshire, Connecticut, testifying in favor of House Bill 6578 and Senate Bill 1017. Voting, in my mind, is a most basic and fundamental right living in a democratic country. However, it's also a privilege and duty not to be taken lightly. As a youth, I learned that people who live in certain other countries are not allowed to vote. Many have brutally fought and starved for this right and have even given their lives, including right here in the United States. I believe that eligible voters should be automatically registered to vote when they handle any transactions within the Department of Motor Vehicles or other state agencies. This will ensure our voter rolls are accurate with updated addresses in order to avoid duplicate registrations. And moreover, it will be a secure and efficient way that saves taxpayer dollars. A few years ago, a friend of mine introduced me to a Chinese American woman who also lives in Cheshire. This woman called me about a month later as I gave her my number and said she didn't know many people here and she wanted to become more acclimated. So I took her to a couple events. Then I asked her if she was signed up to vote. She said there is no such thing as voting in China and she knew nothing about Democrats or Republicans, etc. I told her about the process and its values and subsequently took her down to the town hall and she registered. Since I am a member of a party, she accompanied me to several meetings. Afterwards, she even joined after being nominated. Most importantly, she said that after signing up to vote, she got to meet many people in town and become involved in the community in a positive way. She said to me, and I quote, "I finally feel like I'm home now, and I have met so many new friends." The moral of the story for me is that voting makes people feel equally part of our society by embracing it and gives us a chance to educate ourselves about current events and even take future leadership roles in our government. During the COVID pandemic, I tried not to leave my home unless it was mandatory. For the first time in my life, I was forced to complete an absentee ballot, but I dropped it off at the town hall in the secure ballot box to be safe rather than using the mail. It made me realize that having a ballot box or the option of mailing in our votes affords everyone, no matter their age, physical status, or how busy they were, to take part in voting without having to stand in lines during the day at special times. Since voting is the most fundamental right of eligible citizens, I believe it should be made as simple and easy for everyone. That includes parolees who are transitioning into society and have served their time. I thought about this a lot because I also retired from a career of over 20 years with the Department of Correction, as well as working for the federal government. I want to thank you all for your time, and I'm available if anybody has a question. Thank you.
Thank you, ma'am, for your testimony. Seeing no question, I do appreciate your personal and thoughtful testimony for this time. Thank you. Thank you for your advocacy. Thank you for being here, ma'am.
Thank you.
Have a nice evening. Up next, John Erlinghauser, followed by Luther Weeks. I missed him earlier, followed by Marcus Kors. Mr. Erlinghauser.
Hi, thank you, Mr. Chairman.
Good to see you again, sir.
Pleasure to be with you all. And Mr. Chairman,
You've got the red on again. That's a good thing.
Hey, always. This is my official uniform since the pandemic.
Exactly.
I certainly do appreciate being before the GAE committee, Mr. Chairman and Madam Chairman, the ranking members and members of the committee. My name is John Erlinghauser. I am the Advocacy and Community Outreach Director for AARP in Connecticut, and I represent approximately 600,000 members in the state of Connecticut. I also, as I've said in the past, I'm also a former registrar of voters, having served the city of Ansonia for 16 years. AARP believes that the right to vote is among the most basic of all civic and constitutional rights, but recent elections have revealed many flaws and practices that make it more difficult for citizens to vote. These include registration impediments, long lines, lack of early voting opportunities, and the list goes on. And AARP believes policies should be enacted to encourage and promote maximum participation in the electoral process, and Connecticut should adopt registration and voting systems and procedures that expand the range of voting choices for all residents. We believe Senate Bill 1017 and House Bill 6578 would help facilitate those changes. In Senate Bill 1017, we would help continue the practice of using the absentee ballot drop boxes that we've heard so much. We feel that facilitates a safe and secure voting experience because of the pandemic, and it showed that it should continue. It was very, very popular with our members, and they have said to us they overwhelmingly support the continued use of those drop boxes. And we also support Section 10 of the bill that would allow for digital systems to apply for absentee ballots and other forms. We think that it's important to increase people's ability to access those forms without having to go and have to sign them and use the mail system if at all possible. I do want to note where we haven't testified on specific sections, we take no position pro or con. On House Bill 6578, we support codifying the existing automatic voter registration system. And as others have said, we also would support provisions that would and encourage provisions to expand its use to other agencies in the state. And with that, I will close my testimony, but I do want to just quickly comment on some issues that were brought up about the ballot boxes and chain of custody. Currently, with any transportation of any ballots, there is always a chain of custody. It's whoever the person who's the either the registrar or the town clerk designates, and there's always a chain of custody document with ballots and things of that nature. So I would say that's really a non-issue, and it's really a safe and secure way to go. So I'll close, and I'm open to any questions folks may have. And
Thank you, sir, for your testimony. Appreciate you being here again. Good to see you. See no questions, comments. Quickly, sir, when you say you're on behalf of your organization, how many members do you have again?
In the state of Connecticut, approximately 600,000 and approximately 38 million nationwide.
And so when you take a position on a certain bill, it's on behalf of those 6,000 individuals?
Yes, we do. I mean, I can't, our membership
Right.
reflects the membership, reflects the people of the state and the demographics of the state. But we speak on behalf of our entire membership, and our policy is uniform throughout the country on issues like this. And we support these same changes nationwide where they don't have them. And we fight against the changes in other states where they're rolling back voting access as well.
Thank you very much. Thank you for being here, sir. Good to see you again. Thank you.
Thank you, Mr. Chairman. Appreciate your work.
Have a nice evening. Up next, Luther Weeks, followed by Marcus Kors, followed by Shannon Lane. Mr. Weeks.
Hey, chairs and members of the committee, my name is Luther Weeks. I have submitted testimony on 4 bills. I will be speaking on SB 759. For SB 759, I'm speaking for secular Connecticut, represent the interests of the 42% of Connecticut voters that are non-religious. SB 759 would create a commission to recommend removing all gendered language from the Connecticut Constitution. We applaud that. Yet the scope should be enlarged to remove all unconstitutional religious language or religious privilege from the document. The Constitution state is so nicknamed because of the 1639 fundamental orders, which established Connecticut from its first line as a theocratic state based on white male congregational privilege. Today, the US Constitution and most citizens reject white male or religious privilege declared in the fundamental orders. Today, the Constitution of Connecticut is not consistent with the US Constitution and our current understanding of gender equality and inclusion of all, no matter their beliefs or non-beliefs. Let me get to another page here. Sorry. Connecticut has often been a laggard in updating our Constitution. Recognition of equal rights for non-white men passed in 1876 lagged the 15th Amendment by 6 years. In retrospect, that was responsive. It is 101 years since women gained equal rights, yet our Constitution still implies that the governor must be male. 101 years. It's past time to start the process to correct that. It is 153 years since religious freedom was extended to the states, yet our Constitution still begins by crediting God for our free government. 150 years. It's past time to start the process to correct that. I assert any young person or respected scientist that is contemplating a job offer in Connecticut would conclude that Connecticut is not a welcoming place for anyone not religious or not Christian. 150 years since religious freedom was extended to the states, our Constitution requires General Assembly members to take a religious oath. In fact, 60 years ago, in 1961, the US Supreme Court ruled that was unconstitutional. It's past time to start the process to correct that. In summary, it's time indeed, way past time, to make the Constitution state actually constitutional, gender neutral, and religion free. I also recommend the committee review my expert testimony on HB 6575 and that of my friend, Professor Philip Stark. Even though we do not agree on all recommendations for Connecticut, I encourage questions today, or as HB 6575 moves forward. Thank you.
Thank you. Thank you for your testimony. Are there questions or comments from members of the committee? Thank you, Mr. Weeks, for your testimony today and for always being such a strong contributor to the work of this committee. Thank you very much.
You're welcome.
Next, we will hear from Marcus Kortz. Excuse me if I'm saying that wrong, to be followed by Mark Bernacki, who will be followed by Shannon Lane. Is Marcus with us?
I am, and you pronounce it perfectly.
Great. Welcome. The floor is yours.
Thank you. Hello and good evening, Senator Flexer, Representative Fox, and distinguished members of the Government Administration and Elections Committee. My name is Marcus Kortz. I am currently a UConn School of Social Work graduate student and a resident of Southington. I am here today in support of HB 6578, an act concerning participation in the electoral process. And I speak today really focused on restoring voting rights to individuals on parole. And I'm here not just as a citizen, but as an individual who's worked in corrections for over 6 years, witnessing firsthand the inadequacies of our criminal justice system in fostering rehabilitation, supporting reintegration, and preventing recidivism. Beyond my personal experience, there's a plethora of research on the benefits of electoral participation. In particular, a study conducted at the University of Pittsburgh found evidence that individuals that had assistance with restoring their voting rights and voter registration had increased trust in the government, the criminal justice system, as well as reported an increased willingness to cooperate with law enforcement. Voting not only lays at the core of American values, the right to self-determination and the right to a voice in government, but it serves as a fundamental act of civic duty. Voting isn't just our right, it's our responsibility. We grant individuals parole to provide them with a supervised, structured, and supportive mechanism so that they can most successfully reintegrate back into society. We expect them to stay out of legal trouble, obtain housing, get a job, and pay taxes. We expect them to be productive members of our community, yet we deny them the most fundamental of American rights, the most sacred of civic duties, the act of voting. By passing this bill, Connecticut will be taking a step forward in joining the 18 other states and the District of Columbia, including the rest of New England, that has restored parole voting rights, regardless if their fees are paid in full, restoring a basic tenet of democracy, and ensuring that all of us have a voice in our government and representation. Lastly, I urge you to support this bill because without it, further harm and injustice will come to communities of color, where 1 in 6 Black Americans can't vote due to felony disenfranchisement, compared to 1 in 59 non-Black Americans. I appreciate the opportunity to speak to the committee today in support of HB 6578, a bill which would restore voting rights that rightfully belong to all citizens of Connecticut.
Thank you for your testimony. Are there any questions or comments from members of the committee? Seeing none, thank you again for your testimony. Okay, we are trying to keep in order here and to run this committee as efficiently as possible with people popping in and out. I know that I said that Mark Bernacki was going to be next, and he will, and then Mark will be followed by Shannon Lane, who will then be followed by Sherry Quickmeyer. I will ask if Rhonda Caldwell is here, and then after Sherry would be Rhonda, and then Jeff Berger. So Mark, the floor is yours.
Great. Thank you very much, Senator Flexer, Representative Fox, Senator Sampson, Representative Mastro Francisco, and all the distinguished members of the GAE committee. My name is Mark Bernacki. I am the New Britain Town and City Clerk, and I'm also the chair of the Connecticut Town Clerk Association Legislative and Elections Committee. I'm here to testify on HB 5011. I'd like to thank the committee for working with the Town Clerks Association in exempting land records from this proposed bill. CTCA also supports the change in definition to catch up to the modern technologies that we have when it comes to scanning or taking images with an electronic device. The pandemic had a significant impact on all of our town clerk offices. Our traditional business model from walk-in was rapidly converted to walk-up or by appointment or by email. So we greatly had to rely on digital technologies. With people also working from home during the pandemic, the public demanded more 24/7 access with a lot of the data that we hold in the town clerk's office. In addition, you probably read in a lot of the news articles that from the mid-2020 to the present, the home sales in Connecticut went through the roof. But there were no interruptions or delays in closing of real estate. People were freely able to buy and sell homes utilizing the services of the town clerk's office. The only way we were able to continue the free flow of commerce and property transfer was the offsite 24/7 access to land record images for the searching public. And I know there's another bill that's up in front of you that another town clerk will testify on later this evening regarding that. While town clerks supposedly make it look easy, a great deal of resources are required to make this happen. Copy fees for land records help since a great deal of resources are required to create and maintain a robust digital infrastructure to ensure people can buy or sell their home. We again thank the committee for working with us over the last couple of years. I know Representative Winkler had a lot of questions for me over the last couple of years, and hopefully this is a good compromise for everyone, and we support the exemption of the land records. And with that, I'll open up for any questions that you might have.
Thank you for your testimony. Are there any questions from members of the committee? Seeing none, thank you again for your testimony and thanks for your work with us.
Great, thank you. Hopefully it's not too late of a night for you.
Remains to be seen. Thanks for the good wishes. Next, we will hear from Shannon Lane, who will be followed by Sherry Quickmeyer, who will be followed by Jeffrey Berger.
Hi, thank you, Senator Flexer, Representative Fox, and committee members. It's good to see you all. And I am testifying, as I did last year, in support of legislation, including SB 753 and 5318, that would expand rights for convicted felons who are on parole and count them. I also am testifying on behalf of my good friend, Tanya Rhodes-Smith, who's the director of the Humphreys Institute for Political Social Work at the University of Connecticut. She was scheduled to testify earlier today and was receiving a national award for the work that she does in this area at the exact same time that she would have testified. And together, the work that we've done at the Humphreys Institute and the work that I do as a professor at Wurzweiler School of Social Work, I think emphasizes how important this issue is for us in Connecticut. The work we do at Humphreys examines voting as a social determinant of health. We believe it's a human right, and it's a powerful tool for shaping public policy. Voter participation, you all know, is essential to a strong democracy and a democracy that represents and responds to the needs of all citizens. One of the big challenges with felon disenfranchisement is that these laws are rooted in the structural racism that's built into our democracy. And even statutes that are race neutral in their language were written at a time when the explicit purpose was to deny people of color, and specifically African Americans, the power to vote. And we can see that disproportionate impact continue today, including in many cities and towns across the state of Connecticut. As I think you all know, our voting laws for those with felony convictions here in Connecticut are the most punitive in New England. Tanya and I wrote an article that I've hyperlinked to in my testimony that argues that actually we should go farther than this bill, and we should allow people who are currently serving their sentences the right to vote, which currently happens in Vermont, Maine, and DC. It was raised earlier that, you know, part of the point of a prison sentence is to punish people. And while certainly that's true, part of the purpose of a prison sentence is also to help people to rehabilitate and reintegrate into society. And we have the research to know that giving people access to their right to vote is an excellent way to help them reintegrate into their communities and help them decrease their rates of recidivism, which benefits not just the people who are allowed to vote, but it benefits all of us in the state of Connecticut. Similarly, the rules that we currently have, where people who are prisoners are counted for purposes of electoral power in the cities or towns where they're serving their sentences, really dramatically impacts our towns and cities that they would be in, and that will need the resources to support them when they reintegrate them into the community. One question that was raised earlier was what we should do with people who are from out of state, or if we're not sure where they lived before they came into the correction system. And I would actually recommend a look at the statute in Virginia, which has specific outlines for what to do if we're not able to find out a person's specific residence. And I think that kind of statute can help us bridge the gap between, you know, an ideal system and living in the imperfect world of information we have available. I'm also the Deputy Registrar of Voters in Bethany, Connecticut, and so I also wanted to add my support for
Your 3 minutes is now over.
And HB 6578. We've seen a lot of ways that as a state we can improve access to the right to vote in our elections administration, and these bills both take us in that direction. Thank you so much for your time.
Thank you, Dr. Lane, for your testimony. Are there any questions or comments from members of the committee? Representative McCarthy-Vahey.
Thank you, Madam Chair, and thank you, Shannon, for being here. And I also appreciate you recognizing Tanya Rhodes-Smith. And yes, sometimes the timing does work out that way with these, but I appreciate that both of you are lending your voices to this important work. Thank you very much, Madam Chair.
Thank you, Representative. Any other questions or comments? Seeing none, thank you again for your time and your testimony today.
Thank you.
Next will be Sherry Quickmeyer, who will be followed by Jeffrey Berger. And I would just ask folks that are waiting for their turn to testify. We're just about to finish the people in the 30s. We'll be moving on to number 40. So if you have a number in the 40s, please get ready. A number in the 50s, please get ready, because the quicker you log into the meeting, the more efficiently we can run the meeting and make sure everyone gets their turn in accordance with the order that was chosen by the lottery. So with that, thank you, Sherry. Welcome. The floor is yours.
Thanks very much, Senator and Representative Fox, ranking members Sampson and Co-Francesco. I very much appreciate the opportunity to be here today to testify. I'm Sherry Quickmeyer. For the record, I'm the Executive Director of Common Cause in Connecticut. We're a nonpartisan, nonprofit citizens organization that works to improve the way that our government functions. We have more than about 1.5 million members nationwide and about 15,000 members here in the state. So I'm, very happy to be able to talk about these 5 bills. And I did submit written testimony. I don't know if it's up yet on these 5 election-related bills. And I submitted separate testimony with my board chair, Bilal Siku, on the whole issue of prison gerrymandering, Senate Bill 53. So I will start there that in fact this bill, an act concerning the counting of incarcerated people for the purposes of determining legislative districts, has been spoken about a number of times already today. And I would like to associate myself with the comments that were made, especially by, I believe her name is Patricia Rossi from the League of Women Voters, and also with what Ms. Lane just said. And this bill is the most recent iteration of proposed languages that I've been aware of since the early 2000s, and it is still legislation related to the shameful abuse of incarcerated bodies. And we absolutely let lawmakers inflate the population of their districts and to give places with prisons more representation. And those numbers were detailed earlier. But politicians elected in those gerrymandered districts can, ignore their incarcerated residents. People will leave their place of incarceration, and most of them return home to what they consider home, which is where they came from. And that's where we should be counting people. So there's more, more language in another testimony. Senate Bill 1014, the election monitor for the 2021 municipal election and 2022 state elections, is an important piece of legislation that was brought forth by concerns that residents of a number of cities have had. The bill is very specific to the population of the cities that are impacted, and it's very specific to how long.
Your 3 minutes is now over.
So that should absolutely be supported. 1017, absolutely. We need to make the absentee ballot boxes permanent. It's a national response to the great success we just had. And finally, 6578, which is really about participating in the electoral process. This will AVR, automatic voter registration, is the absolute standard we should be trying to achieve. We should do it beyond the Department of Motor Vehicles. That should be codified, and then we should expand, as other testifiers have already said. We need to incorporate as many people as possible into being registered. It will clean up the rolls, it will save the city's money, and this is just absolutely essential. And restoring the right to vote to people re-entering our communities on parole is another absolutely critical thing to do. Otherwise, we are the only state in the region that prohibits people from casting a ballot. Felony disenfranchisement laws have been around since after the Civil War.
I'm sorry, I really need you to summarize. Okay, thank you.
But thank you.
I went way too long. Thank you for your testimony and thank you for your time with us today. Are there any questions or comments from members of the committee? Seeing none, thank you again for your testimony.
Thank you.
Next, we will hear from Jeffrey Berger, who will be followed by Rhonda Caldwell, and who will be followed by Stephen Karp. Welcome, Jeffrey.
Good afternoon. Good afternoon, Senator. Good afternoon, House Chair Fox, ranking members and members of the committee and former colleagues. My name is Jeffrey Berger. I am a State Properties Review Board member. By the way of experience, I have 40 years of real estate experience in the private sector, and I am retired 8 years from the General Assembly representing the 73rd Assembly District. I'm here on behalf of the board and its chairman and staff to raise opposition to Senate Bill 1015 and also to speak in support of House Bill 6577. The legislature established this bipartisan independent board in 1975. I am here to express opposition for Senate Bill number 1015. I also have on the screen board director Dimple Desai and staff Tom Jarrett. According to DAS, the purpose of this bill is to clarify the State Properties Review Board scope and standard of review, and to raise the threshold for review of construction consulting contracts. However, this bill is to minimize and restrict the board's authority given by the legislature since 1975. You all have my testimony, so I will consolidate in the interest of time. Section 6 in opposition, the language proposes as it relates to commercial properties is very narrow and only focuses on DAS construction service projects. The board reviews diverse proposals from various state agencies. This is a clear attempt to restrict the qualifications and expertise of the board members. Section 7 DAS is proposing changes to limit the original intent of the legislation, which provided the board with a broad review authority as the only independent authority in DAS CS resulted in $0.7. This represents a $600 total operating budget. Section 8 increases the threshold of board review of consultant contracts from 100 to 500,000, which will substantially diminish meaningful oversight of consultant contracts and potential savings to taxpayer dollars. For example, from 2017 to February of 2020, the board reviewed 235 design professional contracts with a total value of $289.3 million. If the threshold was 500,000, the board would have reviewed only 41 contracts, a decrease of 82%. And just quickly, in support of 6577, the board is housed currently in DAS for administrative purposes, and the deputy commissioner had proposed testimony that SPRB, our board, is part of the executive branch. In fact, we are an independent board, which is incorrect. We are an independent board, and we are created by the legislature. Also, the Commissioner of Agriculture had stated that our review has slowed the process for them. We have found that, an example, FY 2020, it took the board 22 calendar days to review proposals compared to 153 calendar days for DAS and DCS. Currently, we've saved on purchases of agricultural land, community farms. Just as one example, one farm was appraised for $800,000. After review of the board, the appraisal was reduced to $610,000, which resulted in a $53,000 savings to the taxpayers. So again, you have my testimony, Madam Speaker, Madam Chairman, and if there's any questions by committee members, I'd be happy to answer.
Thank you very much, Mr. Berger. Good to see you again.
Great
So
seeing
any
you.
questions or
You're looking
comments
great.
for Mr. Berger, or Mr. Desai? Can I ask a few questions, Mr. Berger? Or Mr. Desai, for whoever you deem as appropriate to answer these. The first question I have, what is the relationship between DAS and the SPRB now? By really, I don't mean like, are they friendly or not, but what is there an underlying relationship of some sort for services provided or anything between DAS?
You know what? Yeah, and thank you for that question, Mr. Chairman. Certainly, and the director can also respond, but certainly DAS is the board is independent of the executive branch. We are just housed in DAS for administrative purposes. We are a review board. We have saved, it's not a board that slows the process, Mr. Chairman. We get proposals and turn them around in 20 to 30 days. So anything that's contrary to that is false and information to committee. Certainly our relationship is professional. Our board members are more than qualified. And it was a little bit insulting to hear the commissioner testify that committee members aren't qualified or have the qualifications. We have a staff member, Tom Jerm, that has 40 years of appraisal experience. If you want to include myself, between the legislature and real estate in the private sector, I have 40 years. There's multiple members that have enormous amount of experience. So I think it's a little insulting, so to speak, to have to hear that. So with that said, we're an independent board, Mr. Chairman. We save the taxpayers millions and millions of dollars over the course of our inception by the legislature. And I think it's appropriate that we probably be moved. Originally, the board was at 165 Capitol Ave and operated independently as dictated by state legislature and the legislature and its appointment process. So I think there's a conflict because we review DAS and DCS proposals, and we're housed in the same building, and they still believe that we're part of the executive branch under their authority. So, you know, I think that's incorrect, and by us moving, I think it'll appropriately create a division.
Okay. What I asked the DS representative if the threshold is changed $500,000 as they propose, number of the workload that might be impacted. Do you have any information on that? He said he gets. Do you have any information on that between you proposed 25,000, he proposes 500,000? There's a wide gap between those two numbers. Do you have any information as to how this might work in caseload or the change might impact?
Yeah, as far as the Senate Bill 1015, their proposal is to reduce from 100 to 500, which would substantially diminish the board. I guess if we could give you a time frame from 2017 to 2020, again, the board reviewed 234 design professional contracts with a total value of roughly 290 million. If the threshold was reduced, or increased to 500, the board would have reviewed only 41 contracts, a decrease of 82.5%. So it's a substantial move.
And with that, and in their proposal, not only are they requesting a change in the dollar number, but the change of being just an objective reasoning, so that would not only cut your workload significantly, cut what you do, would cut your ability to review something if their bill passed. Is that correct?
Yeah, no question, Mr. Chairman. It's important that the board, as it was created, has independent review status. Look, we're seeing talk in the legislature now on the State Contracting Review Board and giving them additional authority and oversight. You know, how in good conscience can the legislature decrease the authority and oversight of the State Properties Review Board, and in the same token want to increase the State Contracting Review Board process? You know, I think that both of they handle bidding, we handle contracts and leases. We work in tandem. We should be given the exact authority or more authority and housed as an independent entity.
Thank you. And any indication or insight to provide, the DAS commissioner has seemed to indicate that the relationship with the Department of Agriculture has gotten better, improving, been working those matters very efficiently. Whereas with DAS, it doesn't seem to be as agreeable at the moment. Any ideas why, or suggestions as to why?
Yeah, yeah. Thank you, Mr. Chairman. I mean, I don't understand where that comes from, but I do know this, that when the commissioner, in all due respect, speaks of the legal representation that our board receives under our placeholder status with DAS, we are supposed to receive legal advice from the legal staff there to help our board in its process and in reviewing. We get no review from them. In fact, Senate Bill 1015 was drafted by their legal staff, which decreases our authority. So, it's not a good fit for us.
Mm-hmm.
And for the watching over of taxpayer dollars.
Okay. Mrs. Desai, do you have any comments like that, sir?
Thank you for the opportunity. Yeah, I think one of the comments made was the board is not qualified. As Mr. Berger said, I'm a civil engineer. I have 30 years of experience. I have worked at various departments. I've been employed with the state for last almost 30 years. I work at DECD, managing hundreds and thousands of dollars worth of projects. I was at OPM for 5 years. I have legislative experience as well. So, and my staff, who is Tom Jerem, he's a certified commercial appraisal, and he's also qualified. So to say that we are not qualified and they have to explain to us contract 101, that's not correct. And I personally take it as an insult to my experience. And just to answer, I think we are qualified. For example, for Department of Agriculture's one of the proposal, as Mr. Berger referenced, because of the board and staff review, the appraiser had to change the method of appraising that particular farm. There was a flaw in his assessment. They came back and he revised his assessment, and the price went from $810,000 to $690,000. So that is after, as you heard from department's commissioner, after everybody reviews. They say that we have people who are reviewing these proposals again and again, and there is an oversight. After all this oversight, the board brought up and they found an error. So I think that just shows, I can give you examples after examples for any agency, for DCS, for DOT, for agriculture and others, and show the good work that the board does. And I think the board is exactly doing what the legislature had intended since 1975, and that is to provide independent oversight without any third-party indulgence. And our record shows from 75 that we have saved about $86 million over the years since 75. And compared to, I believe it's, let me just give statistics. We have saved 86.75 million in savings compared to 14.34 million in operating budget of the board. So that is 605% in savings. Now, this savings cannot come if DCS and other agencies have to teach the board and the staff contract 101. I mean, that is, that statistics speaks for itself. I mean, we don't have to tout our own, what we are doing, our statistics, and we have been submitting these reports to the legislature and the governor on an annual basis since, for last 30, 40 years. So I believe, I think by expanding the, the role and reducing the 100,000 threshold to 25,000 threshold, there is a huge potential of additional savings that the state can realize. And what happens, and I heard you had asked the commissioner a question about scope of work. I personally review the scope of work. We go through line by line. We look at the contract. We approve the contract. When an amendment comes in for additional funds for particular architect or engineer or construction administrator, we go back to the original contract and see what services were paid for. Are these new services, additional services warranted? We check that. Now, are these services result of contractors' performance issues? We check that. Because if it is result of contractors' performance, states should not be penalized for those extra costs. Same thing, is this related to architects, engineers, errors and omissions? Did they not design it properly? And if that is the case, we should not be paying, the state should not be paying for those costs, for additional costs. So I think we do review legitimately on like scope of work and everything. And as you heard, they just want to have a checklist. Did they issue RFP? Check. Did they invited bids? Check. And I think that's what they want to bring down the responsibility of board to, just checklist.
Okay.
Mr. Chairman, if I could just add one other point on our bill 6577. There is some language in there that relates to the quasi-governmental and potential oversight that the legislature may or may not pursue for contracting review board, and potentially the role that SPRB could have in more oversight of the quasi-publics. So there's language for the committee members to read. Thank you.
And Mr. Chairman, if I can just add, so I also work for DAS facilities management. So I'm also director of facilities management for DAS.
Okay.
So just to give you an example of the experience.
Understood. Thank you both for your testimony. See no additional questions. I thank you for being here tonight. Thank you for your patience with the committee. Look forward to working with you in the days ahead.
Thank you.
Thank you.
Thank you. Up next, Rhonda Caldwell, followed by Stephen Wednesday Karp, followed by Sue Larson. Ms. Caldwell.
Hi, can you hear me?
We can, yes. Yep.
Okay, great. Good evening. Good evening, Representative Fox and Senator Flexer and the ranking members of the committee here. I'm Rhonda Caldwell from Hamden Action Now. I am a lead organizer down here demanding equity and justice for Black, Brown, and Indigenous people. I'm here in support of SB 753, the act regarding prison gerrymandering, and HB 5318, restoring electoral privileges to those that are exiting incarceration, and most of all, HB 6578 to extend automatic voter registration beyond those that are dealing with the DMV, but those that have any interactions with state agencies. While HB 6578, but this legislation, all three of them all basically are working together in concert with each other. I think the one I want to really speak on more really profoundly tonight is HB 5318, the restoration of electoral privileges, because I heard earlier this morning, this afternoon, from various members of the committee that they were really saying that they didn't want to restore these rights to folks who had already returned to the community because they felt like they needed to be punished further. And a form of punishment was that they were not allowed to vote, yet that they had fulfilled their time, but they were still had duties to the parole board. Well, let me just say that these folks are now working in the community, paying taxes, and a part of the society. They're actually out. Yet there are many that believe that they should still be punished for preventing them from participating in our democracy. My 12-year-old said to me, and it didn't even make sense to her, she said, "Isn't this a civil right? How could you punish somebody by taking away their civil rights?" I told her, I said, "I don't know, but let's find out. Let's talk a little bit more about it." A state that determines that, we want to incarcerate, but we want to continue to punish people once they return by denying them participation in the election process is really quite a travesty, considering the blood that was shed for this sacred right, and that we feel that we should continue to pay even after they return back to the community. I mean, everybody knows the blood that was shed for Black and brown people to have this right. And the blood that shed, the lynchings that took place. Yet and still, the state of Connecticut has people sitting in legislative position that think that they should continue to be punished after they leave prison. Preventing them from participating and continuing and not allowing them to participate in our democracy is not founded in our Constitution. Our Constitution was not founded in punitive voices saying that one voice deserves to have a right to vote and select their legislation and one doesn't. Just in closing, I just wanted to say briefly, to continue to punish formerly incarcerated people when they enter into the community, you're punishing the entire community. Their children attend public schools. They have no voice to speak on their Board of Education. They pay property taxes. They have no voice to speak on behalf of their town and mill rates and things as such. So when you want to punish them, you punish the entire community. I want everyone on this committee to choose democracy over punishment today. Thank you.
Thank you, Ms. Caldwell. Any questions or comments for Ms. Caldwell? Seeing that, I appreciate being here today. Thank you for sharing your testimony. I appreciate your advocacy. Thank you for being here. Up next, Stephen Wanski's Carp, followed by Sue Larson, followed by Kim DeCarlo.
Good evening, members of the committee. My name is Stephen Weinstein Karp. I'm Executive Director for National Association of Social Workers Connecticut chapter, representing over 2,300 members. NASW Connecticut does not believe we should take away the rights of people to vote. This is what makes our nation, our state, a democracy. We really should be looking at parolees and saying, how do we help them reintegrate into the community? How do we help them to return as a good citizen? One of the ways to do that is to allow voting. Voting gives parolees a voice on the people who are going to represent them. It gives them a voice on who is elected, and it gives them a voice on what those policies may be from individuals who have elected them. Denying voting rights is an unnecessary and punitive measure that serves no positive outcomes. Denying voting rights can be psychologically detrimental to the parolee. It impedes re-engagement with the community, and it denies parolees the right to participate in the electoral process that both directly and indirectly impacts on their life. Parolees deserve to have a say in who represents them. One thing that we didn't hear, at least I have not heard someone mention, is in lines 42 and 43. It talks about the Office of Adult Probation. So, and this is in both parolee bills, adult probation within available appropriations. I mean, to me, available appropriations and excuses not to do something. We see no cost in the Office of Adult Probation telling parolees that they have a right to vote. I mean, parolees have a caseworker, have a parole officer. The parole officer can inform them verbally, they can inform them by an email. Where are the costs in that? It looks to me like they just don't want to do it. They don't want to tell people that they have new rights. We do notice that between the two parole bills, that 5318 does require individuals to pay all fines before they could vote. This is sort of like a poll tax. It would surely disadvantage lower income individuals who may not be able to afford those fines, where 6578 does not include that. So we surely prefer 6578. We also support 1017 in terms of ballot boxes. I know my wife and I use these, that we had not heard of any problems. This is a wonderful way to allow people to vote. It will reduce lines at the polls. It makes it easier for people to vote, and they are very much secure boxes. Municipalities have spent the money to put these boxes up for the 2020 election, it seems like it would be almost silly for us not to continue to utilize the ballot boxes. Again, we encourage you to vote in favor of parole. And one final thing we do want to say is electronic voting through DMV, registration through DMV electronically. We live in a world of electronic commerce. The idea that somehow we cannot arrange for people to vote, or I'm sorry, to register to vote electronically really seems to us pretty backwards in 2021. So we certainly encourage that part of the bill. We
Your
also would
3
like
minutes is now over.
and let me just summarize by saying we'd also like to see other state agencies be able to do the same in terms of electronic registration. And I thank you for your time this evening. I'll take any questions if you have some.
Thank you, sir. Any questions or comments? Senator Flexer.
Thank you, Mr. Chair. I just wanted to apologize for misstating your name earlier, Stephen, and thank you for your testimony.
Thank you. It's a tough one.
Seeing no further questions or comments, thank you, sir, for being here tonight. Appreciate your time.
Thank you.
Next, Sue Larson, followed by Tim DiCarlo, followed by Alex Kajstura. Number 42, Sue Larson.
Okay, hold on. All right, thank you very much. Good evening, Senator Flexer, Representative Fox, and members of the GAE. My name is Sue Larson, and I'm the president of ROVAC and also the Registrar of Voters in South Windsor, and I'm here to speak on SB 1017. There's several sections that I'd like to talk about. The first one being including absentee ballots in the audit that we perform after every election and primary. And ROVAC is definitely in favor of being able to do that. Our concern is making sure that the rules are set for us to be able to do that. Every town does things a little bit differently simply because of the size of their town. You have a small town that does their absentee balloting in the polls. It's going to be very easy for them to just include the absentee ballots when they bring the tabulator to Hartford, or they do it manually. Cities, on the other hand, or your larger towns, have multiple tabulators. So will the Secretary of the State define it as tabulator A, which includes districts 1 through whatever, or are we going to be bringing all the tabulators up to Hartford, or considering leaving them in our polling places and having to do them manually? The other issue that we had was in some of the earlier discussions was to consider this a polling location. Well, that means statutes are going to have to change in order to define what a polling location is, because currently it's defined as a moderator, 2 assistant registrars, the checker, the ballot clerk, the tabulator, tender. But you're going to have to change it so that it's modified to include what is in an absentee ballot counting center, so that it's looked at completely differently. And also you have the 75-foot signs. You've got, who can be present inside while they're doing the counting of absentee ballots. A lot of things to consider. So we look forward to trying to straighten things out and clarify exactly what can be done to make sure that the ballots in the election is transparent. Allowing the Secretary of the State to suspend supervised absentee balloting is very critical. I know South Windsor is in the middle of a referendum. It's going to be next week. The executive order by the governor only went so far as to consider special elections and not referenda. So we are now caught between pre-pandemic and pandemic, and struggling on how to make sure that those in the assisted living facility are still able to vote in this referendum, but yet keep them safe, keep us safe. So had the Secretary of the State been able to suspend it,
is now over.
we would be in a better position. May I just have 1 extra minute?
Yes, please summarize and proceed.
Thank you. I'll be quick. I usually try and be very conscious. Okay, redistricting is coming up, And we are very grateful that the Secretary of the State wants to step up and help us with that, because if you look at some of the maps that are given to the towns for the registrars to put our redistricting plans together are very confusing. You've got one house that shows up in one district, the one next to it is another district. And so, if you don't have a very good GIS system, and not all of our towns do, it's very difficult. And then the last thing I want to say is registrars have lots of forms that we would love to not have to provide wet signatures that are under statute. So if we can get this accomplished, it would be fantastic. So thank you very much.
Thank you, Ms. Larson. I always appreciate your time and testimony. Question or comments? Seeing none, good luck with the referendum next week. Senator Flexer, I'm sorry, Senator Flexer.
Oh.
Thank you, Mr. Chair. Good evening, Sue. Thank you very much for your testimony. In this committee, we are doing work around, how do we manage the next couple of weeks, the next couple of months, or whenever the pandemic is over. And we're having conversations in this committee and also in the Planning and Development Committee. We're lucky that Representative McCarthy-Vahey is here on this committee and serves as chair of P&D. Can you just tell us a little bit more about that situation in South Windsor with regard to the referendum? There's a lot of communities over the next several weeks that are going to have that same situation, and I'd love to just get your counsel on what we should do to cover those situations in the weeks moving forward, because while there are a lot of vaccines out there, it's still only 10, 15, 20% of people if we're lucky in the next couple of weeks.
Well, the first thing is it would have been great if the governor had done an extension of that executive order in order to include referenda. They haven't. So we've been struggling to try and figure out how do we make sure that all of these the residents still have the opportunity. So we work with the individual assisted living facilities in working with them, trying to figure out what's the best way. We've been dropping off absentee ballot applications, picking them up, bringing them the ballot, picking them up. We've been, talking with trying to work as best we can with each, because we have 3 facilities with the 4th opening up on next month, in working to make sure that every single person has their opportunity to vote in the referendum. The problem we have is trying to work within the guidelines of supervised absentee balloting and the COVID guidelines, because we have to go to the assisted living facility. We have to maintain 6-foot distance, but at the same time, we're told, why don't you deputize the employees to help them out, because they deal with them every day. We can't do that because it's in the statute that you can't do any of the employees. So it's been difficult. And we're trying our best, but we will assure everybody that if they wanted the right to vote in the referendum, they've been given that right. We've been working very hard.
Well, thank you. Thanks for sharing that with us this evening, and thanks for highlighting the issue overall. Thank you. Thank you, Mr. Chair.
Thanks, Senator Flexer. Seeing no further comments, thank you, Ms. Larson, for being here. Appreciate your time tonight.
All right, thank you.
Up next, number 43, Tim DiCarlo, followed by 44, Alex Testera, followed by number 45, Helen Humphreys. Mr. DiCarlo.
Hello, thank you. I'm here to testify on behalf of House Bill 6579, an act concerning statutes, voter registration, and election administration. Senator Flexer, Representative Fox, ranking members, Sampson and Master Francesco, members of the GAE committee. My name is Timothy DiCarlo, and I'm the Registrar of Voters from the City of Waterbury, chair of the New Haven County ROVAC Association, as well as the chairman of the Legislative Committee for ROVAC. This bill is a bill that the Registrar of Voters Association asked to be raised, and we thank the committee for doing so. It makes several existing changes to Title IX. The first thing that this bill would do would remove an election training unit in Title IX that has never actually existed. This is causing confusion with
extending and maintaining education hours. Removing this part of Title IX would not at all impact the 2015 bill as it appeared in Public Act, which is 15-224. And that is the current training that we have through Yukon City. This would not impact that. This bill also makes a portion, changes the way in which we would have to go in the office for registration sessions prior to an election. Back in the 80s and before, you could only appear certain times during the year to register, change your name, party affiliation, address, and then the list itself had to go out to a printer to be printed. These sessions are outdated as we are in our offices. You can register online through the DMV, several other places in which you can register. So removing this from Title IX would simply just remove a session that for purposes of printing a list that are no longer needed. This bill would also allow for the option for the town to include the 7 day prior to the election registration session on their website instead of just the newspaper. This is not a legal notice. We're not required to do this per legal notice. But many times the town will state when we're holding the hours, which is by law, and sometimes it does not make it into the newspaper. This would just only allow the option. It would not remove the newspaper. It would be in addition to. The bill also removes the Board of Voter Admissions from statutes because this is a board that is no longer in existence in any of the 169 towns in Connecticut. Finally, this bill would allow for the voter election position of tabulator tender for those to reside outside of our town. Right now, there's a residency requirement, and this is more than likely an oversight when this position was first created and when we started using election tabulators in 2005. And finally, this would make a slight change to the way in which we file our head moderator's return. We would still send the electronic moderator return directly on election night to the Secretary of State's office. But instead of mailing a wet copy up to the Secretary of State's office, we would simply put it on file locally in the town.
Your 3 minutes is now over.
I thank the opportunity for testifying on behalf of ROVAC today, and thank you very much.
Thank you, Mr. Carlo. It seems as if, based on your testimony, this is more of a, I don't want to say cleanup bill, but it's more of a makes the process a little more efficient. Updates some past practices which are outdated. Is that correct? Would that be a correct assessment?
Yes, it's nothing more than just bringing some Title IX out of the 80s and into the 2020s.
Okay, great. Any question or comments for Mr. Carlo? Seeing none, thank you for being here today, sir. Appreciate your time and advocacy. Thank you.
Thank you.
Up next, number 44, Alex Castura, followed by Helen Humphreys, followed by Judy Vila. Mr. Castura, I apologize if I mispronounced your last name, sir.
That's totally fine. I'm Alex Castura, Legal Director of the Prison Policy Initiative. Thank you, Chairs Flexer and Fox, for having me here today, and ranking members and the rest of the committee. So first, I just wanted to register our support on HB 6578, restoring voting rights for those on probation. But I'll leave that based on everybody who's spoken on the issue so far. We agree with that. And I've provided my testimony in support of SB 753, ending prison gerrymandering. And so in order to go quicker, I'll just leave my written testimony on that and continue based on everybody who's already testified on the policy issues for why it's a good idea to count incarcerated people at home. And I'll just jump quickly to the questions and issues that have been raised in terms of where people actually live. In the residence law in Connecticut actually says that you do not lose your residence upon incarceration. So whether you're incarcerated for a day to 10 years life, you legally remain a resident for representative purposes of your home district. So just legally, this law would make the way you draw the districts align with the residence law already on the books. And in terms of folks who are serving life, in Connecticut, there are about 10,000 people who are incarcerated. of those, only 75 have life sentences. So it really doesn't make sense to count everybody in the wrong place because you have a handful of people that won't be going back home. And even those handful of people remain legal residents of their home address. And you can see that this residence fact is even acknowledged by towns like Enfield. When they draw their own town council lines, they don't include the people who are incarcerated in the facilities that are in town when drawing those lines. They equalize those lines based on their town population. So they take the census and they exclude the folks who are in correctional facilities. And in terms of who's in the facilities, even if you're serving a long sentence, you're not serving that sentence in a single facility. Across the country, 75% of people move between more than one facility before being released. 12% of people serve time in at least 5 facilities before returning home. Average sentence is about 2 years. So even if you're looking at somebody who's away from home for more than a year, they're not in that single facility. So you're just choosing a random spot that they happen to be in on census day, rather than their home address, which is where they have the community ties, which are long and lasting and where they'll return upon release. And in terms of folks who you don't have addresses for, right now it's 2020, 2021 already, you're about to start your redistricting. So
your 3 minutes is now over.
Even if you pass this bill, it's going to be really quick on implementation. You're going to have to work with incomplete addresses and really get your address databases up to speed for 2030. But there are already provisions in the bill that you have before you right now on how to deal with incomplete addresses, how to deal with people who are out of state. And the 10 states who have passed laws before you already have different approaches. You all have chosen to have one of those in your bill, and I'm happy to speak to how that all pans out.
Thank you very much for your testimony. Representative Haddad, your hand is raised.
Yes, Mr. Chairman. Very briefly, I just wanted to thank Alex for the testimony, and also, the bill references a couple of dates in it, and one of them is May 1st. It says that the Department of Corrections and the Office of Policy Management need to do some of the work necessary to determine what the home addresses are of the prison population beginning on May 1st. The effective date of this act is not likely to be before May 1st. And so I wanted to raise that as just a question or a concern more for our LCO attorneys and others who are watching and listening to this public hearing, because I wanted to make sure that when the effective date is after a date that's referenced in the bill, that we still ensure that that work is happening. But I would also just say this. I think that we have an opportunity, even though it's late in the year, in a redistricting or reapportionment year, to get this work done, because I am one of the 8 legislators that have been appointed to what will be the reapportionment committee. But we also have been informed by the Census Department that they are not likely to release to us the data that will allow us to begin to draw maps until as late as September 30th. And so we have a solid 6 months of time to ensure that we can do the work that you just referenced, that will allow us to reapportion or sort of reallocate the population. But I did just want to take this as an opportunity to mention that concern about May 1st, and also just to thank Alex for the testimony and to indicate that I think that we still have time, even though we are in a reapportionment year. Sorry just for the comment. Don't mean to testify in somebody else's time, but I wanted to thank again for the testimony. Thank you, Mr. Chairman.
Thank you, Representative. Any questions or comments? Alex, if I may ask you a quick question. A woman who testified earlier, Shannon Lane, I believe her name, she made reference to a law in Virginia, I think, about individuals who I think have either passed away or maybe no, maybe they were incarcerated but not in a state which they consider their home. Do you have any familiarity with what she was referring to?
Yeah, so in, actually, if I may first address something Representative Thad brought up.
Please do,
So
yes, please do.
regarding the Census Bureau is likely to be very close to that September 30th deadline. They're unlikely to be early this year. And the Census Bureau is actually doing two things to help out the states who are doing this sort of adjustment. They will map the addresses for you, so you can give they allow you to give a special, basically they allow you to drop in a ton more addresses than you could as under normal circumstances, and they'll map them all, make sure that they all align to the census geographies. And they're also going to be publishing a special table along with the usual redistricting data. So there'll be table 5 there, P5, that'll have the correctional facilities listed in them. And then regarding the Virginia statute, yes, they chose a different approach than is written into the Connecticut statute. What they're doing with folks who have unknown addresses and folks who have addresses out of state is they're going to count them at the location of the facility. What Connecticut has in the statute, in the bill as currently written, is they'll be counted in a separate geography. So it'll be kind of a geography that's not tied to any specific place in Connecticut. So essentially they'll be counted at large. So they won't go back to any specific district.
Any idea in Connecticut what numbers we're looking at for that let's say that population that we have as any idea ballpark in terms of number of people?
People who are not Connecticut residents would be relatively few. Honestly, the biggest problem would probably be incomplete data, which will then go to how much time you have devoted to the data cleanup. The simplest of these things is, you have somebody at 123 Main Street and it's actually 123 Main Avenue. And those kind of things are pretty easy to clean up, but it does take some time. Out-of-state numbers should be fairly low. But I'd expect successful matching of the data to be around 70–80% if it's done on this time frame.
Okay.
But I definitely consider that a success, and definitely way better than counting everybody in the wrong spot.
Yep, understood. Thank you. I did appreciate the comment you made about Enfield. I was not aware that Enfield counted the municipal district. That's interesting to hear. So thank you for bringing that to our attention. Any other questions or comments? Seeing none, thank you for being here tonight. Appreciate your time and testimony. Thank you. Next, Helen Humphreys, followed by Judy Villa, followed by Sam Monica Friedland. Helen Humphreys.
Thank you very much, Chairman Fox, Chairwoman Flexer, ranking members, and distinguished members of the Government Administration and Election Committee. Thank you all allowing me to speak today. My name is Helen Humphreys, and I'm the Communications Coordinator for Connecticut Citizen Action Group. CCAG and its members support a number of bills that are part of this hearing today, and our Executive Director, Tom Swan, will speak on another bill as well later on. But due to time constraints, I'm going to focus on 5 bills, all of which make our elections more accessible and accountable for all Connecticut residents, not just those in a position of privilege. First, SB 753, concerning the counting of incarcerated persons for the purposes of determining legislative districts. First, I'd like to echo the sentiments of the testimony just before me. Thank you so much for bringing up those really important points. And so rather than re-explaining prison gerrymandering, I just want to emphasize the point that communities where prisons are built, which are usually predominantly white and rural, get a larger say in Congress and the state legislatures at the expense of metropolitan and non-white communities. So this bill would end that prison gerrymandering in Connecticut, thereby ending this outdated, racist, and elitist system. We'd also like to speak in support of HB 5318, restoring electoral privileges to convicted felons who are on parole. All Americans should have a right to vote, no matter their life experiences. Restoring the right to vote for people who are on parole and have been disenfranchised from our democratic system only strengthens our democracy by increasing voter participation and helping those who are firmly incarcerated reintegrate into society. People who are living in our communities deserve the right to be a part of said community and have a voice in it as well. We'd also like to speak in favor of SB 1014, an act concerning municipal election monitor for the 2021 municipal elections and the 2022 state elections. This past year, with the implementation of an election monitor, we felt that it worked extremely well and restored some faith in our democratic system for a community who has every right to have said lack of faith in the system. Connecticut voters deserve free and fair elections every time we go to the polls, and by passing this bill, it will fund the position for the next 2 election cycles, giving our election officials and our voters the support we need to rebuild trust and restore democracy. I'd also like to speak on SB 1017 concerning the election administration. This bill truly brings Connecticut into the 21st century in terms of elections. We specifically support making ballot boxes permanent, the allowance of absentee ballot applications to be submitted online, the electronic signature verification, and making sure those in our community who are visually impaired are given accessible ballots. Voters enjoyed using the absentee ballots from the safety of their homes and the convenience of the ballot drop boxes this past year. We need to create the right environment for full enfranchisement and free and fair elections. And then finally, I'd also like to speak in favor of SB 1016 concerning municipal ethics. This bill requires all municipalities to adopt and maintain a code of ethics, and we see this as a positive step forward for all of our elections to be transparent, ethical, and accountable. CCAG is urging legislators to pass these bills because voting rights is truly what these bills are about.
Your 3 minutes is now over.
So yeah, all Connecticut residents, we want to participate in this free and fair election. And so thank you very much for your time and open to any questions.
Thank you, Ms. Humphries. Any questions, comments for Ms. Humphries? Seeing none, thank you for appearing tonight. I appreciate your testimony and your time. Thank you for being here.
Thank you very much.
Up next, 46, Judy Vila, followed by Sam Oliver Friedland, followed by Alex Sarno. Judy Vila. Judy Vila, I see she's in the waiting room. Is she present? Judy Vila.
Let's try that. How's that?
We can hear you. We can see you. Thank you.
You can hear me, but you can't see me.
No, we
How's
can see you. We can see you. Perfect.
Pretty scary. What can I say? I appreciate all the time that co-chairs Flexer and Fox and ranking members and the committee have spent on this. It's been quite a day. I've been with you since 1 o'clock. I did submit written testimony, and now I will just make a few remarks based on today's conversation. I do testify in support of HB 6578 and SB 1017. I do support expansion of automatic voting registration and restoration of voting rights for parolees, and also secured ballot drop box. Beyond my support for these common sense bills bringing Connecticut into the 21st century, I wish to state my view that blocking and delaying opening the state constitution smacks of voter suppression, and I know that's not the real intent. Statistics show that Connecticut voters want more accessibility. So we need more options for registration and casting ballots because people's lives are complicated. The sandwich generation is real. People have to care for elderly family and parenting children and working at jobs that don't provide flexibility for election day. And we also have to recognize the needs for seniors and for people with disabilities. Those responsibilities often hamper civic engagement, and we have to recognize that people should not be denied their rights. Parolees who've paid their debts to society deserve the rights of full citizenship as they reintegrate. I'm a retired professor, and I can say for sure that expanding AVR online for students would facilitate their registration and their participation in voting. Sometimes it's really confusing for them when they're in school in another state. Today, there were many testimonies involving changes to different procedures in the state, involving technology and increasing access for different government administrations. Ranking Member Master Francesco said we should use technology when we can. And there were many examples from testifiers about education and the town clerks, and of course, Rovac using so much technology. This week, I received an email from Representative Fishbein explaining how the expansion of DMV online access to licenses and other forms would make our lives better. If DMV records can secure people's information, then it makes sense to increase automatic registration through DMV and many other agencies that would serve the public. I hope that we can expand registration and balloting procedures to facilitate free and fair elections. Thank you very much for your time.
Thank you, Ms. Villa. Any questions or comments? I appreciate you being with us except for all day today thus far. Thanks for advocacy and hope you have a nice evening. Thank you for being here.
Thank you very much.
Next, Sam Oliver-Friedland, followed by Alex Sarnoff, followed by John Santa. Mr. Oliver-Friedland.
Good evening, Representative Fox, Senator Flexer, Vice Chairs, Ranking Members, and members of the committee. My name is Sam Oliver-Friedland, and I'm Chief Counsel at the Center for Secure and Modern Elections. We work across the country to make elections more secure, more inclusive, and more efficient. And I'm testifying here today in support of HB 6578 with some minor changes to make it conform with similar versions that have been introduced in previous years. The people of Connecticut and the people of this room care deeply about the integrity and fairness of our elections, and key to that is ensuring that voter registration rolls are complete, accurate, and secure. Automatic voter registration, AVR, does just that. The initiative has been passed or implemented in 22 different states, as wide a variety as West Virginia and Colorado, Utah and Maine, and often through bipartisan majorities. At its core, AVR is about modernizing election systems so that voter rolls are accurate, and so every eligible voter has their roll heard. AVR takes an interaction with the government that an eligible citizen is already having, such as applying for or renewing a driver's license, applying for Medicaid, and uses that information they're already providing to automatically register them to vote unless they choose not to. It only applies to eligible citizens, and voters will have the opportunity to decline if they choose. The benefits are extraordinary. First, AVR will modernize Connecticut's voting system. At a time when Connecticut's government is taking strides to move into the future, AVR will help reduce duplicate registrations, ensure up-to-date registration information, and offer the most accurate voter registration rolls. Second, AVR helps elections run more smoothly. Moving away from paper-based registration dramatically reduces the staff time needed to do data entry, and with an electronic system, registrars spend less time on manual data entry and updating registrations one by one, and more time ensuring elections are run efficiently and securely. It also saves money. A study in Arizona found that it costs over $3 in average staff time to process a paper form, compared with less than 50 cents for an electronic system. At a time when Connecticut faces tighter budgets, and when there seems to be constant cuts to critical services, AVR eliminates the cost of provisional ballots, costly paper transactions, and manual data entry. Finally, AVR is about basic government efficiency. When eligible citizens interact with state governments, they should be able to benefit from the services they're seeking and register to vote. These transactions can also update eligible voters' addresses when they interact with an agency, so they don't need to re-register when they move, and keeping the rolls up to date and secure automatically. As I mentioned, we support this bill with minor changes. Specifically, we would suggest the addition of the provision that's existed in previous versions of this bill that would allow implementation of AVR at other agencies that verify citizenship of eligible voters. This would include Medicaid. At CSME, we work across the country to ensure that eligible voters have their voices heard. We've seen firsthand the benefits of AVR and strongly support this common sense legislation to modernize your elections, register hundreds of thousands of eligible new voters, and move Connecticut's election systems into the future.
Your 3 minutes is
For
now
all of the
over.
above reasons, I'd urge your support of automatic voter registration in Connecticut. Thank you.
Perfect timing. Any questions or comments? Sure, I can just quickly ask, you mentioned some other states that have been participating. Can you give me a quick synopsis of other states that have participated in AVR?
Yes, I unfortunately, I didn't bring the full list of 22 in front of me, but can submit that in written testimony. These are different states across the country. I mentioned West Virginia, Utah, Colorado, Nevada, Massachusetts, Vermont, some neighbors, some states further away, but different types of states have all found this to be a fantastic way to keep voter rolls secure, ensure that voter rolls have only eligible voters on it, and make the elections more accessible for their citizens.
All fairly broad in terms of departments that use it?
Yes,
examples of that nature?
Yeah, there's a wide variety. The most common agency and sort of first step often towards implementation is the Department of Motor Vehicles or the state equivalent. Many states sort of offer the Secretary of State or similar state official the ability to designate other agencies as AVR when they're ready. Medicaid, we think, is a particularly good agency because of the robust data procedures required by federal law. But you see in other states, agencies as different as tax agencies or public universities. Basically, any agency that's interacting with the government and does some sort of verification of U.S. citizenship can be a good option for this.
Okay. Thank you. Any questions or comments? Seeing none, appreciate your testimony. Thank you for spending your time with us. Thank you.
Thank you.
Up Alex Sarnoff, followed by John Santa, although they may be together, followed by Dennis Mema, followed by William Roberts. 48, Alex Sarnoff.
Good evening, Representative Fox, Senator Flexer, members of the Government Administrations and Elections Committee. My name is Alex Sarkoff. I direct the Sentencing Commission. John Santa is our vice chair and was planning to join me, but I don't think he's here, and I don't think he'll be able to join. I know you've had a long day, so I'll be very brief. I've submitted written testimony. I'm testifying on House Bill 5318, and that concerning restoring electoral privileges to convicted felons who are on parole. The commission has testified on similar bills in the past, and so I just wanted to join this effort and offer my voice and the voice of the Sentencing Commission to this effort. We have pointed out in the testimony the ambiguity that may currently exist with respect to special parole, something that I don't think has been discussed much, but there are a lot of people out there in special parole, and it's not quite clear whether people on special parole can vote or not. And so hopefully this bill would address that. And then just the last thing I will say is that I really hope that the committee would address not only this bill and this population, but also larger restoration of voting rights. The commission did submit a proposal to the committee that would restore voting rights to people on parole, but also to everyone incarcerated, with a narrow carve out of those who have a life sentence without possibility of parole. And so if not this year, then hopefully next year, I do hope that the committee will consider it. Thank you.
Thank you, Alex. Any questions or comments? And Alex, I assume in stating the bill you've supported, you're in favor of the fees being waived too?
I'm sorry, I couldn't hear that.
You're supportive, obviously, of the fees being waived?
Oh, absolutely.
Yeah.
Absolutely.
Great. Seeing no questions or comments, thank you for being here, Alex. Good seeing you. Appreciate your testimony.
Thank you.
Up next, Dennis Mema, followed by William Roberts, followed by Stephen Winter. Number 50, Dennis Mema.
Hi, how are you?
Good. How you doing, sir?
Not bad. So thank you very much, esteemed chairs, co-chairs, and other members of the Government Administration and Elections Committee for the opportunity to submit some brief testimony in support of SB 1017, HB 6575, and HB 6578. So like I said, my name is Dennis Mema, and in my professional capacity as an election technology policy analyst for the OSET Institute, which is a nonpartisan election technology research nonprofit, I'd like to first direct the committee's attention to extensive written testimony submitted in support of HB 6575 by myself, an OSET board member and principal election scientist, Dr. Philip Stark. He's also notably the inventor of the risk limiting audit. So I believe his testimony will definitely serve as a valuable resource to both the General Assembly, the GAE committee, and the risk limiting audit working group if 6575 is adopted. And separately, in my individual capacity as a lifelong Connecticut Milford resident who cares deeply about ensuring that we have free, fair, and secure elections, I'd like to speak in favor of SB 1017 and HB 6578. I think these bills both make meaningful progress towards the ultimate goals of equity and security. So with regard to 1017, I want to touch specifically on permanent Dropbox availability. And I know there was great testimony by Secretary Merrill, and I definitely don't want to beat a dead horse, but this and specifically the other section on electronically submitting signatures, I think are small statutory changes that would definitely materially increase both voting accessibility, voting convenience, and therefore ideally voter turnout, which is obviously something we should all be striving to improve every day. So according to a best practices sheet recently released by CISA, which the Cybersecurity and Infrastructure Security Agency, they make the argument that Dropboxes are a very reliable, secure, and effective alternative for voters who might not want, for whatever reason, whether that be a security concern with the post office or a time constraint with trying to return their ballot. These serve as a really great alternative for voters. And I know that the General Assembly has expressed interest in expanding absentee ballot voting. So we want to make sure that all those ballots are counted, because to put it in context, in 2018, the plurality or majority of rejected absentee ballots were thrown out due to having missed the deadline. So we want to make sure that those ballots are counted. And the other aspect of this bill I wanted to touch on, which is allowing voters to submit signatures electronically, I think is definitely another smart move in the name of accessibility and modernization of a pretty historically cumbersome process, provided that it is limited in its scope, to forms and applications as it says in the statute. Definitely not, anything to do with the actual transmission of ballots. I also wanted to touch quickly on 6578. I think it's a really great bill that makes meaningful progress towards overall election equity, especially for people of color. But otherwise, I'm out of time. So thank you very much for the opportunity, and I'd be happy to answer any questions.
Thank you. Thank you for your testimony. Are there questions from members of the committee? Representative McCarthy-Vahey.
Thank you, Madam Chair. And I do actually have a question. Thank you so much for your testimony today, Dennis, and for being here and staying here with us. I just want to ask you to talk for 1 second about risk limiting audits. And that term is one that I think most people are not exactly familiar with. And even earlier today, when Secretary Merrill testified, I thought, one phrase I use often is in the 4th grade parlance. How would you describe that, and why is that such a preferred option as opposed to the way we are doing things now?
Absolutely. So when it comes to risk limiting audits, the whole purpose is using it. It can get very complicated, so I'll definitely defer any very technical questions to Dr. Philip Stark. His contact info is in the written testimony. But at a glance, essentially, it's a process where you look at the margin between, the election results. Let's say 49%, something like that. So very, very close. And the purpose of a risk limiting audit is to be able to count the correct number of ballots, to be able to find the correct confidence interval, which is essentially the correct confidence to be able to say for sure that there's no extra error occurring between whether it be voting machines or otherwise tabulation errors, to be confident in the results. So it's almost like a recount in a sense, that you're going through the ballots and going into specific districts and counties where the tallies are close, and recounting those ballots to make sure that there was no error involved. And the whole purpose of it is essentially to remove any margin of error within the original count. And there's a variety of ways to do that. I think Dr. Stark touches on two different ways that Connecticut can go about it. But overall, as opposed to auditing the accuracy of specific voting machines, this kind of goes into the votes themselves to make sure that the count is accurate. I hope I did an okay job of describing that.
No, I do think it helps. I think it's just, a newer concept maybe for some folks to be thinking about. And maybe I put it this way, and correct me if you think I'm wrong, but instead of looking at a location to be auditing, we're looking at the data.
Exactly.
And making the decision to audit based on the data and the numbers.
Mm-hmm.
And the way that audit would happen would be slightly different as well. I think it's probably an important thing for us to be looking at, because making data-informed decisions is a good way to go.
Absolutely.
Thank you for your answers. Thank you, Madam Chair.
My pleasure.
Thank you, Representative. Are there any other questions? Seeing none, well, thank you. Thank you again for your testimony. Have a good evening.
Bye-bye.
Next, we will hear from William Roberts, who will be followed by Stephen Winter, who will be followed by Jack Friquez. William, welcome. The floor is yours.
Thank you. Good evening, Senator Flexer, Representative Fox, and other distinguished members of the Government Administration and Elections Committee. My name is Will Roberts, and I am a leader with the ACLU Connecticut Smart Justice Campaign. The right to vote is a fundamental part of American democracy, and I believe it is a core constitutional right that should never be taken away. So I'm testifying today in support of House Bill 6578, an act concerning participation in the electoral process. This bill would allow people who are on parole in Connecticut to vote. There are approximately 3,500 people on parole in Connecticut today. Parole is a form of community supervision for people who are previously incarcerated and have been approved to be released and live in society. Hopefully, a person on parole can find employment so they can support themselves, reunite with their families, and have shelter and food on their table in the communities that they choose to live in. People would be more successful at integrating into society when they are engaged with their community. The right to participate in the democratic process is central to that. Restoring the right to vote for people who are rejoining society recognizes that people on parole are full citizens and need to be treated as such with dignity that fosters a connection and engagement with their community. More than 6 million Americans are currently disenfranchised and discriminated against due to a felony conviction. Laws that disenfranchise people because of a felony conviction have disproportionately targeted Black and Brown Americans and their communities. In many states, these laws were, in fact, intended to have this racist effect. Mass incarceration combined with disenfranchisement laws subverts participatory democracy, particularly for communities of color. Restoring the right to vote for people on parole is a step towards dismantling these harmful and discriminatory laws. It is long overdue to remove this racist legacy. In Maine and Vermont, citizens never lose the right to vote, even while incarcerated. In Massachusetts, New Hampshire, New Jersey, Pennsylvania, and Rhode Island, pretty much most of the East Coast, people have their right to vote restored automatically when released. New York removed voting restrictions for people on parole in 2018. Colorado and Nevada restored voting rights for people on parole in 2019. California voters overwhelmingly passed a ballot measure in November of last year to restore the rights of people on parole to vote. Again, it is way long overdue for Connecticut, which champions itself as a constitutional state, quote unquote, to allow people who are on parole the right to vote. I also want to note that we should not pass legislation that requires people to pay any fines before being restored to voting status. There should not be a poll tax to vote. Requiring people to pay to vote is fundamentally undemocratic and a relic of a time that had even more voter suppression at one time. I find it also ironic and hypocritical that towns in where prisons reside can claim a prison population to receive state and federal grants and funding, yet those in prison
is now over.
Can't have any say or vote on how that money is distributed. This bill, House Bill 6578, is the best version of voting for people on parole. Thank you for listening to my testimony, and I welcome any questions you may have.
Thank you. Thank you for your testimony. Are there any questions from members of the committee? Seeing none, thank you again for your time this evening, and thank you for your testimony.
Thank you, you too.
Next, we will hear from Stephen Winter, who will be followed by Jack Friquez, Ishua Omoigu. I'm really sorry if I'm pronouncing people's names wrong, and I want to be corrected when it's your turn. So Stephen, the floor is yours. Welcome.
Thank you, Chair Flexer, Chair Fox, Ranking Members Sampson and Master Francesco, and members of the Government Administration and Elections Committee. Thank you for the opportunity to testify before you this evening. As the Alder for New Haven's 21st Ward and on behalf of the Steering Committee of Voter Choice Connecticut, I want to express my support for HB 6578 and SB 753. Both bills would begin to redress historic injustices in our state that unfairly reduce the power of underserved Black and Brown communities. Both bills would also move us closer to the fundamental principle of one person, one vote. In registering voters in inner city, Dixwell, and New Hallville and New Haven, I have had to inform citizens returning from incarceration that they were not eligible to vote as they were still on parole. It is extremely disheartening and stands as an impediment to helping returning citizens as they reintegrate into society. We should seek to engage returning citizens in civic life, not to turn them away. Furthermore, on principle, these returning citizens are citizens, and no citizen should be denied the right to vote. Neither should they be required to pay fees in order to vote. We cannot ignore that these returning citizens are disproportionately Black and Brown, and that denying them their voting rights serves to reinforce racist structural inequities in Connecticut. In a similar vein, we must no longer tolerate the practice of prison gerrymandering, which increases the political representation and state funding of largely white rural communities at the expense of largely Black and Brown urban centers. This egregious inequity is Connecticut's present-day analog of the U.S. Constitution's 3/5 clause, the great structural imbalance in electoral power that the Connecticut delegation had the shameful role in introducing at the Constitutional Convention. We can help to amend these present-day inequities and recognize our state's role in historic inequities by advancing SB 753. I'm glad to hear that delays in receiving the census results should give Connecticut ample time to eliminate prison gerrymandering in this redistricting cycle so that this heinous practice will not continue for another decade. At a time when other states are seeking to limit and revoke the franchise, Connecticut should seek to expand and protect voting rights. Indeed, as other states seek to abridge voting as a privilege, we must recognize voting as a right, one that HB 6758 would restore to those on parole. With this in mind, Connecticut should seek out opportunities to engage voters, as the participation of voters is fundamental to a functioning democracy. Codifying the current practice of automatic voter registration at the DMV is great, but Connecticut should go further and extend automatic voter registration to other state agencies. Thank you.
Thank you. Thank you for your testimony. Are there any questions or comments from members of the committee? Seeing none, thank you again for your testimony and for your time this evening. Next, we will hear, again, I want to just say, I want to get people's names right. So Jack Friquez, and after that, it will be Ishiwa Omoigu, followed by Drupad Nag, followed by Molly Franco. Okay, Jack, did I get it close?
Pretty close, yeah. Thank you.
Tell me how to say it right. It's important that I say it right.
Yeah, you're all good. Thank you, Senator Flexer, Chair Fox, Ranking Member Sampson, and Master Francesco, and the esteemed members of the JE Committee. I'll try to be brief today since it's been pretty long. My name is Jack Anthony Pena Fresquez, and I'm a resident of New Haven and a senior at Yale University. And I also want to thank you for allowing me to testify today in support of HB 5318, an act restoring elective privileges to convicted felons who are on parole. I first learned about the crisis that is felony disenfranchisement in the fall of 2019 when I met James Jeter and became involved in his longstanding work to expand voter eligibility with Unlock the Vote. I, along with 3 classmates, knocked doors across New Haven every Saturday morning for the semester to raise awareness about SB 233, a bill which would have similarly removed restrictions on voting for people on parole with felony convictions. I quickly learned that while some community members hadn't thought about this issue, many others had family or friends who themselves had been disenfranchised. I also learned that Connecticut is the only state in New England which continues to harm this group of people by depriving them of their right to vote. This is not a mistake. The justice system is not broken. It is working exactly as intended. As others have said, in this post-Reconstruction period, white lawmakers across the country codified felony disenfranchisement laws that targeted Black Americans, diminishing their electoral power and therefore their political power. The racialized legacies of these laws are alive and well in the state of Connecticut. While the state's white population outnumbers its Black and Latinx residents by a ratio of 3-to-1, according to a report by the Council of State Government Justice Center, there are twice as many Black and Latinx people being held in Connecticut prisons. More broadly speaking, every year this country chooses to disenfranchise approximately 5.2 million voters due to felony conviction. While many more are being denied the right to vote for other reasons, currently or formerly incarcerated people continue to be punished by harsh felony disenfranchisement laws. Unsurprisingly, this complex set of laws builds upon a tradition of codes that systematically criminalizes Black people, attempting to diffuse Black political power and uphold white supremacist voting mechanisms. This bill is one drop that I hope will be part of a wave of changes, ensuring increased voter access and expansion to voter eligibility for all people. Voting is a constitutionally guaranteed right, which should be denied to no one, least of all the very people who are most harshly affected by the policies that they're precluded from shaping. I also want to acknowledge the work that this work does not end here. Over the past year, I've worked with Alex Sarkov of the Sentencing Commission and a broad coalition of leaders and community members, including the DOC, the Registrar of Voters, town clerks, and others to craft a bill that would restore voting rights to all, or almost all, including those who are currently incarcerated. That is not the bill that is before this committee right now, but that being said, this bill, HB 5318, is an essential step in ensuring that our elections are completely democratic and represent all people in Connecticut, and I urge you to vote the bill out of the GA committee. Thank you so much for your time.
Thank you. Thank you for your testimony. Are there questions or comments from members of the committee? Seeing none, thank you again for your testimony and your time this evening.
Thank you.
Next is Ishiwa Omogoi. I don't think they're here. So after that will be Drupad Nag, followed by Molly Franco, followed by Michael Ashkew. Drupad, I see that you're here. The floor is yours. I don't see you responding, so I'm going to move on to Molly Franco. Molly Franco, you will go next. Welcome, Molly. The floor is yours.
Thank you. Senator Flexer, Representative Fox, Ranking Member Sampson and Mastro Francesco, and distinguished members of the Government Administration and Elections Committee. My name is Molly Franco. I am currently a Master's of Social Work candidate at the University of Connecticut, as well as the current co-chair of the Graduate Student Organization at the School of Social Work, and a member of the UConn Hartford Voting Power Corps. I'm submitting this testimony in strong support of Senate Bill 753, an act concerning the counting of incarcerated persons for purposes of determining legislative districts. As it stands, Connecticut is one of the many states that utilizes Census Bureau data to draw legislative districts. While this may be convenient, Census Bureau data counts incarcerated persons as members of the community where they are incarcerated instead of their permanent residences. This distorts the recorded populations of towns and cities across Connecticut. Towns like Enfield and others have their populations inflated by the correctional facilities located within them, and in turn, communities, primarily communities of color, are being undercounted and therefore underrepresented. This practice is unconstitutional according to the state's own statutes. General Statutes of Connecticut 914 states, no person shall be deemed to have lost his residence in any town by reason of his absence therefrom in any institution maintained by the state. While this may seem like a trivial issue, the fact remains that this skewed population data comes at a disservice to communities across the state. Additionally, what message does it send when the state of Connecticut has no issue counting an incarcerated person when it serves them for funding and representation, but that same person is prevented from accessing that same funding and representation? Connecticut should stop delaying this legislation and join states like New York, Maryland, and others in ending prison-based gerrymandering. A prison cell is not a residence and should not be counted as such. Lastly, I would like to share my additional support of bills House Bill 5318, an act restoring electoral privileges to convicted felons who are on parole, and Senate Bill 1017, an act concerning election administration. Thank you for your time today.
Thank you. Thank you for your testimony. Are there questions or comments from members of the committee? Seeing none, thank you again for your testimony and thank you for your time.
Thank you all.
I see Drupad is with us, so you will be next and will be followed by Michael Ashkew and then Susan Mitchell and then Natasha Brunstein. Welcome, the floor is yours.
Hi, sorry about missing it. Thanks for coming back to me.
Sure.
Dear Senator Flexer, Representative Fox, Senator Sampson, Representative Mastro Francesco, and esteemed members of GAE committee. My name is Drupad Nag, and I'm a voter from Cheshire, and I strongly support HB 6578 and SB 1017. These are vital pieces of legislation, and their passage should be a priority for the General Assembly this legislative cycle. Expanded access to voting should be a bedrock principle of any state and country that is genuinely interested in building a strong, inclusive democracy, reflective and responsive to the will of its people. Both bills address critical weaknesses of the current voting system and are supported by a majority of Connecticut residents. Automatic voter registration should be a no-brainer. It codifies what the DMV already does in the state law, but it's important that the bill should be amended to expand AVR to other state agencies such as DSS, Husky, Access Health CT, state colleges, and universities. AVR will save money, $3.50 per registration, add roughly 245,000 new voters, and enhance security by eliminating outdated addresses and duplicative registrations. Saving the state money, adding new voters, and securing the integrity of our elections, there's no reason to oppose such common sense legislation that so obviously strengthens our democracy. It also makes drop boxes permanent, which is important as it increases the chance that people will vote by making the process easier. We shouldn't restrict people from voting by artificial barriers and always look to ease burdens on voters. Restoring voting rights to individuals on parole is also an essential piece to expanding voting rights in Connecticut. Over the past decades, there's been an increased focus on how our carceral system has methodically wreaked havoc on Black and Brown communities across America. It seems inhumane that those who have quote unquote paid their debt to society re-enters the community and are still denied a fundamental right of this country. Many who have been incarcerated have been brutalized by their experience in prison and then are further dehumanized by denying them the right to vote. Defenders of our current carceral system frequently claim that its goal is to rehabilitate those who have committed crimes. As a society, are we seriously interested in reintegrating the formerly incarcerated if we deny them the right to vote? Voting is an important way to welcome the formerly incarcerated back into our society. It's a way to allow them to actively participate in their community and have a voice in who will represent them. Further, given how mass incarceration has targeted Black and Brown communities where 1 in 16 Black voters are denied the right to vote due to felony disenfranchisement laws versus 1 in every 59 non-Black voters, the inability of formerly incarcerated to vote artificially decreases the voting power of those communities, which frankly may seem as a benefit to some.
Your
not
3 minutes is now over.
I think both are important pieces of legislation. If passed, would demonstrate a real commitment towards the values of our state and country purport to embody. I strongly encourage the committee to vote in favor of HB 6578 and SB 1017. Thank you.
Thank you. Thank you for your testimony. Are there any questions or comments from members of the committee? Seeing none, thank you again for your testimony and thanks for your time this evening.
Thank you.
Next is Michael Ashkew. And again, if I'm saying that wrong, please tell me, followed by Susan Mitchell, followed by Natasha Brunstein. Is Michael here? I don't see Michael, so I am going to call on Susan Mitchell. Susan, are you here? Yes, you are. Welcome, Susan. The floor is yours.
Thank you. Senator Flexer, Representative Fox, Senator Haskell, Representative Thomas, and members of the GAE committee. Thank you for allowing me to provide some testimony today. I am commenting specifically on House Bill 6577, which is an act concerning the State Properties Review Board, something we have not heard much about from tonight. I am a farmer. I am a first-generation farmer. I grow certified organic vegetables, and I have been operating a small business in Connecticut for 6 years. And as a first-generation farmer, the ability to access affordable and appropriate farmland is incredibly difficult, not only in Connecticut, but across the nation. And we are lucky enough in Connecticut to have 2 programs with the Department of Agriculture that will help farmland stay farms forever. It's the Farmland Preservation Program and the Community Farms Program. My comments today specifically are in opposition of sections 3 and 4 of HB 6577, which aims to include the State Properties Review Board in the administration of the Community Farms Act. The Community Farms Act is designed to protect smaller properties and has a focus on food and fiber producing farms, which in light of climate change, in light of storms and power outages, we need to be able to feed ourselves. And we really need to be able to encourage the next generation to farm. And in that, if we have properties that are more affordable because they have gone through the a farmland preservation program, that makes them that much more accessible to the next generation. The State Properties Review Board adds an additional layer into an already very long process. And we are at a point where we have a crisis occurring in land access. And I think it is to the betterment of our state that we keep the farmland preservation programs as simple as possible. Those properties are already very highly vetted. And I would like to encourage land access and not discourage it and install even more roadblocks into this process. Thank you.
Thank you. Thank you for your testimony. Are there questions from members of the committee? Representative Haddad.
Thank you, Madam Chair. I wanted to say hello to my friend Susan. Susan is a farmer who had a small local farm in Mansfield, but recently moved to Columbia, sadly, for our town. Me and my family have been purchasing food from her through her CSA for a couple of years now. Susan, you and I have had a lot of conversations about how difficult it is, particularly for small farmers, yourself included, to find farmland to purchase. And partly that's because it's been so hard to preserve. It's particularly smaller farms that are suitable for new young farmers who don't need, a 300 or a 350 acre farm. So I appreciate your coming here today, hanging in here with us and offering your testimony. I hope that we'll be able to have more conversations about this moving forward. And I wanted to thank you for your testimony and say that I will follow up with you more directly to understand more of the nuances of your testimony. But at this late hour, I'll just say hi and not ask a question. Thank you very much, Madam Chair. Thank you for indulging me. I appreciate your patience.
Thank you, Representative. Are there other Representative Palm?
Thank you, Madam Chair. Hello, Ms. Mitchell. Can you just briefly describe what would change if this authority were to be expanded? I don't really understand why it would be a problem. Is it too complicated, or can you just put into layman's terms why you are opposed to this?
Very simply, The properties that enter the Maine Farmland Preservation Program go through a very thorough vetted process. Then they go to the State Properties Review Board, which has delayed the preservation by up to a year in time because of just the pace at which they operate. So you're asking farm families to wait 2 years, 3 years, 4 years to move through a state program to do something which benefits our state and our communities, which is to protect prime and important farmland. The Community Farms Program does not have, is not under the purview of the State Properties Review Board, and as such, can operate in a slightly quicker fashion. The program is also incredibly underutilized by the Department of Agriculture, and it is by far more appropriate for new and beginning farmers because they are smaller sized parcels. We desperately need to get farmers on land because they stop farming because they can't find affordable land. And so by adding the State Properties Review Board, it's going to slow down an already very slow process. And we just don't need any more hurdles, really.
Thanks. That's a really clear answer. I appreciate that. If this process were expedited, would you still be opposed to it?
I don't know how exactly you or one could guarantee an expedited process. I think there is already a very good vetting process in place for all the properties that go through farmland protection. I'm just not in favor of adding another layer.
So to you, it would be duplicative of what we already have. Yeah. Okay, great. Thank you very much for that very clear answer. Thank you. Thank you, Madam.
Thank you, Representative. Are there any other questions from members of the committee? Seeing none, thank you again for your time and your testimony this evening. Next is Natasha Brunstein, followed by Keith Eichner, followed by Charles Decker. Natasha, I see that you're here. The floor is yours. If you would like to unmute yourself or show your camera, you don't seem to be doing that. So I'm going to call on Keith. Natasha, are you here?
Yes, I'm here. Can you hear me?
Oh, you're on my screen twice. I'm so sorry.
No, I apologize for that.
Okay, are you connected in two different ways?
I'm not quite sure what's going on. I'm sorry about that.
Okay, well, go ahead with your testimony.
Thank you, Madam Chair Flexer, Mr. Chairman Fox, and members of the committee. My name is Natasha Brunstein, and I'm a member of the Peter Gruber Rule of Law Clinic at Yale Law School. We represent the Connecticut State Conference of the NAACP and the ACLU of Connecticut. We are here to urge you to pass SB 753 to finally abolish prison gerrymandering. Prison gerrymandering diminishes the political power of urban communities and discriminates against Black and Brown voters by denying them the constitutional guarantee of one person, one vote. In recent years, 10 states have recognized that prison gerrymandering undermines basic democratic values, and they've passed legislation ending the practice. With your leadership, Connecticut can and must become the 11th. Connecticut chooses to draw its legislative maps by counting incarcerated people as residents of the districts where the state has chosen to locate its prisons, rather than the communities they call home. 2/3 of people incarcerated in Connecticut are Black and Brown, and they disproportionately have permanent homes in the state's largest cities. But by contrast, Connecticut's prisons are primarily in rural white districts. And this takes political power away from incarcerated people's communities. For example, based on 2010 redistricting data, a New Haven resident's vote for state office counts for only 85% of the vote of a resident of Enfield because of prison gerrymandering. This exacerbates the effects of mass incarceration that already harm communities of color. Simply put, it artificially inflates the political voices of residents in rural white towns at the expense of other diverse urban and suburban communities. Redistricting that discriminates against urban residents in favor of some rural residents is precisely what the United States Supreme Court has found to be unconstitutional. And indeed, Connecticut may be subject to renewed litigation if the legislature fails to act. Passing SB 753 is especially vital this session, which is the last before the decennial redistricting process. If the General Assembly does not act, and no changes are made during the redistricting process, this invidious process will be enshrined into law for another 10 years. And furthermore, this cycle, the Census Bureau is making it even easier for states to adjust redistricting data. Lastly, I want to emphasize that this bill will not affect town revenue streams. This legislation mandates only one thing: corrected data for your districting. It's entirely separate from funding. In closing, prison gerrymandering is a gross voting rights violation and a flagrant racial injustice. Connecticut cannot wait another decade to abolish this discriminatory practice. We urge you to act now to pass SB 753. Thank you.
Thank you. Thank you for your testimony, and I apologize for mispronouncing your name a little bit. I apologize for that. Are there any questions from members of the committee? Seeing none, thank you again for your time and for your testimony this evening. Next is Keith Eichner, followed by Charles Decker, followed by Mike Savino, followed by Corey Betts. I don't believe that Keith is here, so Charles, welcome. Charles, the floor is yours.
Thank you, Chair Flexer and Chair Fox and members of the committee. My name is Charles Decker. I'm a senior research analyst with Unite Here, and I serve on the Board of Alders in New Haven, representing Ward 9. There are several important bills up for the public hearing today, and I commend the committee for your work to secure the right to vote in our state. But I'm here today to testify in favor of SB 753, the act concerning accounting of incarcerated persons for purposes of determining legislative districts. I'd like to thank especially Senator Winfield and Representatives Dillon and Porter from the New Haven delegation, my city, for co-sponsoring this bill. Dismantling the carceral state needs to be the civil rights struggle of our time. But one of the reasons why the carceral state is so dangerous and so difficult to dismantle is that many of its most insidious features are invisible. Thousands of citizens, disproportionately Black men, are ripped from their communities. Their bodies are warehoused out of public view. When they come home, they're excluded from many aspects of civic life. They find it nearly impossible to find work or housing. This has created, especially in our Black neighborhoods in New Haven, as in many other cities, a generation of what sociologist Becky Pettit has called invisible men. And prison gerrymandering is a prime example of an invisible force that drives a carceral state. It further minimizes the voices of those whose voices have already been so diminished by the criminal justice system. It is an affront to the bedrock principle of our democracy of equal representation, or one person, one vote. It quite literally means that Black communities in Connecticut are entitled to less of a say than other communities. New Haven and our state suffer from nearly a century of segregated development. Almost every neighborhood in New Haven that is poor now was marked as declining or hazardous by redlining maps in 1937. The same neighborhoods that had the highest home foreclosures during the Great Recession are the neighborhoods that have the highest COVID-19 infection rates. It's unconscionable that you can map so many negative outcomes on a set of maps outlining institutionalized racism from the 1930s. Yet we can, and prison gerrymandering makes it all the more difficult to change these maps. Our volunteers with Unite Here and with New Haven Rising knock on many, many thousands of doors every year. We understand the power of elections and elected leaders in the fight for justice and opportunity. Prison gerrymandering hinders our work and stifles Connecticut's ability to overcome its past of segregated development. Residents in cities need representation that is accurate to their population. Cities that will be on the hook for implementing successful reentry programs like New Haven need their full political representation. Successful reentry will have important implications for our city's abilities to provide freedom and dignity to all residents. But prison gerrymandering makes this even more of an uphill struggle than it already is. I'm an elected official and I'm an organizer, but I'm also a Black man in America. My ancestors went to war for the right to vote. Looking at the assault on voting rights in our country, it breaks my heart that my generation is going to have to wage that battle again. But ending prison gerrymandering is one step that shouldn't require a generational struggle. It's completely straightforward, it's impactful, it's just, and we have the power to do it now if we choose to, but we're out of time to make the right decision. So I urge the committee to vote favorably on the bill and then to push and convince your colleagues to finally correct this injustice. I thank you very much for your time.
Thank you. Thank you for your testimony. Are there questions or comments from members of the committee? Seeing none, thank you again for your time this evening.
Thank you.
Next is Mike Savino, who I don't believe is here, followed by Corey Betts, who will be followed by Aaron Good, who will be followed by Jonathan Perlow. Corey, The floor is yours. Welcome.
Good evening, Madam Chair Flexer, Mr. Chairman Fox, and members of the committee. My name is Corey Betts, and I am the Criminal Justice Chair of the NAACP Connecticut State Conference. On behalf of the NAACP of Connecticut and its thousands of members, I'm here today to testify in support of SB 753, which would abolish prison gerrymandering in Connecticut. The NAACP of Connecticut has long opposed prison gerrymandering. We view this issue as a core part of our agenda for racial justice and civil rights in Connecticut. To that end, in addition to our legislative advocacy, we were a party in a lawsuit against the state arguing that prison gerrymandering in the state legislative maps drawn based on 2010 census violated the US Constitution. This bill, which is being considered at a crucial time, represents a long overdue opportunity to end this unjust practice. I'll make 3 points in my testimony. First, prison gerrymandering harms incarcerated people by depriving them of meaningful representation. Incarcerated people deserve to be represented in their home communities where they have roots and family. Instead, prison gerrymandering counts them as residents of communities with which they have no connection or contact, represented by legislators who are really keeping them in mind. This is simply unfair. Second, prison gerrymandering has a powerful and discriminatory racial effect. Most incarcerated people are Black or Latinx and come from the urban areas with large and Latinx populations. Prison gerrymandering has a great impact on these urban areas, which see their votes count for less. Meanwhile, most prisons are in white rural areas, which see their votes count for more because incarcerated people are counted there. Because of this, prison gerrymandering denies representation to Blacks and Latinx people and unfairly reduces the political power of Black and Latinx voters. In this way, prison gerrymandering is a legacy of racism, artificially reducing Black political power like a modern day 3/5 clause. Finally, it is important that the General Assembly pass legislation to end gerrymandering this session before the redistricting process concludes with new maps. Unless the General Assembly acts this session, there is a strong risk that Connecticut will lock in prison gerrymandering for the next decade. This issue is simply too important to put off any longer. I urge you to pass SB 753 and ensure that Connecticut adopts maps that treat incarcerated people and Black communities with the respect and fairness they deserve. Thank you.
Thank you. Thank you for your testimony. Are there questions or comments from members of the committee? If not, thank you again for your time and your testimony this evening.
Thank you, Madam Chair. Have a good evening.
Thank you. You too. Next, we will hear from Aaron Good, who will be followed by Jonathan Perlow, who will be followed by Carrie Shaw.
Hello, can you hear me?
Yes, we can hear you, Aaron.
Hi, thank you, Madam Chair and distinguished committee members. My name's Aaron Good, and I'm with the New Haven Votes Coalition, and I want to speak
Aaron,
in favor.
I hesitate to interrupt you. If you can turn your camera on, that's best practice for our hearings, but if you can't, I also understand. Maybe this is causing more harm than good. I can send you a request. There you go.
Okay, sorry about that.
That's okay.
Yeah, I'm with the New Haven Votes Coalition. I just wanted to speak in favor of 3 of the bills in today's hearing, 6578, 1017, and 753. With respect to 6578, codifying AVR, the AVR administrative agreement between DMV and the Secretary of the State into statute is very prudent. It will place AVR in a much more durable legal footing. That is a good thing. As you've heard, we do need to go beyond AVR that just harvests data from DMV. Up to 40% of New Haven residents do not have cars. They do not interact with the DMV. They're completely left out of the benefits of the current AVR system. So DSS, DRS, Husky, Access Health, CT, state colleges and universities. We may have a database of people signing up for COVID vaccines or for COVID relief loans or cash assistance. All of those databases can and should be included. If the state is already collecting that information, we should be allowing our residents to benefit by not requiring them to also file a duplicative voter registration form. AVR is good for younger voters and new voters. It's good for streamlining the workload of our local election officials who no longer have to deal with the proliferation of paper forms. It's good for ballot integrity and security, and 77% of Connecticut voters support it. With respect to voting rights for parolees, the zip code 06511 here in New Haven has the most individuals who would be affected by this legislation of any zip code in Connecticut. When I talk to people involved with New Haven's prison reentry initiative, what I hear most is that parolees want and need to be reintegrated as quickly and thoroughly as possible into society. And one small way to do that is to allow parolees to be reenfranchised without respect to fines. We've seen recently in Florida how poverty is weaponized against people trying to have their voting rights restored. And that's not the path that Connecticut should be taking. 1017, I have a very close friend in New Haven who told me that her absentee ballot that was requested on October 10th arrived in the mail on December 2nd, a month after the election. Even under the best case scenario, first class mail from New Haven has to go to Hartford to be sorted. A letter sent 5 blocks can take 5 days to arrive. According to our city clerk here in New Haven, in some elections, as many as 10% of absentee ballots are disqualified because they arrive late. So after the expansion of absentee ballots in 2020, many more people are interested in voting absentee. We don't want to go back to the old system of not having a permanent drop box option, so our absentee voters can have peace of mind that their vote has arrived in time to be counted. And the language about including
Your 3 minutes is now over.
Yeah, just to conclude, the language about including ABs in our randomized post-election audits, my colleague Luther Weeks of CT Election Audit has been all over that. This is a change that must accompany any expansion of absentee ballot access. And SB 753, I've also addressed that in my written testimony that I submitted. So thank you very much, Madam Chair and committee, and I appreciate the time. Thanks.
Thank you. Thank you for your testimony. Are there any questions or comments from members of the committee? Seeing none, thank you again for your testimony and for your time this evening. Next, we will hear from Jonathan Perlow, who will be followed by Carrie Shaw, who will be followed by Gloria Brown. Welcome, Jonathan. The floor is yours.
Hello, Senator Flexer and Representative Fox, Ranking Member Sampson and Master Francesco, and distinguished members of the GA committee. My name is Jonathan Perlow. I am co-founder of Voter Choice Connecticut, the citizens movement working to bring ranked choice voting to Connecticut. I'm testifying in favor of several bills. HB 6578 to restore parolees' right to vote and to codify automatic voter registration, SB 1017 to make ballot drop boxes permanent and allow online absentee ballot applications, SB 753 to end the practice known as prison gerrymandering, and SB 1014 for election monitors to ensure the integrity of election administration in Bridgeport. To have a strong and resilient democracy that is truly representative, I believe 4 conditions must be met. Expand the voting franchise to all citizens, adopt measures that increase voter participation, have measures in place to ensure that every vote is counted, that actual threats of fraud and election tampering are prevented, and that secure elections from threats foreign and domestic. And lastly, ensure that outcomes of elections represent the electorate. Each of the bills I cited support one of these conditions. Testimony from others demonstrate these reforms are supported by large proportions of voters across party lines, so I will not repeat them. I would like to point to another source of validation for these reforms. The American Academy of Arts and Sciences For nearly 250 years, the Academy has worked to bolster citizens' understanding and engagement with their government. Last year, the Academy released a far-reaching report, Our Common Purpose, Reinventing American Democracy for the 21st Century. The report offers 31 recommendations for building a fresh commitment to democratic citizenship and American constitutional democracy. Among the recommendations are most of the elements in the bills I cited. Specifically, the report recommends universal automatic voter registration. That goes beyond implementing AVR and DMVs, and I encourage you to expand HB 6578 to include all relevant state agencies. It recommends restoring voting rights to citizens with felony convictions upon their release from prison, including those on parole as included in HB 6578. And it recommends expanding ballot drop-off locations to increase voter participation and confidence. Making ballot drop boxes permanent, as proposed by SB 1017, helps fulfill this objective. Importantly, these reforms will help communities of color to have their voices heard and bring us closer to the ideals upon which this country was founded. Your agenda will make it easier for more people to vote and improve the integrity of elections, 3 of the 4 conditions for strengthening our democracy I described above. I ask that next year the committee consider election reforms that fulfill the 4th condition, making our democracy more representative. In particular, I urge the committee to pursue ranked choice voting. It too was included in the Academy's report as a key recommendation to achieve equality of voice and representation. Thank you very much for your consideration and hearing my testimony tonight.
Thank you. Thank you for your testimony. Are there questions or comments from members of the committee? Seeing none, thank you again for your time and for your testimony this evening.
Thank you all very much.
Next, we will hear from Carrie Shaw, who will be followed by Gloria Brown, who will be followed by Eliza Saren Becker. Carrie, the floor is yours.
My name is Carrie Shaw. I'm president of Humanists and Free Thinkers of Fairfield County and chair of the statewide Connecticut Coalition of Reason. SB 759 makes a step forward to modernize Connecticut Constitution so it is inclusive of all Connecticut residents by setting a task force to examine the Constitution's relevant passages. Let's not waste this opportunity. We recommend that the bill be improved to give the task force the mission to help make the state constitution gender and religious neutral, to identify all existing gendered and religious language, and to reiterate the equality of all citizens. In fact, this recent January, that's 2 months ago, town executives across Connecticut issued proclamations endorsing religious freedom for all, regardless of religion or lack thereof. The advantages of a religious and gender neutral constitution are many. First, to enhance our state economy by making it clear that all who wish to create businesses, create jobs, or assume employment here are welcomed by our state, which recognizes their worth without prejudice. Second, to forestall the inevitable legal challenge to the existing wording of the state constitution, which would involve needless state expenditures for a cause that would fail in court. And 3, to encourage freedom, tolerance, and harmony, making it clear that the state of Connecticut will not favor one person over another, abrogating their freedom of conscience or their gender or sexual identity. 42% of Connecticut residents identify as non-religious. Let's make the Connecticut Constitution consistent with the United States Constitution.
Thank you. Thank you for your testimony. Are there questions or comments from members of the committee? Seeing none, thank you again for your testimony and for your time this evening. Next, we will hear from Gloria Brown, who will be followed by Eliza Saren Becker, who will be followed by Justin Farmer. Gloria, the floor is yours.
Thank you. Senator Flexer, Representative Fox, Senator Sampson, and Representative Mastro Francesco, and all the members of the Government Administration and Elections Committee. My name is Gloria Brown, and I live in Southington. I am a retired teacher who taught for 37.5 years in Wolcott. Thank you for the opportunity to speak to you today about House Bill 6578. Restoring the right to vote to people re-entering their communities on parole is extremely important to me. I am here to speak about and for a person I will call Lenny. At age 14, Lenny was arrested, tried as an adult, which was terrible, and sentenced to 40 years in prison. While in prison, Lenny did many things to make himself a better person, both physically and mentally. He continued his education and took many college courses online. He did meditation and yoga. He was an exemplary prisoner. My son, who is an attorney, was assigned to Lenny's case 7 years ago. After serving 25 years of his 40-year sentence, Lenny was released 2 years ago. It took 5 years to accomplish this. He got a job and has been promoted twice. He is engaged to be married. He and his fiance recently bought a house. He has been very successful in reintegrating into his community. He pays Connecticut income tax and property taxes, but he cannot vote. There are many Lennys in the state of Connecticut who have worked hard to reintegrate into their communities. They deserve to have their right to vote reinstated. Connecticut has the most stringent criminal disenfranchisement laws in the Northeast, and it is the only state in the region that still prohibits those on parole from casting a ballot. I urge you to support this legislation that will change that. Thank you for the opportunity to present my testimony.
Thank you. Thank you for your testimony. Are there questions or comments from members of the committee? Seeing none, thank you again for your testimony and for your time this evening.
Thank you.
Next, we will hear from Eliza Saren Becker, followed by Justin Farmer, followed by Ava Bermudez Zimmerman. Eliza or Justin, I don't believe that they are here. So Ava will be next. And after Ava will be Clarissa Kimmy, followed by Brett Jennings, followed by Theo Hacks.
Hello there. Good evening, and thank you for this opportunity. My name is Ava Bermudez Zimmerman. Hello, Co-Chair Senator Flexer, Co-Chair Representative Fox, and the ranking members of the committee. Thank you again for this opportunity because this issue is so important. I'm here in support of Bill number 6578, and that concerning participation in the electoral process, and also number SB 1017, and that concerning election administration. I represent childcare providers here in the state of Connecticut through SEIU CSCA. We have 26,000 members throughout the state of Connecticut. And as I mentioned, childcare is also a big part of our membership. In total, we have thousands and thousands of providers who every single day, they give their time, their care, the compassion to our most youngest and most important future voters here in the state of Connecticut, which are infants and toddlers. Our childcare providers, some of them work 40, 50, some even 50 to 60-hour work weeks. And when it comes every single election season, time for them to have the ability to vote, unfortunately, some do not have the opportunity to do so because they're with the infants and the toddlers. When we're talking about voter disenfranchisement, when we're talking about the capacity to connect with our politicians and have the opportunity to give an opportunity to give our providers basically the perspective of participation, we have to talk about voter registration. We have to talk about absentee ballots and not give them, let me go back to my testimony here. I was skipped and I just got off kilter. I'm so sorry. So just going back to the testimony and not to waste your time or my time here, when we're talking about voter disenfranchisement and we're talking about this particular bill, the bill codifies AVR. And right now, when we're looking at the Department of Motor Vehicles into state law, it's important to recognize this first step. However, we must also expand AVR in the Department of Social Services and Husky Access Health. So that way the state has the opportunity to connect with other agencies. When it comes to automatic voter registration, it'll enhance our security, it'll enhance the integrity of the election process. And right now it's extremely outdated. So it addresses duplicate errors that happen in the process. I know in my 15 years of organizing, when I'm registering voters, when I talk to voters, I had one particular incident where I had a husband who lost his wife 2 years prior. And unfortunately, she was still listed in the database and that still hadn't caught up. And she had gotten calls from over 10 organizers asking her to go out and vote. And in fact, she was deceased. So we're working with a system that's outdated. We're working with a system that providers are depending on us to codify and to realize in modern day times so that they have an opportunity to go and vote. Like I mentioned earlier, childcare providers work very long work weeks. They don't always have the ability to leave their houses before the election day is done. Some work way past 8 p.m. So I do implore you to consider and support this legislation. I hope that with the other people who testified prior to me who are experts in this legislation, you have the information at hand to consider this legislation. And thank you for your time.
Thank you. Thank you for your testimony. Are there any questions or comments? Seeing none, thank you again for your time tonight.
You made it easy for me. It's been such a long day. Take care, everyone.
Thank you. Next is Eliza Saren Becker, if they are here, followed by Justin Farmer, if they're here, followed by Clarissa Kimmy. Is Justin here? All right, looks like Justin is here. Justin, the floor is yours. Welcome.
Thank you, and I apologize for being passed over. So, good evening, co-chairs, Senator Flexer, Representative Fox, as well as Vice Chairs Haskell, and as well as the ranking members.
Oh, Justin, did you freeze up? I think you may have frozen, so it might be helpful actually if you turn your camera off. It might lower the bandwidth that's required for us to hear your testimony. Justin, can you hear me? Okay.
Okay, can you hear me now?
Yes, we can. Thank you. Thank you, Justin.
All right, I think y'all know what I look like. And so I'm here tonight to speak to y'all on House Bill 6578, Act concerning participation in electoral process, as well as SB 753, Act concerning counting of incarcerated persons for the purpose of determining legislative districts. I'll start with the latter first. Last year I talked to y'all about prison gerrymandering and shared my brother's story about being in a prison in Pennsylvania and how he did not feel that he was part of the community where he was, nor did he have the ability or access to vote. And the mail that he got from the prison inviting him to that community was something hurtful and painful that many community members in our state face here today. I was part of a suit with the NAACP in the Yale Rule of Law Clinic, fighting this issue in the courts. There's not much I can say about this. It's time that we do the right thing. I'm willing to partner with anyone and everyone to do that. It brings me sadness and disjoy to know that we're continuing this process. And I hope that I will not be here 10 years from now advocating to make sure that communities like mine get access. The only thing I'll share before switching over is this summer I had multiple people reach out to me from prisons asking for help, asking for advice on their loved ones being imprisoned, and they felt more comfortable reaching out to a municipal leader than their senator or representative because they felt that the experiences that we share together were more pertinent, and they knew that once they re-entered our community, that they would be with community members like myself or Representative Porter, who would be helping them to get the resources to get back on the wagon and to be a member of our community in good standing. So this is not just about fairness, this is not just about representation, but this is making sure that everyone, including the people who have not touched the criminal justice system, are equally held and are able to be represented by people that they elect for their community. Switching over to, automatic voter registration, I support the bill. I feel the bill needs to be strengthened to reach out to our DMVs, reach out to Husky Health, colleges, universities. Our democracy only works if people participate.
Your 3 minutes is now over.
And I'll surmise my thoughts with the more people engage, the better we can do our work. So thank y'all. I've been here all night with y'all, and I appreciate everything that y'all do.
Thank you. Thank you for your testimony. There is a question. So Senator Haskell has a question for Justin. Go ahead, Senator Haskell.
Thanks so much, Madam Chair. Not a question, just a comment to say, Justin, I remember you coming to testify on this bill last year, and you said this is a must pass because we're getting close on the timing. Well, now we're really getting close on the timing, and now it's really a must pass. So I just wanted to thank you for your continued advocacy. You've had your eye on the ball for some time, and we're grateful for it.
Thank you.
Thank you, Senator. Thank you again, Justin, for your time and your testimony here this evening.
Safe travels.
Well, that's the beauty of Zoom legislating, no travels, right? There will be no travels this evening. But thank you, Justin. Next, we will hear from Clarissa Kimmy, who will be followed by Brett Jennings, who will be followed by Theo Hacks, who will be followed by Kip Kolasinkas. And please, as you come up, if I've said your name wrong, tell me how to say it the right way. Clarissa, welcome. The floor is yours.
Thank you. Good evening, and thank you, Senator Flexer, Representative Fox, Ranking Members Master Francesco and Sampson, and other members of the committee who are here after a very long day of testimony. My name is Clarissa Kimmy, and I'm here testifying on behalf of the Lyman Center at Yale Law School to express our support for HB 6578. We'd additionally like to propose several amendments to House Bill 6578 so that the bill not only does the important work of re-enfranchising members of our community, but ensures those who already have the right to vote can vote. Each year, there are 4,000 eligible voters incarcerated in Connecticut who face serious and often insurmountable barriers to voting. People awaiting trial and those who are only incarcerated of misdemeanors are indeed eligible to vote, but they must navigate a maze of forms and mailings in order to do so. To go from being unregistered to casting an absentee ballot requires at minimum 7 mailings. Some of these forms go to the registrar and some go to the town clerk, and not every town does it in the same way. Last semester in my clinical program, a group of Yale Law professors and students spent weeks trying to figure the system out as part of an effort to help eligible incarcerated voters vote. The process was expensive, time-consuming, and difficult to understand. But we also saw how important this effort was. We were able to help 200 people cast their votes during this past election, and dozens of people wrote saying how much it meant to them to be able to vote, even during this difficult time in their lives. But each year there are thousands of others who have to navigate this maze alone. I'm here today to direct you to our written testimony proposing several changes to House Bill 6578 that would help simplify the process and reduce these barriers. They're straightforward changes, but would help ensure that those with the right to vote can vote. The first is including a provision that would require the DOC to provide voter registration forms when someone first enters a correctional facility. The second would provide for absentee ballots to be automatically sent to eligible incarcerated voters. And the third change would provide for election staff to drop off and pick up absentee ballots from local correctional facilities in the event that someone is arrested soon before Election Day and there just isn't sufficient time to mail it in. These changes are simple but important. The history of voting rights in this country shows that having the formal right to vote is important, but it isn't always enough. The state has an active role to play in removing barriers to voting and ensuring that every voice is heard. These changes help ensure Connecticut is meeting that obligation. We've provided written testimony with more detail and would love to speak with you about these proposed changes. Our contact information is provided in our written submissions. Thank you so much for your time.
Thank you. Thank you for your testimony. Are there questions or comments from members of the committee? Seeing none, thank you again for your time and your testimony this evening.
Thank you all.
Next will be Brett Jennings, who will be followed by Theo Hacks, who will be followed by Kip Kolesinkis, who will be followed by Lucius Coulette. Brett, the floor is yours. Welcome.
Good evening, Senator Flexer, Representative Fox, and members of the GAE committee. My name is Brett Jennings, and I'm a junior at Yale College and a resident of New Haven. I am testifying today in support of HB 5318 as a part of the Yale College Democrats. HB 5318 is an important step forward in protecting the voting rights of all people in Connecticut, including felons on parole. Connecticut has the most restrictive voting laws for felons in the Northeast, but voting is and should be a fundamental right in our democracy, and the voting rights of all people, including felons on parole, should be protected. Felons on parole should be able to participate in the electoral system in the same way as others in their community, as they work and interact with their communities, and should be able to have a say in how it's governed. Restoring the voting rights of felons on parole can aid their reintegration into their community, and the increased opportunities for civic engagement voting provides can decrease the rate of recidivism. Additionally, these policies disproportionately impact people of color in Connecticut, primarily Black people, due to racial issues in the criminal justice system and the history of these policies being rooted in the Jim Crow era. These policies further racial inequality in voting access, and extending voting rights to felons on parole through HB 5318 is a positive and necessary step in protecting the voting rights of people of color in Connecticut and upholding the democratic ideals of our country. I thank you for your time and your consideration.
Thank you. Thank you for your testimony. Are there questions from members of the committee? Seeing no questions, thank you again for your time and your testimony this evening. Next is Theo Hacks, who will be followed by Kip Kolesinkis, who will be followed by Lucius Coulette, who will be followed by Brian Mezek. Theo, the floor is yours. Welcome.
Good evening, Chairs Flexer and Fox, Vice Chairs Haskell and Thomas, and distinguished members of the GAE. My name is Theo Hawks, and I am a first-year student at Yale University. I'd first like you all to thank you. I would like to thank you all for your time. I know this has been a very long hearing, and I would like to thank you for allowing me to testify today. I am here to add my voice to the extensive support for Senate Bill 753, an act concerning the counting of incarcerated persons for purposes of determining legislative districts. To start, Senate Bill 753 would create a more representative democracy in Connecticut. As it currently stands, Connecticut counts incarcerated persons as members in the legislative districts where their correctional facilities are located, instead of the home districts where the inmates resided prior to incarceration. This practice, known as prison gerrymandering, affords undue electoral power to the districts with carceral facilities. As a current New Haven resident, I was especially concerned by the 2018 NAACP investigation, which found that due to the inflated voting power created by its several prisons, the vote of a resident in District 59 counts for 15% more than a vote in District 97, which contains part of New Haven. Similar imbalances occur in other prison gerrymandered districts across the state. Furthermore, Connecticut General Statutes 914 states that no person who resides in any institution maintained by the state shall be admitted as an elector in the town in which such institution is located. This serves to show that the state of Connecticut already admits that incarcerated individuals are most logically political residents of their home districts. Under Senate Bill 753, that acknowledgement would be extended to the rest of Connecticut's incarcerated population. Second, Senate Bill 753 would address the systemic racism which permeates the process of prison gerrymandering. Data from the Connecticut Department of Corrections in the 2010 census shows that throughout the state, districts containing correctional facilities are significantly more white and rural in their demographic makeup than the incarcerated individuals they house. This blaring disparity between demographics of prisons and their respective legislative districts highlights the concerning fact that prison gerrymandering shifts power away from minority communities and towards predominantly white districts, which seldom reflect the same political interests as their incarcerated populations. Finally, by signing SB 753 into law, Connecticut would join several other states, including New York, Maryland, California, and others, which have all made the same commitment to reallocating census locations of their incarcerated populations. Especially given the upcoming redistricting cycle later this year, I urge the Connecticut General Assembly to pass this bill and push our state towards a more equitable and representative democracy. Thank you.
Thank you. Thank you for your testimony. And seeing no questions, are there any questions from members of the committee? Seeing none, thank you again for your time and your testimony this evening. Next, we will hear from Kip Kolesinkis, followed by Lucius Collette, followed by Brian Mezek, followed by Holly Hansen. Kip, welcome.
Thank you. Great, thank you. Dear co-chairs Flexer and Fox, and you did a fine job on my name. Vice chairs Haskell and Thomas, ranking members Sampson and Mastro Francesco, and members of the GAE committee. I appreciate, and sorry, I apologize, I have a broken camera. I appreciate the opportunity to submit testimony in opposition of HB 6577, an act concerning the State Properties Review Board. These proposed changes will slow down the Community Farms Preservation Program process, further hindering our efforts to prevent small farms from development and making it harder for new and beginning farmers to access affordable farmland. It will also deter farmland owners from applying to the program. Again, my name is Kip Kolesinkis, and I'm co-chair of the Working Lands Alliance, a broad-based statewide coalition dedicated to preserving Connecticut's farmland. In addition, I've spent the last 26 years as a professional soil scientist and conservationist working on Connecticut farmland preservation projects and helping beginning farmers find land. Since 1978, the Connecticut Department of Agriculture's Farmland Preservation Program has done an exemplary job in protecting our state's farmland. In fact, according to a 2020 report released by American Farmland Trust, ranks the Connecticut Farmland Preservation Program as one of the top 10 programs in the US for quality and effectiveness. In 2008, the Connecticut General Assembly created the Community Farms Program to protect small farms that don't qualify for the other PDR program. And I was part of a group of partners who provided guidance in developing the criteria and procedures. Since Connecticut established the Farmland Preservation Program, farmland protection has evolved and features extensive oversight and evaluation. So the Community Farms Preservation Program applications already go through a very vigorous review step from the time a farmer submits their application to closing. They're subject to well-documented policies and procedures required by agencies, including agricultural appraisals that are completed by specialized certified appraisers who must attend special training on how to value farms. And because of this statute, these projects also utilize local funding, and so a project may be subject to a public hearing, town vote, or a land trust board meeting before local dollars are expended. The community farms programs are very well vetted by state, federal, and local experts who understand the comprehensive and complex process of evaluating the development rights on agricultural land. In fact, I was one of those professionals who worked for USDA as a farmland protection program manager in Connecticut from 1995 to 2011, and I'm very familiar with the oversight requirements. A project must also follow state and federal agency standards and practices and be in compliance with IRS regulations. In addition, the Connecticut Attorney General's Office has final approval. By adding the State Properties Review Board to the Community Farms Preservation Program, we'd be adding an unnecessary and duplicative extra step. Could slow it down by 2 to 6 months. And so I'm more in agreement with the comments by Commissioner Hurlbert and Deputy Commissioner Petra as far as my experience with the State Properties Review Board. So it would add an unnecessary step and make it harder to protect these farms and provide land access opportunities for beginning farmers. So on behalf of the Working Lands Alliance, I urge this committee to oppose HB 6577. Thank you very much for the opportunity, and I have also provided written testimony.
Thank you. Thank you for your testimony. Are there any questions from members of the committee? Seeing none, thank you again for your time this evening and for your testimony.
Thank you, and thank you for all your work.
Next, we will hear from Lucius Collette, who will be followed by Brian Mezek, who will be followed by Holly Hansen, who will be followed by Amy Ewing. And again, if I've mispronounced your name, please feel free to correct me. Lucius, welcome. The floor is yours.
Thank you. So thank you to co-chairs Flexer and Fox, the ranking members, and the rest of the esteemed GAE committee. So my name is Dr. Lucius Collette. I'm an assistant professor of sociology and criminal justice at Suffolk University and a lifelong Hartford resident. I'm speaking to you all to provide a little bit of context around the disenfranchisement of people on parole and to advocate for the passage and expansion of HB 6578. And so nationally, just about every state restores voting rights to those who have been convicted of crimes at some point via automatic procedures. In fact, there's a growing trend within just the last couple of years of states ensuring that criminalized people can exercise or recapture their right to vote after prison. And so Colorado recently passed a law ensuring that people on parole supervision can vote. Nevada and New Jersey have also revised their voter laws. So across the country, the consensus appears to be that democracy can only be democracy if everyone can participate. In Connecticut, however, we've managed to manufacture an unequal political system where those with the least social and economic power, people who have been released from prison, are unprotected by the fail-safes of democracy. And so the roughly 3,000 plus people on any given day who are under parole supervision but cannot vote are working, living, providing for their families in the community. They're paying taxes, but they have no say in how their tax money is being put to use. So in many ways, they're being economically exploited and politically erased. This system of disenfranchisement also artificially reduces the political power of our most disadvantaged communities. And so I looked into some of the data last year, and what I found was that roughly 65% of those currently on parole came from just 30 zip codes in Connecticut. So these zip codes are located primarily in towns like Bridgeport, New Haven, Waterbury, Hartford, towns with extensive levels of poverty and large numbers of Black and Latino folks. So if you live in one of these particularly disenfranchised places, the ability of your community to advocate for the resources, policies, and the politicians it needs is severely limited by an outdated policy that extends really a racist legacy of prohibiting Black and Latino folks from the vote. And so if we care also about public safety implications, research suggests that disenfranchisement may even increase crime and recidivism. It certainly does not reduce it. So this policy of excluding people on parole from voting both reduces the political power of poor Black and Latino communities, and it makes them less safe. Over a decade ago, Connecticut, we took a positive step on this issue by ensuring that people on probation can vote. It's time we take another long overdue step in our path towards a greater democracy. So I urge you to pass HB 6578, and indeed it's my hope that you pass an extended version that would extend automatic voter registration beyond the Department of Motor Vehicles to other state agencies as well. All right, thank you.
Thank you. Thank you for your testimony. Are there questions from members of the committee? Seeing none, Lucius, I just have two clarifying questions. You said you were a lifelong resident of where?
Hartford.
Hartford, okay, it cut out for me. And then did you provide written testimony as well?
I'll be submitting, I didn't get a chance to, but I'll be submitting that as well.
Can you make sure that those 30 communities that you talked about is in that written testimony?
Yep.
Thank you. Thank you very much. And again, thank you again for your time and your testimony this evening. Next is Brian Mezek, who will be followed by Holly Hansen, who will be followed by Amy Ewing, who will be followed by Sarah Russell. Brian, welcome. The floor is yours.
Thank you very much. Chairpersons Flexer and Fox and members of the GAE committee. Good evening. My name is Brian Mezek. I am a Connecticut State Marshal based in New Haven, and I'm here on behalf of the State Marshals and the State Marshals Association, which represents marshals across the state. I'm here to comment quickly on two bills, SB 1017 and HB 6576. You're probably wondering what a state marshal is doing here. We've put written testimony in on both of them, so I'll just quickly summarize our position. In regards to SB 1017, we would ask the committee remove sections 23 through 26 of the bill. We don't think that very rare and special elections for US Senate or Congress should be called for by email. State marshals serve these very rare writs of election issued by the governor going back, from our understanding, at least into the 1800s. So we would ask that the committee leave those historical and legal traditions in place. And then in regards to HB 6567, we've put in written testimony on that also. We're quite supportive of that bill, protecting the people in the Attorney General's office. Obviously, they deserve to return home after work each day without fear that their home address can be revealed to members of the public under a FOIA request. So I just want to take a moment to highlight, similarly, we state marshals, we face the same concerns. We're peace officers. We serve virtually every piece of civil legal process in the state of Connecticut. We enforce court judgments, housing court orders, family cases, contentious things like restraining orders, protective orders, custody orders, and we also make civil arrests under judges' orders and bring people into court. So those responsibilities, they put us front and center with the public. And I was really struck by what Attorney General Tong said earlier about a harrowing call that his office received. I think he called it blood curdling. I've had similar calls to my office saying people outright insinuating and threatening to show up at my house. And we have marshal members who have even more harrowing concerns that I can share with the committee. We understand the need for open and transparent government. I agree with what the ranking member said earlier, but AG Tong made a great statement. He said, where public officials live have nothing to do with public policy. And we agree with that in a time when bad actors have shown us that public officials are targets. I don't know if anyone saw 60 Minutes a couple weeks ago. Judge Salas and her family had a horrible situation. So we think that the legislature has a responsibility to protect where you can the people in the AG's office, and we face similar concerns. We're out there every day protecting people's due process rights and constitutional rights of notice, and this bill is only asking to protect someone's home address. So we urge members of the committee to support 6567, protect the people in the AG's office, and help us too, because your state marshals are out there every day keeping the court system moving. So we have a very public and vital role. So I'm happy to answer any questions you might have.
Thank you. Thank you for your testimony. Are there any questions from members of the committee? Brian, did you submit written testimony?
We did, yes.
Okay, great. And would you be the appropriate person for us to reach out to if we had further questions, particularly around what you said on 1017?
Yes.
Okay, great. Thank you. Thank you very much for your testimony.
Thank you. Appreciate it.
Next, I'm sorry. Representative Master Francesco, did you have a question? Oh, I apologize. Go ahead.
That's okay, Madam Chair. I couldn't get my click the raise hand button before you started talking, so I apologize. Thank you, Madam Chair. Thank you, Brian, so much for your testimony. Just a quick question. Have there been a lot of incidents where the public have gone to the marshals' homes?
We've received, many of our members have received threats to that effect. Our personnel file, while we have a very unique position in state government, we have some legacy from the sheriff system. We all became state marshals. So we're technically not state employees, but we have functions and powers of the state that are given to us. So our home address is in our personnel file in the State Marshal Commission, and anyone can FOIA that. So our name is really our work. Our name is on the front of all these papers. There's only about 200 of us in the state, and we serve every piece of legal process. So we have had people call marshals and say they're going to show up at their house. We had one member someone called him and said, "Marshal, get to my house now, or I'm coming to your house and you can serve me." And the state police and the SWAT team ultimately had to get involved. It was an eviction situation. So we're concerned that our home address is hanging out there. And I know that people say, it can be found on the internet. I've tried to do the work for myself to get my home address off the internet and have been pretty successful. But one thing I can't do is prevent the state from giving my home address out under a FOIA request. So I know the concerns that everyone wants to be in there, but every employee of the judicial branch has this protection. But, all the clerks taking the papers in, but the men and women out there driving around the state every day serving these papers and enforcing the orders don't have that same protection. So we're just asking for our home address to be shielded, nothing more than that.
No, I obviously share your concerns. We want to make sure every citizen in the state is protected. Things could get a little crazy these days. So it's a good step that you at least try to go online for now and try to get your address off of any sites that are out there. I know that can be a tedious and difficult process at many times, but it, certainly something to advocate for your colleagues in the meantime to do something like that. So Brian, thank you so much for your testimony. I appreciate you hanging in there all day long and coming before us and giving us your thoughts.
This is a very hardworking committee. You guys are going to be going until 10 or 11. Thank you. Thank you for your work for the state of
prediction, Brian. I reject that prediction.
Thank you, Brian. Thank you, Madam Chair.
And I really cared about what you said, Brian, but now I'm not so sure. And I'm just kidding. You're welcome, Representative, and thank you again, Brian, for your testimony.
Appreciate it.
Next, we will hear from Holly Hansen, who will be followed by Amy Ewing. Welcome, Holly. The floor is yours.
Thank you, Chairperson Flexer and Chairperson Fox and members of the committee. My name is Holly Hansen. I'm a resident of Manchester, Connecticut, and I'm currently obtaining my master's in social work from UConn with a concentration in community organizing and a focus area of study in urban issues. I'm here to testify in strong support for Bill 5318, an act restoring electoral privileges to convicted felons who are on parole. This bill is necessary for creating equality in our voices. Voting is a right, and over this past election, we've seen how powerful each vote is. So in order for Connecticut to uphold democratic values, it needs to remove any difficulties in the way for the people who reside in it to have a voice. Additionally, parole is supposed to be about an opportunity for the formerly incarcerated to reintegrate into society and make positive ties and connections. So how can we recognize them as whole people on the path to rehabilitation, trying to be positive, active members of the community, and expect them to live up to that ideal when we're simultaneously prohibiting them from taking on the basic form of civic engagement as a citizen? Furthermore, the long-rooted history of voting suppression being used as an act of racial injustice can no longer be ignored. The criminal justice system is disproportionately stacked to disenfranchise Black voters. And we've seen this as a historical trend of white people who have wanted to reduce Black people's voting power. So by disallowing formerly incarcerated people on parole to participate in the voting process in Connecticut, it solidifies racial inequalities in our democracy. So in conclusion, I strongly support HB 5318, and I thank you for your time today.
Thank you. Thank you for your testimony. Are there any questions or comments from members of the committee? Seeing none, thank you again for your time this evening and for your testimony. Next is Amy Ewing, who will be followed by Sarah Russell and Hannah Snow, who it's my understanding will go together, and they will be followed by Gary Monk. Amy, welcome. The floor is yours.
Thank you, Madam Chairperson. I have a statement. I've submitted written testimony, and I'm here to speak it as well in support of SB 759, which would make gender neutral language in the Constitution. And we're requesting an extension to remove religious language and preferences as well. I'm Amy Ewing of Stamford, Connecticut, and these are my own personal views, but it also reinforces the position that you heard earlier today from Luther Weeks of Secular Connecticut and Carrie Shaw of the Humanists and Freethinkers of Fairfield County, a group that I'm a member of as well. Words matter, actions matter more, but words still matter. So let me give you a small example. Early in my then marriage in the early 1980s, I applied to a department store for a credit card in my name since I wanted the credit history. And I was also at that time the only source of income which would secure our ability to pay the bills. I received the card, but it was issued in my husband's name. I was furious. As a couple then, we had received the credit, the action, but the words, his name, not mine, showed I was not valued and respected as a customer. That may have been the price of doing business at that point of time, but it's not appropriate for my state's constitution. gender neutral language would be appropriate. And it's a sort of language that sends a message that we welcome college students, job seekers, researchers, anybody who wants to come and contribute to the state of Connecticut, no matter what their gender is or their gender expression. So let's use gender neutral language as suggested in SB 759. I have another story which explains why I'm suggesting we would want to remove religious language and preferences as well. I was walking around my new Stamford neighborhood and a neighbor stopped me to chat. And her second question after "what is your name" was, "what church do you go to?" Her assumption was, of course, that I would, of course, attend a church, and the only question was which one. That left out other religious observances and the choice to be guided by secular humanist values instead. I guess that's fine for a neighbor to assume, but it's irrelevant and inappropriate for my state's constitution. In fact, we worked with several of our cities in January to declare a Religious Freedom Day, and Stamford was one that issued a proclamation, and it says, "We affirm our commitment to the freedom to practice a belief or religion, to change religions, or to have no religion." Very straightforward wording. And
Your 3 minutes is now over.
Okay, so I request that you not only remove the gender specific language, but also remove religious language and preferences while you're at it. Are there any questions?
Thank you. Thank you for your testimony. Are there any questions from members of the committee? I don't see any, but thank you again for your time and for your testimony this evening.
And thanks for your patience, everyone.
Thanks for your patience.
Bye-bye.
Bye. Now we will hear from Sarah Russell and Hannah Snow, who again, it's my understanding you two will go together. And then after that is Gary Monk, who will be followed by Rachel Popolsky, who will be followed by Charlotte Johnstone. So Sarah and Hannah, the floor is yours.
Good evening, members of the Government Administration and Elections Committee. My name is Hannah Snow, and I'm a resident of North Branford, Connecticut, and I'm here today as a law student intern on behalf of the Civil Justice Clinic at the Quinnipiac University School of Law. We support HB 6578, which would restore voting rights to individuals who are on parole. Although this bill is an important step forward, we urge the committee to amend the bill to eliminate felony disenfranchisement entirely in Connecticut by restoring voting rights for incarcerated citizens as well as people on parole. Connecticut's felony disenfranchisement law is the most restrictive in the Northeast. In Maine and Vermont, individuals convicted of felonies never lose their right to vote, even during their time in prison. In Massachusetts, New Hampshire, New Jersey, New York, Pennsylvania, and Rhode Island, people convicted of felonies have their right to vote restored automatically when released from incarceration. There is also a growing national movement to restore voting rights for people in prison. In 2019, bills eliminating felony disenfranchisement entirely were introduced in 9 states, including Connecticut. In 2020, Washington, D.C. enacted emergency legislation that restored voting rights to incarcerated people. Around the world, many countries do not restrict the voting rights of people in prison. In the past 2 years, California, Colorado, Nevada, and New Jersey have adopted legislation providing that when someone is released from prison from incarceration, their voting rights are automatically restored. In Maine and Vermont, incarcerated people register to vote in the towns where they live before they were incarcerated. Individuals request absentee ballots from their town clerks in those towns and receive their absentee ballots at the prison by mail. Connecticut uses these same absentee ballot systems for people incarcerated pretrial or serving sentences for misdemeanors. These individuals vote in the towns where they lived before incarceration. Treating a person with dignity and fostering connection and engagement with society helps promote rehabilitation. Access to the political process promotes a sense of fairness and legitimacy in institutions. Restoring the right to vote for prisoners and recognizes that those in prison are full citizens capable of engaging in society in productive ways. The reality is that most people in prison will be released at some point in time. Suffrage is the most fundamental right in a democracy. It grants the government legitimacy by instilling power in its citizens. Moral, educational, racial, gender, and language-based exclusions on voting have historically existed in our state, but have ultimately all been eliminated.
The call to reenfranchise people with felony convictions does not deny their past wrongs. It is instead an opportunity to allow those people to meaningfully and positively participate in the political process and in civic society. We urge the committee to amend the bill to restore the voting rights of all of Connecticut's citizens. If the committee declines to take this step, we ask that the bill be amended to make clear that the people in community residences under DOC custody, such as halfway houses, have the right to vote. HB 7160, which passed the House in 2019, contained language covering those in community residences. Making clear that voting rights are restored on the day of release from prison will help eliminate confusion. And we have Nicole Porter, who is the director of the advocacy at the Sentencing Project in Washington, D.C., an expert on felony disenfranchisement. She's been working with our clinic, and with the committee's permission, she'll speak in place of Professor Sarah Russell.
Thank you, Hannah. My name is, and I want to thank the committee. Thank you, Senator Flexer and Representative Fox and distinguished members of the committee. My name is Nicole Porter. I'm the Director of Advocacy of the Sentencing Project, a national organization based in Washington, D.C., and it's been an honor to work with Hannah.
Can I just pause you for just a moment? I'm so sorry to interrupt you, but your name is being identified where we're being broadcast live on the Connecticut network. And you're also misidentified on Zoom. So before you continue, I don't want your words to be attributed to someone else. So can you give us just a minute? What is your name again? I apologize.
Nicole Porter.
Nicole Porter. Okay.
Yes.
We will work to rename you. And generally it is late in the evening, but okay, great.
You got it.
Go right ahead, Nicole. We just want to make sure that we're doing this all as straightforward as possible.
Understood, and thank you for giving me an opportunity to offer comments and testimony to the committee this evening. So again, I just wanted to share that it's been an honor to work with Hannah and the other students at the clinic at I'm sorry if I mispronounced that university. It's a wonderful school, and I apologize for mispronouncing it. So anyways, as a national organization, the Sentencing Project is supportive of universal suffrage. And so I am here to testify in support of HB 6578, but want to urge an amendment that eliminates felony disenfranchisement outright, if possible. So I wanted to say that, many comments have been shared this evening that offer an overview of reforms that have dominated the expansion of democracy over the last 25 years, and specifically 25 states and Washington, D.C. expanded voting rights to citizens with felony convictions over that time period. Many folks have already shared comments that I was going to share, so I'll just reinforce one issue around public safety specifically. Disenfranchisement has no deterrent effect on crime, and many people who raise questions around expansion of rights to people with felony convictions have questions about the impact on public safety. And so I did want to center that as part of my comments this evening. While the effectiveness of most sanctions, criminal sanctions, is at least partially measured by how well they discourage future crimes from occurring, disenfranchisement has no such effect. Many people are not even aware that they lose the right to vote when they're sentenced, and largely due to the complexity of state disenfranchisement laws and the failure of states to notify potential voters of their ineligibility, the goal of disenfranchisement is inconsistent with public safety aims. If the goal of criminal sanctions—
I hesitate to interrupt you, but I do believe you've been notified that your time has expired. So if you wouldn't mind summarizing.
Oh, I'm sorry. I didn't realize that it had already expired. I just wanted to reinforce the point that there is inconsistency between disenfranchisement and public safety, and that disenfranchisement policies offer no public safety goal. So I'm going to be submitting written comments to the committee that offers to expand on that thought, but I just wanted to bring that into the discussion this evening.
Thank you. Thank you for your testimony. Are there any questions from members of the committee? Seeing no questions, thank you both again for your time and your testimony this evening.
Sure, thank you.
Next, we will hear from Gary Monk, followed by Rachel Popolsky, followed by Charlotte Johnstone, followed by Stacy Yarbrough. I do not believe that Gary or Rachel are here, so I believe Charlotte. Charlotte, welcome, Charlotte. The
Hi.
floor is yours.
All right, thank you. So to Senator Flexer, Representative Fox, Senator Haskell, Representative Thomas, Ranking Member Senator Sampson, and Representative Master Francesco, and esteemed members of the committee, thank you for the opportunity to submit testimony for Senate Bill 759. I'm testifying to express my support of Senate Bill 759, an act which would establish a task force with the intent of improving gender-neutral language in our state constitution. Gender-neutral language is more important than most would think. Just because male-gendered generic terms such as congressman or chairman are commonplace does not mean that their use as generic terms does not implicitly devalue and derogate women. Although many who use male-gendered generic language do not intend to cause harm, this kind of exclusionary language does affect women. Indeed, in one study, women who heard gender-exclusive language in a job interview were less engaged, motivated, and less likely to personally identify with the job than women who heard gender-inclusive or gender-neutral language. So I want to reiterate that I staunchly support Senate Bill 759 because I understand the importance of gender inclusivity in our language and policy. Furthermore, I want to acknowledge that non-binary people are another group whose gender identity has been excluded in our state legislation. That is why I propose that the esteemed committee should add a second section to Senate Bill 759 with language representing the intent of proposed House Bill number 5654, which calls for the updating of state forms, applications, and methods of identification to include a non-binary gender option. Some state agencies, such as the DMV and DCF, have already made the shift to include a third non-binary gender option on IDs and forms. Nevertheless, this option remains unavailable in other state agencies, and it is important that we instate policy that institutes this change at every level of registration and interaction with the Connecticut government that a citizen could have. This proposed section would not require agencies to reprint every existing form and application. Instead, moving forward, all forms and applications would have an added box for a non-binary gender option. I think this is a logical addition to a bill that is meant to increase gender equality in our state legislation and policy. If it is impossible for this section to be added to Senate Bill 759, then I request that proposed House Bill number 5654 is given a chance to be heard in a public hearing. Due to the ubiquitous nature of gender-exclusive language, it is hard for me to conceptualize or quantify the impact it has had on me and the choices that I have made in my life as a woman. I cannot imagine the added weight of not even being able to select my own gender on the state applications and forms that I fill out. We as a state must strive for true gender equality, which is why I both support Senate Bill 759 and propose that a second section should be added that would update all state forms, applications, and IDs with a non-binary gender option. Thank you so much.
Thank you. Thank you for your testimony. Are there any questions from members of the committee? Representative Thomas.
Thank you so much, Madam Chair. And thank you, Charlotte, for being here. I must say what you said just struck a note because I cringe a little inside every time our esteemed chair is addressed as chairman. And it really bothers me. So I can only imagine how it impacts how people perceive themselves and what they believe is possible for themselves. So I'm so happy to see a student here advocating for this important issue. I don't really have a question, but I wanted to thank you, especially for hanging in so late.
Thank you so much. It's been great to hear everyone else's testimonies as well. So
get involved, stay involved. Thank you, Madam Chair.
Thank you, Madam Vice Chair. All right, seeing no other questions or comments, thank you again for your time and your testimony this evening. Next is Stacy Yarborough, who will be followed by Taylor Tucker, who will be followed by James Jeter, who will be followed by John Marion. Stacy, welcome. The floor is yours. Stacy, I need you to unmute yourself.
Unmute. Sorry about that. Good evening, Senator Flexer, Representative Fox, Representative Master Francesco, and distinguished members of the committee. My name is Stacy Yarborough. I am the North Haven Town Clerk and Tax Collector as well. Thank you for affording me the opportunity to submit this testimony regarding HB 6212, an act concerning the confidentiality of the residential address of certain protected persons. with regard to online municipal records. The decision to testify regarding this bill has been a delicate process, and it's not only in consideration of the fact that I'm a member of the CTLA Legislative Committee, but also as an attorney who once practiced family law and experienced firsthand the issues that are raised here. CTCA agrees with the intent behind this bill, insofar as crime victims in Connecticut having the right to be protected from the accused throughout the criminal justice process. Yet, for all its good intentions, CTCA does not agree that HB 6212 is able to properly expand protections of these victims of violence as provided by the Address Confidentiality Program. Now, in this day and age of advanced technology, most, if not all, information sought to be protected by this bill is readily available by the internet, by way of the internet, perhaps a review of police department records, DMV records, or in other words, in many places beyond the records of the town clerk's online records. All it would take would really be for a very determined, unhappy, belligerent person to simply visit and peruse the land records of town hall. Moreover, redaction of online land records, as well as any other department here in the municipality, can create a false sense of security for the people who are intended to be protected. Now, while redaction may be intended as a way to shield individuals with recognized safety concerns from being accessible through documents contained in our online records, their needs should be addressed in a way that doesn't impede normal business activities and the free flow of commerce, creating a far-reaching economic impact well beyond town clerks, such as members of the public, attorneys, title searchers, municipal departments, as I've mentioned before, state agencies, and something not many people may think about, but adjacent landowners, as similar items such as that. Notwithstanding redaction, the same land records would be available in their original format in town halls by just coming down here and visiting. Redaction for specific parts of online records can prevent access to information and documentation necessary for providing constructive notice, protecting land rights, preventing fraud, as well as unintentionally prohibiting or delaying people from buying and selling real estate. Lastly, it would be prudent for me to mention the possibility of certain legal ramifications if redactions are not done properly or updated upon the expiration or change of the certification that is part of this particular bill in reference to the pre-existing program. As it relates to the town clerk's office,
your 3 minutes is now over.
Redaction would require basically a title search, which would equate to liability for the town. In conclusion, the CTCA looks forward to helping the committee find solutions, and we would really be interested in establishing a working group to make recommendations for the future of this bill, one that meets the needs of all. We don't want to see land records turned off as of October 1st, because I think that's what, and the CTA thinks that's what will happen with regard to this bill. I sincerely thank you for your time, and I'm ready for any questions if you have any.
Thank you. Thank you for your testimony. Are there any questions from members of the committee? I don't see any, but thank you again for your time and your testimony this evening and your patience.
Thank you. And I wanted to say that I'm impressed by how you guys have run this very long meeting. I'm really impressed. And you're very kind and thoughtful with regard to everyone who's speaking. And that's very nice to say.
Oh, well, that's very kind of you to say. Thank you very much. And
thank you.
Again, thanks for participating today. We appreciate it.
Thank you.
Next, I don't believe Taylor Tucker is here, so we will hear from James Jeter in just a moment. And James will be followed by John Marion, who will be followed by Peter Spain, who will be followed by Molly Norris. So James, welcome. The floor is yours.
Thank you to the co-chair, Senator Flexer, Representative Fox, and to the esteemed members of the GAE committee. I want to thank you for allowing me the opportunity to speak about why I support the immediately eliminating the unfair practices of felony disenfranchisement for persons on parole in the state of Connecticut concerning their democratic right to vote. My name is James Jeter. I am the co-director of the Full Citizens Coalition to Unlock the Vote. I am the program founder and director of the Civic Allyship Program at Dwight Hall at Yale. I'm a student at Trinity, and I am formerly incarcerated, currently disenfranchised. I've started off this argument, this testimony in years past with giving some background history into who I am and telling my story. It's painful to constantly retell the same story for the same issue year in and year out. So I'm gonna skip that and more so I want to just talk about the theory and ideology behind the American experience, right? The preamble of the U.S. Constitution states, "We the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessing for liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. We the people." The preamble of the Constitution sets the contextualization of the contract. We the people of the United States, as opposed to we a people of the United States, makes the Constitution a living, breathing contract that should at all times account for all the people. This is the theory behind the experiment of America, that we can create leadership, not rulership by class or race, but leadership from the collective voice of the people, for the people. We bombed ships because our rulership was taking our taxes and not giving us representation from amongst us. I highlight these points that set as the bedrock of our nation because we are presented today in this hearing to begin to move in the living aspect of our Constitution and move toward the we the people and away from the we a people. I believe the logic of our nation's forefather was encompassed in all of their models and symbolism in order to make sure that we don't forget that point. For example, e pluribus unum, of many one. Even if their limited concept of who was a person hadn't caught up to the theory and ideology, the theory ideology stand. The question is, are we in Connecticut in 2021, are we more aligned with their concept of a person in 1776 or the reality of our current structure and our current people? The denial of people on felony parole, denying me the right to vote, the right to engage and to have a say, the denial of my citizenship. So I believe I'm currently a non-citizen. I dwell in a space of civic death. This has done nothing to encourage or aid me in being productive, and productivity is the only way to ensure that I have my best foot forward and acclimate into society. Civic engagement is a strong way to help further lower rates of recidivism in our state. And I know, like, I have time myself, so I know our 3 minutes is up, and I don't want to push the ball any further. But I will say this: we've made some strides in Connecticut as a state around incarceration, and I believe we'll make even stronger ones this year. But I want you to understand this: I went to prison at 17. I was released at 36. I will not be eligible to vote until I'm 52 years old. I list 3 titles. I hate listing titles, but I've dedicated my last 4 years to the restoration of my community and the communities like mine in this state. It hasn't been 4 years of just moving on with my life. But yet I recognize the hurdles in my community, and I recognize how they start, and that the lack of being able to build base to power and elect and help engage and form our structure is robbing all of us. And I'm here today to submit that you guys take the necessary step in restoring these rights and to end these practices in our state. Thank you.
Thank you. Thank you for your testimony. Before I ask if there's any questions from other members of the committee, if you wouldn't mind me asking you, how long is your parole period?
I discharge regular parole in 2027, and then I have 5 years of special parole.
Okay.
So functionally 2032.
Thank you. Well, your testimony has been really valuable to me this evening, so I thank you personally for that. Are there any questions or other comments from members of the committee? Well, thank you again for your time and your patience this evening.
Thank you.
Next is John Marion, who will be followed by Peter Spain, to be followed by Molly Norris, to be followed by Tom Swan. John, welcome. The floor is yours.
Thank you. Good evening, Chair Flexer and Chair Fox, members of the committee. Thanks for having me tonight. My name is John Marion. I'm Executive Director, actually, of Common Cause Rhode Island. My friend and colleague, Sherry Quickmeyer, asked me to testify tonight about HB 6575. That's the work group on risk limiting audits. I'm just going to be very brief. I submitted written testimony. Somebody asked, like, what is a risk limiting audit? Risk limiting audits are the most efficient method to catch and correct tabulation errors in elections, and really to make sure that the correct winner is the certified winner of an election. Our state, Rhode Island, enacted only the second law in the nation in 2017 requiring risk limiting audits for statewide elections. And we did that because in 2016, there was a local election where the tabulator had been programmed incorrectly, and it yielded the incorrect result. The winner did not win. It was a sewer bond. It wasn't a contest for office. But somebody noticed the irregularity and it was reprogrammed and the ballots were rerun and the outcome shifted before certification. A risk limiting audit would maximize the chance to catch such errors. It wouldn't rely on the sharp eye of a local clerk. It would rely on the power of statistics and statistical sampling. So that's what risk limiting audits do. So our law passed in 2017. It had a phased in implementation. We did pilots in 2019. And then last year, we did full scale pre-certification risk limiting audits on the presidential primary and the general election successfully. I just want to make two last points. If Connecticut decides to adopt this work group, you're going to have a community of experts, including administrators here in Rhode Island, your neighboring state, who will help the state think through this new technique. We relied heavily on current and former election officials from around the country, as well as advocacy groups such as Common Cause and the Brennan Center to help implement our audits. The last point I'll make is you're going to hear a lot about, about catching and correcting errors, but there are residual benefits to risk limiting audits. Rhode Island had terrible ballot accounting practices prior to the passage of this law. Risk limiting audits force election administrators to know where every ballot is and what box it is placed and have a manifest for that. And that really has good effects, not just for risk limiting audits, but it's just good ballot accounting practices. And so they have great residual effects.
Your 3 minutes is now over.
In Rhode Island. So I said I'd be quick, but I wasn't. So please refer to my written testimony and feel free to, I put my email in there. Feel free to reach out to me with any questions. Thanks.
Thank you. Thank you for your testimony and your honesty at the end there. Yeah. That gave me a nice chuckle. Are there any questions or comments from members of the committee? Representative Fox.
Thank you, Mr. Marin, for being here today and for your advocacy and your patience with the committee process today. Two quick questions. One, when you implemented the program, what did you use as a template in terms of starting point? And the second question is, with the risk limiting audit you performed in 2021, what were the outcomes of that one, the presidential election?
Yeah, so that's a great question. So we didn't have a template because we were only the second state to really implement them statewide. Colorado was the first. So we had to build a template. So I mentioned we did pilots. We actually piloted all 3 methods of risk limiting audits that are known and did a time analysis of how long each step of each took, and then made decisions about what to do during full implementation based on that analysis. In my written testimony, there is a report, I think it's like 82 pages that we wrote, that is a guide to how to do these that Connecticut could rely on. I just want to mention Luther Weeks was actually part of the implementation group and was a valuable part of that time study. The audits, we did 2 in 2020. One was in the primary that had what's called a 10% risk limit, and the general had a 9% risk limit. And we met the risk limit after the first sample. That sounds like gibberish, but that just means it was a very successful audit. After pulling, I think in November, after auditing 18,000 ballots of almost 500,000 total, we were able to confirm with 9% confidence that that sample represented the full population of ballots and that that outcome was correct, if that makes sense.
It does. Thank you very much.
You're welcome.
Thank you, Representative. Are there any other questions from members of the committee? Seeing none, thank you again for your time this evening and your testimony and your patience.
Oh, absolutely. Thank you.
I don't believe that Peter Spain or Molly Norris are here. So if they are not, I am going to next call on Tom Swan, who will be followed by Olivia Rinks, who will be followed by Elise Krantz, who will be followed by Kathleen Adams. Welcome, Tom. The floor is yours.
Hi, thank you very much, Senator Flexer, Representative Fox, and other members of the Governmental Administration and Elections Committee. You all are putting in some long hours this session on Zoom, and we appreciate it. And we also appreciate the hard work of the committee staff and pulling these together. I'm the executive director of the Connecticut Citizen Action Group. We're a statewide membership-based organization whose one of our top priorities is ensuring a vibrant and healthy democracy. And I'm very happy to say that you all in this committee have put forward a number of proposals that will really strengthen democracy in Connecticut and take us into the 21st century and live up to the idea of one person, one vote. My coworker, Helen Humphreys, talked about a number of the bills earlier today that you're hearing. So I'm just going to focus on House Bill 6578, an act concerning participation in the electoral process. And I will point out, I haven't caught everybody's testimony, but I've caught almost everybody's one way or another today. I don't think we've heard one person testify against this or 1017 or prison gerrymandering, any of these bills. There have been some questions raised by members of the committee, but there's been nobody from the public who's testified against any of these bills. In 6578, we strongly support the restoration of the right to vote for people on parole. It was 20 years ago that we passed legislation to advance that right for people on probation. We're the only state in New England that does not allow people on parole to exercise their right to vote. And we support this version over the version of 5318 because this does not include a poll tax. It doesn't say that you have to pay your fines in order to do it. A poll tax would be a continuation of some of the discrimination that was behind this bill to begin with. In terms of automatic voter registration, we're very happy you're codifying the agreement between the Secretary of State and the Department of Motor Vehicles. That has worked exceedingly well. I've heard nobody complain about it. The challenge with that is that not everybody drives. Not everybody has a license. So when you don't expand, we're hoping that what you will do is you will expand this practice to other agencies, including Department of Social Services, various education entities. We could go through the list in a longer way. I included more in my writing. The failure to do that is discriminatory against people with disabilities, people in urban centers, younger people, older people, African Americans and Latino drive at a lower rate than middle-aged white
Your
folks.
3 minutes is now over.
Okay. We want to work with you to amend this and pass this and continue your great efforts to strengthen democracy here in the state of Connecticut.
Thank you. Thank you for your testimony. Are there any questions from members of the committee? Seeing none, thank you for your time this evening and for your testimony and for your patience. Thank you.
Thank you, Sarah Little Rose.
Next, we will hear from Elise Krantz, who will be followed by Kathleen Adams, who will be followed by Joan Andrews, who will be followed by Emily Melendez, who will be followed by Betsy Guerra. Elise, welcome. The floor is yours.
Thank you. Good evening. My name is Elise Krantz, and I'm a voter from Southington. I'm here today to ensure members of the committee know how important it is to me that House Bill 6578 and Senate Bill 1017 passes. I will focus my remaining time and support for two specific elements of the first bill. When I first learned about House Bill 6578, I honestly wasn't sure how I felt about convicted felons on parole being granted the right to vote again. But the more I wrestled with the issue, the clearer the answer became. These individuals are on parole because a parole board determined these individuals have reformed and no longer pose a threat to others. Being released from prison early means these individuals should be reintegrated into our community as contributing members of society. If these individuals do not have their right to vote reinstated, how can we expect them to embrace the notion that they should fully participate as good, ethical citizens of our community? Not only does preventing formerly incarcerated people from voting undermine good faith attempts at reintegration, it also decreases the voting power of the communities in which people on parole reside. While those on parole are concentrated in only a handful of Connecticut communities, they are communities with significant populations of Black and Brown people. It is a historical fact that felony disenfranchisement laws became widespread in the United States after the Civil War as a way for states to suppress Black political power. While many residents of Connecticut do not wish to acknowledge the presence of laws that support systemic racism in our state, I cannot stand by and allow this kind of inequality to persist. Disenfranchising people on parole sustains a racist system of inequality in our state, and that is why I urge you to pass this bill. Regarding the voter registration aspect of the bill, I would like to take it a step further. I strongly urge the committee to not only codify automatic voter registration at the DMV, but also expand it to other state agencies. In recent months, there has been a great deal of discussion about the honesty and integrity of our nation's elections. These concerns have only grown as the popularity and interest in no excuse absentee ballots and early voting have also increased. Like others across the state, I too want to ensure our voter rolls are accurate and reflect the names of all individuals who are eligible to vote. One of the easiest ways to assure voters and lawmakers that elections in Connecticut are organized and ethical is to enhance the security and integrity of our elections by eliminating outdated addresses and duplicative registrations through automatic voter registration. A democracy isn't a democracy if it's only convenient for some members of society to register to vote. Because I firmly believe in safely and ethically expanding voter access to include all eligible voters, I urge you to pass House Bill 6578 with the expansion
Your 3 minutes is now over.
With the expansion of automatic voter registration beyond the DMV to other state agencies. Thank you for your time.
Thank you. Thank you for your testimony. Are there questions or comments from members of the committee? Seeing none, thank you for your time and your patience this evening and your testimony. Next is Kathleen Adams, who I don't believe is here. So we will hear next from Joan Andrews, who will be followed by Emily Melendez. Joan, welcome. The floor is yours.
Welcome. Thank you. And I can't quite read my speech because it says good afternoon, so I'll have to extemporize a little bit. Thank you. Thank you for your patience. And from hearing from all of us, good evening, Chairperson Flexer and Fox, ranking members Sampson and Mastro Francesco, and distinguished committee members. I am Joan Andrews. I am an Assistant Attorney General. I am Vice President of our relatively new union, the Association of Connecticut Assistant Attorneys General. And we are here in support of House Bill 6576. You sort of began this hearing, I think, with hearing from our leader, Attorney General Tong. I would like to thank him for his support. His employees do appreciate that, his regard for our safety. I wish I could say this was theoretical, but it's not. We have had members who have been directly threatened, and there is a concern about releasing home addresses. And I understand in this climate and environment with the internet, some think it may be an illusory protection, but I do think Attorney General Tong said it well. It doesn't have to be the state contributing to that or facilitating that. There's many things about our public service that are out there, it's understood are salaries are available, perhaps our emails, all different kinds of things. And that doesn't change. But where we live doesn't have anything to do with the public work that we do as really the law firm for the state. I won't keep you too long. I just think one thing that occurred to me as I did listen today, there are our client agencies, the ones that are witnesses in court, who might be an employee of the Department of Corrections or Social Services or Public Safety, any one of the agencies out there. When they testify in court and they're sworn in, raise their right hand, the address they provide is generally not their residence address. They provide generally their work address because they're there in that capacity. And I think this is simply an acknowledgement of that, it seems to me. So that being said, I'd be happy to answer any questions.
Thank you. Thank you for your testimony. Are there any questions or comments from members of the committee? Well, again, thank you for your time and your patience this evening. And I think it is an interesting coincidence that we started the day talking about this important issue and we're ending it talking. So thanks for your patience and waiting all day today. So thank you very much.
Thank you.
And I think the last person we're going to hear from is your colleague, Emily Melendez. So Emily, welcome. The floor is yours.
Good evening, and I'm just like Joan. I had my notes, good afternoon, but thank you all for, staying through for all of this. Senator Flexer, Representative Fox, and all the members of the committee. And I just want to add just a few points to what both A.G. Tong and my colleague Joan Andrews just added. Most of what we do is civil work in court or in administrative agencies, but it is clear to us from our own experiences that civil actions are not always civil. And what this bill would do would take away a burden that is upon all public employees who are not on this exemption list. And that burden is that if the way it's currently set up, and it's been interpreted by the Connecticut Supreme Court, our addresses are public records, unless we can show that we fit in within an exemption under the Freedom of Information Act. But that's a burden, and you have to do it each time that someone would request those records. So what this bill would do would be to eliminate that burden. And I think that that is really important because the folks who are already on this exemption list do many of the same things that we do, including in court, out of court, and in administrative agencies. And this bill covers not just the assistant attorney generals. It covers the entire office. And I failed to also note that I was the past president of the Association of Connecticut Assistant Attorneys General, which is affiliated with AFT Connecticut, but that is one of the reasons I'm here, but it's for the entire office. Some of our staff, they're frontline getting phone calls from very angry people demanding to know what their name is, and then the request could go in. And I would just close with my own personal experience many years ago prosecuting on behalf of the Commission on Human Rights and Opportunities, who, by the way, are exempt, their addresses are exempt from disclosure, a housing discrimination case. Strangely enough, the landlord was a gang leader. And when he showed up for the hearing, administrative hearing at the CHRO, he brought 15 gang members with him. Now, we had a state police officer, actually there were two present, and so things did not get out of hand. But it always concerned me because 2 years after that case was done, he showed up at our office demanding to see me. And I wondered whether he would go for my address. That did not happen, but this would take those concerns off of the table without having to make a presentation before the FOI as to why my address should not, or any of our addresses should not be disclosed. So with that, that's my testimony.
Thank you. Thank you for your testimony. Are there any questions from members of the committee? Seeing none, well, thank you very much again for your testimony this evening and for your patience for the entirety of this hearing. Thank you very much.
Thank you.
And with that, I believe there are no other members of the public who are signed up to testify. So thank you to all of the members for sticking with us, those of you that are still here, which is quite a few. And we will be together sometime soon, I am very sure. So thank you all very much. This ends our hearing. Bye-bye.
Good night, everybody.
Thanks, Madam Chair.
Good evening. Thank you.
Good night. Good night.